Well, under company secretary mentioning yesterday, Mr. Chatterjee mentioned one matter when the application is urgency. Your Lordship was pleased to direct to mention this matter when your Lordship is sitting in the special bench. Mr. Anand Chatterjee mentioned.
Yes, yes. What is the urgency?
My lord, I'm still here. I'm still here,
Yes,
my lord.
Yes. What is the urgency?
Mr. Chatterjee
My
is
lord,
the
but Mr. Rai, kindly, my lord, allow
Any of
Mr.
you,
Rai, my
please.
lord,
Yes.
being there.
that an injunction arising out of this appeal has been admitted by your Lordship whether the revision is maintainable. That is the only basic point.
The
For
appeal itself is not
Not
maintainable,
maintainable.
my lord, and my business has been stopped completely. And it's a
It's
liquor
appearing as
license.
and there is a caveat, non-service of caveat also.
appearing as an application. You have given
Application.
A notice to the other side.
Application. Yes, I have about notice.
Mr. Debraj is appearing.
On Monday, this will appear at the application ki note din Monday. Monday ki. Read application. Monday it will appear as a specially fixed matter immediately after the to be mentioned.
So grateful, my lord.
Grateful.
Extremely grateful.
Thank you.
Extremely grateful.
May I have your lordship's leave? Item number 178 of your lordship's daily list, when it's an application arising out of a writ appeal.
Yeah.
But my shop is going to be demolished. A completely unreasoned order has been.
Very well. Monday, second matter after that.
Grateful.
For inclusion.
I'm mentioning upon.
Your Lordship, on 8th December, Your Lordship had passed an order. Your Lordships had passed an order directing that the component authority be brought from the lower court to rectify the LCR, lower court records, Your Lordship, and requisites fees may be paid within 1 week. Within 1 week of the order, Your Lordship. We were pursuing it from
What do you want now?
Lordship. The requisite fees has been paid after a day, Your Lordship.
To be mentioned Monday.
Your Lordship, may it be kept today to 2 p.m. It's a short direction, Your Lordship.
Appearing in the list.
No, Your Lordship.
No, Monday.
Lordship. Monday.
The proper mentioning slip. If the heading to be mentioned, yes.
May I be permitted to mention one matter for inclusion in list under the heading application?
After vacation. Yes.
We are permitted for mentioning a matter, Lordship. The urgency is that the mother cannot visit her child for last 6 months. The father is in America and the mother is in Behala, Kolkata, and he is not showing the face of the child to the mother, and the mother has.
Is it appearing in the list?
Yes, Lordship, but
Which item?
Lordship, it's in mentioning. So I have to
I
check.
don't know the item. Please don't mention. Call on the list. Yes.
My lord, I'm praying for correction.
What correction, please?
My lord, paragraph number 5. The original application was filed by the respondent number 5.
It has become writ petitioner.
My lord,
In
5.
In paragraph.
Paragraph number 5, second line.
In paragraph number 5 of the order dated December 15, 2025, comma, instead of respondent number 5, comma, it was transcribed as writ petitioner in the second and third line of the said paragraph. First up, let the said
My lord,
paragraph be
paragraph
deemed
number
to stand corrected to the effect that the expression double inverted writ petitioner shall be read as respondent number 5. Yes.
My lord, paragraph number 6, third last line also.
First up, similar correction shall be effected in the third last line of paragraph number 6 of the said order. First up, next para. This order be deemed to be a part of the order dated December 15, 2025. Next. In view of the relative of one of us within bracket Shobhusachi Bhattacharya J bracket closed appearing for one of the parties, let the matter stand released from our list on personal ground with liberty to the parties to seek assignment before a different assignment to a division bench before the Honorable the Acting Chief Justice. Fine.
My lord, I'm back to appear for the appellant, my lord. And
I appear for all the respondents. Right.
my lord, the appellant, my lord, is the owner of the JW Marriott Hotel, my lord. The JW Marriott Hotel, my lord, is located on the bypass on JBS Halden Avenue. That is under Pragati Maidan, my lord, police station, which is under the jurisdiction of the court at Alipur. Now, my lord, the respondent and the appellant, my lord, entered into an agreement whereby the respondent agreed to provide certain services at the nightclub operated on the premises of the hotel.
Yes.
The agreement also contains an exclusive jurisdiction clause which says that the jurisdiction will be that of the courts which have jurisdiction over the property, that is the hotel. But irrespective of that, my lord, a suit is filed, my lord, before the city civil court. Now, kindly, my lord, have page 31, which is the where from, my lord, the memo of the parties will be evident, my lord. Kindly have page 31, my lord.
Yes.
Page 31, my lord, will find the plaintiff is Fire Events, principal business as at Old Courthouse Street, 5th floor, room number such and such, Kolkata 1. And the second person also, my lord, will see that Beleghata Road, Beleghata Police Station, Beleghata. And kindly see the defendant's address. Fabworth Promoters Private Limited, business at JW Marriott Hotel, 4A JBS Halden Avenue, Tangra, Police Station, Pragati Maidan. And my lord, there is also a, now kindly have the jurisdiction paragraph, my lord. Kindly have page 34, para 16.
Yes.
That the cause of action on various dates, including the date when the defendants refused to pay on 30th October 2025 after receiving the mail at Old Courthouse Street, 5th floor, 508 Kolkata 7001. Within the jurisdiction of Hare Street Police Station, and office of plaintiff also resides within the Hare Street Police Station. So, my lord, their contention is, my lord, for if one can make out what is written in that paragraph, is to say that they have suffered the consequence of the breaches committed by the defendants at their office in Hare Street Police Station, which is within the jurisdiction of the Learned City Civil Court. Now, my lord will see that is one part, my lord, where my lord, I won't be presumptuous to cite judgment, but I'm carrying, my lord. My lord will recall, my lord, that in the early 90s, my lord, in the context of 226, this issue had arisen, my lord, because this honorable court was taking a permissive view. Then, my lord, Supreme Court, my lord, a series of judgments has held, my lord, that the petitioner or the plaintiff's residence is not relevant at all under section 20 of the CPC, my lord. Either has to be the defendant or where the cause of action has arisen, and the plaintiff suffering an order is not cause of action, my lord. Now, my lord, in addition to this, kindly see the first, my lord, may see the prayers. The prayer A, my lord, is a decree for declaration that defendant is responsible and duty bound to give access to run the business in compliance of the agreement dated 20th February 2025 executed between the plaintiff number 1 and defendant. Now, this is couched in a way, actually give access is, and my lord, this becomes clear when the injunction application is seen. But kindly see the schedule, my lord. The schedule again refers to JBS Halden Avenue, Tangra Police Station, Pragati Maidan. Now, my lord, may kindly have the injunction application for a moment, and what has been granted, what was sought, and then what was granted by the Learned Trial Court. Kindly have, my lord, page 41, 38 it begins. Kindly have, my lord, page 41, the reliefs that have been sought in the injunction application. To grant temporary ad interim injunction till disposal of the suit, restraining the opposite party from transferring, alienating, mortgaging, and to create any third party interest in respect of scheduled suit property mentioned in the schedule below in any manner whatsoever. So, my lord, now, my lord, even keeping aside section 20, this would be barred even under section 16, my lord. Effectively, and thirdly, my lord, the injunction application is beyond the scope of the relief that is sought in the suit. They are effectively seeking a temporary, no mandatory injunction in respect of the property could have been sought or has been sought. But in the interim order, my lord, they have interim injunction has been sought in respect of the property. And kindly have page 40, paragraph 13. What is this access that they're talking about? They say defendant is bound to give access to the petitioner to run the business as per specifications stated in the agreement. So, my lord, now this injunction application is moved, my lord, before the Learned City Civil Court, my lord. The Learned Trial Judge, my lord, passes an order, my lord, on 11 kindly see 11 this is 11 November 2025. This is at, my lord, page 85 of the, or if my lord wants to see it from the memo of appeal, page 85 of the stay application, my lord will see. This is, my lord, 11 September. It should be 11 November, my lord. It's mistyped as 11 September. Record is taken up on the basis of put up petition filed. My lord, sorry, my lord, page 85. Yes. Put up petition filed on behalf of the plaintiff. A separate application under Order 39, Rule 1 and 2, read with 151 has been filed.
You have not filed a certified copy?
My lord, we have got the certificate. We had taken leave, my lord, but we are carrying the certified copy, my lord. Please give the certified copy.
Yes.
Learned counsel for the plaintiff submitted that plaintiff number 1 is partnership firm represented by one of its partners, and plaintiff number 2 is the other partner of the said partnership firm. The said partnership firm is into the business of providing event management services in hotels, restaurants, etc. On 20th February 2025, an agreement was executed in between the plaintiff and defendant number 1, which is running a hotel, namely JW Marriott, Kolkata, for providing services which have been mentioned in detail in Schedule A of the said agreement, such as sound setup, beautiful and ample lighting arrangements, stage setup, and audio-visual display, providing artists required for the events, DJ, live band, other artists in nightclub, namely Gold at JW Marriott Hotel, which is situated in basement of said hotel, and pursuant to said agreement, plaintiffs had started providing their part of the assigned services. The said agreement was valid from 1st March 2025 to 31st May 2026. After the execution of the said agreement, the plaintiff had invested huge amount of 30 lakhs towards interior, etc. of the said nightclub. However, on 30th October 2025, all of a sudden, without assigning any reason, defendants had informed the plaintiff that their contract stands terminated from 3rd November 2025, and the plaintiffs had been further asked that all pending deliverables and invoices be finalized by 6th November 2025. It has further been submitted that plaintiffs had invested a huge amount of money towards infrastructure for running the said nightclub in the hope that their contract would be effective till 31st May 2026. However, the sudden termination of contract by the defendants would cause severe financial loss to the plaintiff. Accordingly, prayer has been made to restrain the defendants by way of ad interim injunction from transferring, alienating, mortgaging, and or create any third-party interest in respect of the said club, Gold, situated at basement 1 of Hotel JW Marriott, Kolkata, as termination notice given by the defendant is without any justifiable basis and for harassing the plaintiff. On going through the plaint, injunction application, and annexures attached thereto, and on considering the arguments advanced by the learned counsel for the plaintiffs, it appears that agreement dated 20th February 2025 executed in between the parties, plaintiff had been assigned to provide certain services which have been detailed in the Schedule A of the said agreement. In terms of the said agreement, it was also specified that hotel manager may terminate the said agreement at any time during term thereof on giving 30 days prior written notice without giving any cause and without any termination fee or any other cost, charge, or expense of any kind or nature. And in the event either party breaches a provision, the non-defaulting party may terminate the said agreement by giving 10 days prior written notice. Termination email dated 30th October 25 has been served through email, from which it appears that said termination is possibly on account of the plaintiffs having not met the standards and expectations outlined in the agreement, and despite previous discussions and opportunities for improvement, no sufficient progress has been made. Therefore, defendants are required to give 10 days prior notice before termination of the agreement, which apparently does not appear to have been given, as termination notice was sent to email on 30th October. Agreement was terminated with effect from 3rd November. Therefore, in my opinion, plaintiff have been able to make out prima facie, and balance of convenience also appears to be in their favor. And it also appears that if interim relief is not granted, then irreparable injury would be caused to plaintiffs, and moreover, plaintiff have been able to make out a case for granting ad interim relief on ex parte basis, considering the urgency of the matter. Accordingly, the parties are directed to maintain status quo and not to create any third party interest in respect of nightclub, namely Gold, situated in basement 1, Hotel JW Marriott, Kolkata, till the next date. So, my lord, I am not even on the merits, my lord, that this being a service agreement, in any case, my lord, this is not specifically enforceable. Their claim has to be in the realm of damages. But irrespective of that, my lord, today we are on jurisdiction, my lord. Quite clearly, my lord, this property is not within the jurisdiction of the Learned City Civil Court, my lord. Despite that, and despite the schedule itself disclosing this fact, and the basis of jurisdiction being where the plaintiff has suffered, my lord, the Learned Court has granted this injunction. After this, my lord, we have filed Order 7, Rule 10, my lord, which has again, the matter has been adjourned to February, my lord. Now, kindly, my lord, one judgment, my lord, I wanted to show, my lord, on this aspect. Kindly have 1994 4 SCC 711. That, my lord, because on Order 7, Rule 10 or been an appeal, my lord, I have to satisfy ex facie, my lord. It cannot be something which is a tribal issue at all, or even for the court to apply its mind to it, the learned trial court to apply its mind to it. Now, my lord, may kindly have paragraphs 8, 11, and 12. Now, this was in the context of 226, but section 20 is also discussed, and it is similar, my lord, because eventually the two bases of jurisdiction is the same even under 226. From the facts pleaded in the writ petition, it is clear that Nico invoked the jurisdiction of the Calcutta High Court on the plea that a part of cause of action had arisen within its territorial jurisdiction. According to Nico, it became aware of the contract proposed to be given by ONGC on reading advertisement which appeared in Times of India at Calcutta. In response thereto, it submitted its bid or tender from its Calcutta office and revised the rate subsequently. When it learned that it was considered ineligible, it sent representations including fax messages to EIL, ONGC, etc. at New Delhi demanding justice. As stated earlier, the steering committee finally rejected the offer of NICO and awarded the contract to SIMCO at New Delhi. Therefore, broadly speaking, NICO claims that part of cause of action arose within the jurisdiction of the Calcutta High Court because it became aware of the advertisement, it submitted its bid or tender and made representations demanding justice from Calcutta on learning about the rejection of the offer. The advertisement itself mentioned that tender should be submitted to EIL in New Delhi, that those who would be scrutinized in New Delhi, final decision whether or not to award the contract to the tenderer would be taken in New Delhi. Of course, the execution of the contract work was to carry out in Gujarat. Therefore, merely because it read the advertisement at Calcutta and submitted offer from Calcutta and made representations from Calcutta would not, in our opinion, constitute facts forming integral part of cause of action. So also mere fact that it sent fax messages from Calcutta and received reply thereto at Calcutta would not constitute integral part of cause of action. Now kindly have, my lord, para 11 for a moment. Para 11, my lord, will find at page 721. Strong reliance was placed on the decision of this court in state of Rajasthan case by learned counsel for ONGC. The facts of that case reveal that respondent company, having its registered office at Calcutta, owned a large chunk of land on the outskirts of Jaipur. The special officer, Town Planning Department, Jaipur, at the instance of Improvement Trust, Jaipur, issued a notice intimating that the state government proposed to acquire a large part of the said parcel of land for a public purpose, namely implementation of development scheme. The said notice was duly served on the respondents at their Calcutta office. The respondents thereafter participated in inquiry, contended that they proposed to use the land for constructing a 3-star hotel. Special officer, however, felt that alleged needs of the respondents was just a pretense and land was not needed bona fide with them. Consequently, requisite final notification or acquisition was issued. Thereafter, an attempt was made to seek exemption. These are on the facts. Having failed to get the land released from acquisition, respondents filed writ petition. Then, my lord, will see the question which arose for consideration in the backdrop of the said facts was whether the High Court of Calcutta had jurisdiction to entertain the petition and grant ex parte ad interim relief. This court observed that upon the said facts, cause of action neither wholly nor in part arose within the territorial limits of the Calcutta High Court, and therefore the learned judge had no jurisdiction to use Rule Nisi or to grant the ad interim prohibitory order. After extracting the definition of expression cause of action from Mullah's Code of Civil Procedure, the court observed as under: the mere service of notice under section 52(2) of the Act on respondents at registered office at Brabon Road within the territorial jurisdiction limits of the state of West Bengal would not give rise to cause of action within that territory unless the service was integral part. The entire cause of action, now this is again on the facts, now lastly, my lord, I'm sorry for my lord taking your lordship's time, under para 12, pointing out that after issuance of notification by the state government under section 52(1) of the Act, the said notified land became vested in state government, free from all encumbrances, and hence it was not necessary for the respondents to plead the service of notice under section 52(2) for the grant of an appropriate direction order under article 226. This court therefore held that no part of the cause of action arose within the jurisdiction of Calcutta High Court. This court deeply regretted and depreciated practice prevalent in High Court of exercising jurisdiction, passing interlocutory orders in matters where it lacked territorial jurisdiction. Notwithstanding the strong observations made by this court in the aforesaid earlier decisions, we are distressed that even in cases where, now it is indeed a great pity that, my lord, this is all on the facts, I don't want to read this. Now, my lord will see after this the last para of that sub para. In that case, the contract in question was executed at Aligarh. Construction work was carried out at Aligarh. Contracts provided that in the event of dispute of Aligarh court alone, the arbitrator was appointed and was to function at Aligarh. Merely because the respondent was a Calcutta-based firm, it instituted proceedings in Calcutta High Court, and the High Court exercised jurisdiction where it had none whatsoever. Now, my lord, therefore, mere fact that your office, the plaintiff's office, is located is not to be considered as a part of cause of action for the purposes of section 20C. Additionally, my lord, I have already shown, my lord, the reliefs, my lord, which will show that this is in effect a suit for land, my lord. Lastly, my lord, I just wanted to show the jurisdiction, the exclusive jurisdiction clause, which my lord will find at page 17, my lord. Kindly have that for a moment. My case is even dehorsed this, but be that as it may, my lord, kindly have page 17 for a moment, my lord. Clause 6. The agreement, my lord, of the stay petition, my lord.
Yes.
The agreement shall be construed under and governed by the laws of the country in which the hotel is located. Any dispute, controversy, or claim arising out or relating to this agreement or breach, termination, or invalidity shall be settled by local courts of the country in which the hotel is located. Each party irrevocably A. Submits to the exclusive jurisdiction of the local courts of the country and all courts competent to determine appeal from whose courts with respect to any proceedings that may be brought at any time relating to, and B. Waives any objection it may now or in the future have to the venue of the proceedings and any claim it may now or in the future have that any proceedings have been brought in any inconvenient forum. Notwithstanding anything, either party may seek injunctive or equitable relief in any court of competent jurisdiction. Now, my lord, my submission is, my lord, even if we keep this clause aside, the learned city civil court does not have jurisdiction in the matter because the property is admittedly located outside jurisdiction. But my lord, this clause also assists me, and because, my lord, quite clearly, my lord, this the court of the learned civil judge will not be covered under the last line because it is not a court of competent jurisdiction in terms of the CPC either. So for granting this relief. And my lord, lastly, my lord, the relief which has been sought, my lord, in the injunction application is beyond the scope of the suit. Because my lord will see, my lord, the relief is there is no mandatory injunction sought. They seek a declaration that this effectively it's specific performance of the agreement. But in the injunction, my lord, they have sought injunction in respect of the property. And today, my lord, I'm not. There's a judgment to say that the injunction should not be beyond the scope of the suit. Would your lordship like to see it, or I think it's a presumption on our part to show so many judgments. So, my lord, my humble submission is, my lord, that this is a squarely, my lord, a case, and where, my lord, my issue of territorial jurisdiction has now been raised. Despite that, my lord, the learned court has, my lord, if my lord sees the last order, kindly show the last order. Certified copy, my lord, has been given. Kindly see, my lord, that's the last order, my lord. We are carrying an appeal against that also if necessary, but kindly have, my lord, the order dated 12th December, because, my lord, it could be put to me that I should first approach the trial court. Kindly see 12 December 2025 order. Haziras have been filed on behalf of the plaintiff. Defendant number 1 has appeared by filing Wakalatnama, Hazira and petition under Order 7, Rule 11, read with 5151 CPC. Copy of the said has been served on the learned counsel for the plaintiff, who has verbally prayed for adjournment for filing written objection. An application under Section 144, read with Section 151 of CPC, has also been filed, and its copy has been served on learned counsel of the defendant number 1, who has verbally prayed for time. Learned counsel for defendant number 1 has pointed out that in order number 2, there is a mistake in the date. The same needs to be corrected. From perusal of record, it appears that injunction application under Order 39, Rule 1 and 2, read with Section 151, has been filed on 11 November 2025, along with put-up petition, and the order was passed and uploaded on such and such. Now, all this is not relevant. Now, kindly see, learned counsel for defendant number 1 has pointed out that the Hotel JW Marriott, in which the plaintiff were operating nightclub, namely Gold, is situated within jurisdiction of Police Station Pragati Maidan, which would come within jurisdiction of District South 24 Parganas. Therefore, this suit ought to have been filed at Alipur South 24 Parganas. Learned counsel for the plaintiff has submitted that they would file objections to petition filed by defendant number 1. Accordingly, it appears that question of territorial jurisdiction has to be gone into, but it's also true that plaintiffs have to be heard after giving sufficient opportunity of filing written objection and for being prepared, for which plaintiff deserves some time, which has been granted. On the next date, this court would take up territorial jurisdiction also, for which parties must come prepared, and plaintiff is at liberty to file appropriate petition for return of plaint to proper court. For hearing injunction application and petition filed to the written objection, if any, in the meantime, on prayer, ad interim injunction is extended. Now, my lord, this honorable court, my lord, division bench, my lord, has held, my lord, that where an objection as to territorial jurisdiction is raised, my lord, you have to decide that first. You cannot extend the injunction. 2009 judgment.
But the extension is not under challenge before us now, right?
The extension, my lord, is not.
Because the jurisdiction point was raised at the time of extension.
No, our first off, we were not first date was ex parte.
At the outset, it was ex parte, so there was no question of your raising jurisdiction.
Well, it's ex facie, my lord. It is evident, my lord, from the schedule.
Yes.
Then I'll not show that.
No, because jurisdiction point was not taken when this order was passed. Could not have been taken.
Yes, yes. In fact, we have taken other grounds also in 711 other than territorial jurisdiction.
Yes.
So that is a separate issue, my lord. Yes, madam.
Let us hear the other.
My lord.
Yes.
My lord,
first of all, my lord, this is not a suit for land. And the cause of action that has arisen because, my lord, the agreement has been terminated and the termination notice was received by me within the jurisdiction of the Civil Court at Calcutta. So if Lordship sees, my lord, the termination email, my Lordship will take, my lord, page 65. They admit, in fact, page 65 is the email that was sent to us. But this, my lord, we received in our office, which my address is Kolkata 1. So in terms of section 20 of the Code of Civil Procedure, section 20C, cause of action wholly or in part rises. So my termination notice gives me the cause of action to file the suit. Because if my contract is terminated and if my goods are withheld by the appellant, then, my lord, I have a cause of action to claim damages. If Lordship sees, my lord, the plain, the reliefs, my lord, page 34, prayer B, page 34.
Yes.
It's not been couched in a proper language, but decree for declaration that the defendant is liable to pay penalty and compensation for late/delayed payment and for restraining the plaintiff to run the business as per the agreement. So my complaint is that there has been breach. And
You have not asked for specific performance.
no, I have not asked for specific
You have
performance.
asked for damages.
Yes.
So you really should lie in damages. Why injunction?
Because, my lord, if Lordship sees the termination notice, page 65, because what they have done is,
We have to go by your relief sought in a suit.
yes.
So relief sought is damages. The specific performance has not been claimed. Whatever
Apart
way
from
that
that,
has been couched.
Yes.
So if your main relief is damages, then why should you get an injunction at all?
If Lordship sees the first prayer,
If you get the damages, you get the damages, but no relief lies in injunction.
but Lordship sees the first prayer at page 34 is
Then-
that I am entitled
If
to
you
carry.
say that's a specific performance prayer, then you have to overcome that difficulty that this is an agreement which can be performed by them personally.
Yes, but if Lordship sees, it's not akin to exclusively for specific performance, but it is couched in a manner that I should be given the right to run the club. It's declaration that the defendant is responsible and duty bound to give me access to run the business. Because, what has happened, contract was of 28th of February 2025. This is a services agreement. Now, I was required to provide services in terms of the schedule to this agreement that I'll provide lighting, I'll manage events.
Every part of the cause of action arises there. Your receipt of the termination email is it is non-issue. The termination was effected by them at their office by sending the email.
Yes.
Termination occurred then and there. You received it. Your knowledge of the termination was post facto. Your receipt of the termination was not an essential condition of this is not a contract. Contract, yes. Promise, offer made, acceptance in your place, we could understood if this was the agreement. You are absolutely right on that. But termination is not a contract that your acceptance will be a relevant factor. Are we clear on that?
Yes, yes.
So termination occurs then and there, whenever they send the email. Termination occurs there, not when you receive it. Acceptance in termination is not a concept known to law. Acceptance of a contract concludes the contract. You may say acceptance place has jurisdiction. For termination, your receipt of that is a consequence, post facto consequence of the termination, which is the cause of action. So you don't have a case, will set aside the order or passes an order, admit and pass an order stay, whichever you agree.
No. If Lordship sees, I do understand it's an ex parte ad interim order.
Whenever the matter came to you, you understood. Not the ex parte part, the other part. So, but you have to argue, definitely you are making good arguments. That is the only argument which can be made, which you are saying.
Yes, because
that is your plaint also.
Yes, plaint case proceeds on the basis that I am, because I'll just indicate one, so far what you has fallen from your lordship, that issuance of the termination will only give the cause of action. So the cause of action arose from their hotel at JBS Halden Avenue.
We have also held in some judgment. I have held in some judgments sitting singly that even if the effect of the termination pertains to your the place where you received the email, then also we can understand. But this business which we are talking about is carried on at Halden Avenue, JBS Halden. Yes. Not in your. So therefore, it's not that you are affected also in your office.
No, but if the termination notice, a receipt of termination notice affects my right. So, Malad, my affectation
Termination affects your right.
yes, termination
Receipt
affects
has
my
nothing to do with it. Receipt of the notice is
no, Malad,
post
if
facto.
and if I have a if the termination notice was sent but had I not received it,
Then also the termination had occurred.
then Malad, the termination wouldn't have been communicated.
There is
the
no question of
termination-
acceptance of a termination. In a termination, it's not a contract, as you said.
Yes, but my
Even if you did not know of the termination, termination had occurred. When you know, you would have filed a suit.
but Lordship, can we consider that affectation of right was within the jurisdiction of the city civil
Affectation
court?
of the right was JBS held in. Your business was being carried on there, is being carried on there.
Yes, it
So
is.
your affectation is also there. That's what we are saying. So no, by no stretch of imagination can we say that city civil court has.
But they have, Malad, if Lordship sees the order of 12th of December 2025,
Yes, we've seen that.
but they have already filed an application and the issue is pending. What the learned judge has done is only has given me a
Not
right.
only on the prima facie case, also while granting injunction, you know very well jurisdiction is one of the prime components of prima facie.
Yes.
So that had to be taken into consideration by the court on the face of the plaint. We are going only by the face of the plaint
Yes,
and your
yes.
injunction.
But Lordship sees Malad only once, Malad, page 34, the my
But we are there only.
cause of
34 is
action.
the main thing.
Malad, my pleading is that the cause of action arose when they refused to pay the amount and receiving the email. Malad, that's what has been pleaded. Malad, I cannot improve on my case as to whatever is there. So I'm only Malad making
The moon is shining in paragraph 16 of your plaint.
yes.
It's a moon shining.
Very Malad, I leave it.
Either we set aside or we can, two options we are giving to you. This is, I mean, we'll ultimately choose the options, but we are giving the option to you. We can admit the injunction, appeal and put it on hold, grant a stay, and keep it pending, directing affidavits and all. Or we can set aside the order, dispose of the appeal, in which case we'll direct the learned trial judge, we'll say that this does not affect, none of the findings affects the order 711 or the suit. Tentative findings for the purpose of this ad interim stage. 711 will be heard out immediately, and dependent on that, the injunction application will be taken up thereafter and disposed of.
Then Lordship will kindly.
I think that will be better for all of
Yes.
you. Otherwise, grant of state remains pending for 2 years. Thank you for being intelligent. Please take your seats. We'll just pass out. The present challenge has been preferred against an ad interim order of injunction passed in connection with a suit instituted by the plaintiff stroke respondent numbers 1 and 2 for the following reliefs. Reliefs গুলো page 34 থেকে set out করবে, আমরা দাগ দিয়ে দিচ্ছি। এখান থেকে যেখানে দাগ দিয়ে দেবো, হ্যাঁ, page 34. Next para. Learned counsel appearing for the appellant argues that the learned trial judge, while granting ad interim injunction, failed to consider that the learned trial court did not have territorial jurisdiction to take up the matter. Push up, it is pointed out that the premise of the relief sought in the plaint is an agreement entered into by the parties on March 28, 2025. Push up, by such agreement.
Sorry. No, date February. Sorry.
Sorry.
I'm sorry, man. I should have.
No, we are sorry. February 28, 2025. Pushed up, by virtue of the said agreement, the plaintiffs were to render certain services to the defendants, who run a hotel from our premises at JBS Haldane, Haldane Avenue, Tangra, Police Station, Progati Moydan, Kolkata 700105. Which up next para. It is submitted that the first relief sought in the suit is a decree for declaration that the defendant is responsible and duty bound to give access to run the business in compliance of such agreement. Push up next para. As such, the plinth of the suit is premised around the location where the business was being run by the plaintiffs. Push up such location being out of the territorial, beyond the territorial jurisdiction of the learned trial court, the learned trial judge ought to have rejected the plaint on the ground of lack of territorial jurisdiction. Push up secondly, it is argued that the suit is, comma, in the garb of a declaratory suit, comma, one for specific performance of contract, full stop, since the premise of the suit is a service contract, comma, such a suit for specific performance does not lie, comma, for which uh, the plaintiffs have sought to obtain reliefs indirectly, comma, which they could not get directly. So next para, thirdly, comma, it is contended by the appellants that the only basis on which jurisdiction has been claimed to be within the City Civil Court at Calcutta, comma, the trial court, comma, is that the email by which the contract was terminated was received by the plaintiffs within the jurisdiction of the City Civil Court at Old Courthouse Street. Full stop. Next para. However, comma, learned counsel relies on learned counsel for the appellant relies on ONGC versus Utpal Kumar Basu and others, reported at 1994 4 SCC 711, to argue that the receipt of such communication and the location thereof is immaterial to ascertain the territorial jurisdiction of the court taking up the suit. Full stop. Next para. Both going by section 16 and section 20 of the Code of Civil Procedure, comma, the City Civil Court did not have jurisdiction, comma, since it is the Alipur Judges Court which has territorial jurisdiction to take up the matter, comma, according to the police station of the location of the hotel. Full stop. Next para. Learned counsel for the appellant next contends that the reliefs sought in the suit are primarily touching the immovable property, comma, which is situated outside the jurisdiction of the City Civil Court. Full stop. Next para. The suit is one for land stroke property and not for specific performance of contract in effect. Full stop. Next para. Lastly, comma, learned counsel for the appellant argues that the prayer for temporary injunction sought by the plaintiff stroke respondents was even beyond the reliefs claimed in the suit. Full stop. Next para. It is also insinuated that the relief of the plaintiffs could at best lie in damages. Full stop. Next para. Learned counsel appearing for the respondent argues, plaintiff's respondents argues that the suit is not one for land in its present form. Full stop. By placing reliance on relief small a within bracket in the plaint, comma, it is contended that the same seeks a declaration that the defendant is responsible and duty bound to give access to run the business in compliance of the agreement in question. Full stop. Next para. Thus, comma, the cardinal premise of the suit was the agreement and its termination. Full stop. Since the termination was communicated to the plaintiff stroke respondents, comma, the latter having received such communication at their office situated at Old Courthouse Street, which is, comma, in turn, comma, situated within the territorial jurisdiction of the City Civil Court at Calcutta, comma, the trial court has territorial jurisdiction to hear out the suit. Who's up next para? It is argued further by the respondents that in terms of section 20 of the Code of Civil Procedure, comma, a suit lies wherever even a part of the cause of action lies. Part of the cause of action took place. Full stop. Thus, comma, at least since the termination notice was received by email within the territorial jurisdiction of the trial court, comma, the said court has jurisdiction to take up the suit. Full stop. Accordingly, it is prayed that the appeal may be dismissed. Full stop. Next para. We admit the appeal to be heard on the grounds taken in the memorandum, comma, on being satisfied there is a strong prima facie case made out. Full stop. Next para. At this juncture, comma, we give option to learned counsel for the parties, comma, upon expressing our proposed order, comma, to choose as to whether they would prefer the appeal to be taken up for hearing to cut short unnecessary pendency of litigation before this court, comma, which would not be inure to the benefit of either of the parties. Full stop. At this, comma, the parties consent to the appeal being taken up and decided here and now. Push up next para. Upon a careful consideration of the arguments of the parties, comma, we find substance in the contention of the appellant, comma, as opposed to that of the respondent. Full stop. Unlike an agreement, comma, where the location at which the offer was accepted, comma, to form a concluded agreement, comma, might have a germane bearing on the cause of action, comma, a termination is independent and irrespective of the receipt of communication of such termination. Full stop. The receipt of the termination as pleaded by the plaintiff stroke respondents within the territorial jurisdiction of the city civil court is merely a fallout of the termination, comma, happening post facto after the termination has taken place the moment the email was sent by the defendant stroke appellant from its own office, comma, situated outside the territorial jurisdiction of the city civil court at Calcutta. Full stop. Termination takes place the moment it is decided by the by one of the contracting parties to terminate and takes a decision to so terminate, comma, which happened in the present case beyond the territorial jurisdiction of the city civil court by the mere fact of sending the by sending the email in question. Full stop. Hence, comma, we do not find substance in the defense of the respondents herein that accept the receipt of the termination, receipt of the email carrying the termination, comma, would have any germane bearing whatsoever on the jurisdiction of the court. Full stop. Going by the principle laid down in ONGC Supra, comma, cited by the appellants, comma, the mere fact that a communication was received by the defendant at a particular place does not confer territorial jurisdiction on the courts having jurisdiction over such location. Full stop. Next para. Secondly, comma, we find that the suit is not one for specific performance. Full stop. Although the first relief sought in the suit is a declaration that the defendant is responsible and duty bound to give access to run the business in terms of the agreement in question, comma, such business is actually run outside the territorial jurisdiction of the trial court. Full stop. More importantly, comma, relief B seeks a declaration that the defendant is liable to pay penalty and compensation for late stroke delayed payment. Full stop. Prayer C of the plaintiff also seeks a relief of a payment of 50% of average payment of the last few months. Full stop. Thus, comma, apparently, comma, on the face of the plaintiff, comma, the remedy of the plaintiffs lie in damages and not in specific performance. Full stop. Next para. Thirdly, comma, as rightly argued by the appellant, comma, the rights claimed in the suit, comma, in whatever manner couched, comma, ultimately lead to corporeal reliefs sought in respect of an immovable property which is situated outside the territorial jurisdiction of the trial court. Full stop. Even the temporary injunction application, comma, on the basis of which the impugned identity order was granted, comma, seeks a relief restraining the defendant stroke present appellant from transferring, comma, alienating, comma, mortgaging, and to create any third party interest in respect of the suit property. Full stop. Evidently, comma, such relief is not only beyond the prayers made in the suit, comma, but also betray the fact that the suit has been filed seeking corporeal reliefs in connection with an immovable property which is situated outside the territorial jurisdiction of the city civil court at Calcutta. Full stop. Next para. If the if the plaintiff stroke respondents were to argue that the suit is not one for relief regarding the right of the plaintiffs to run their business at the immovable property, comma, which again pertains directly to the immovable property, comma, then the outcome would be that the suit had to be couched as one for specific relief, which has evidently not been done by the plaintiffs, comma, for whatever reason, within bracket, one of which might be that a suit for enforcement of a service contract, comma, arguably, comma, is not maintainable within the uh, four corners of the Specific Relief Act 1963, bracket closed, full stop. Next para, thus, comma, on a comprehensive consideration of the materials on record and even on the face of the plaint and the injunction application, comma, we clearly find that the trial court did not have territorial jurisdiction to entertain the suit or to grant an ad interim injunction, comma, which facet, comma, despite being an integral part of prima facie case, comma, was not adverted to at all by the learned trial judge. Full stop. Next para. We, however, comma, we clearly we hereby observe that the above findings stroke observations made by us all pertain to the limited scope of the appeal which arises out of an ad interim grant of injunction and are not conclusive but only tentative in nature and shall not affect in any manner the pending proceedings before the trial court, comma, including the application under Order 7, Rule 11 of the Code of Civil Procedure, which is pending at the behest of the defendant stroke appellant, and or the disposal of the injunction application, finally, and or the hearing of the suit. Full stop. Next para. However, comma, in view of the above observations, comma, we are of the opinion that the learned trial judge clearly acted beyond jurisdiction and granted impugned ad interim injunction illegally dehorsed the law. Full stop. Next para. Hence, comma, FMAT 495 of 2025 is allowed on contest, comma, thereby setting aside the impugned order bearing order number 2 dated November 11, 2025, passed by the learned judge, comma, 7th bench, comma, City Civil Court at Calcutta in title suit number 2504 of 2025. Push up. Next para. The certified copy of the original certified copy of the impugned order has been filed before us today and be kept on record. Push up. The defect in that regard be deemed to stand removed. Push up. Next para. The learned trial judge is requested to take up the pending application under Order 7, Rule 11 of the Code of Civil Procedure filed by the defendant stroke appellant herein as expeditiously as possible upon granting opportunity to the plaintiff stroke respondents to file written objection thereto and after affording an opportunity of hearing to both parties. Full stop. It is expected that such exercise shall be concluded within 4 weeks from the date of 4 working weeks from the date of communication of this order to the learned trial judge. Full stop. Next para. Immediately upon disposal of the said application, comma, the learned trial judge shall take up for hearing the injunction application and decide the same in accordance with the decision arrived at on the application under Order 7, Rule 11 of the Code of Civil Procedure. Full stop. Affidavit, written objection to the injunction application shall be filed by the present appellant within a fortnight from this date in the trial court. Full stop. Anything else you want?
No, Your Lordship.
Consequentially, can 1 of 2025 is also disposed of. There will be no address to causes. Thank you. Let's go. কবে আছে?
I am for the appellant, my lord.
I am for the response.
And last occasion, lordship directed us to go through some rulings of Honorable Apex Court.
What was the point? Just remind.
Yes.
Oh, the irretrievable breakdown.
Yes.
Yes, my lord. Now, at
Yes.
first I am placing my case, my lord. Then I am coming that those rulings.
Yes.
Wife is the appellant before lordship.
Right.
Point taken in the plaint: desertion, cruelty, adultery. Now, issues has been framed on these points, and learned judge shot out some admitted proposition, admitted facts. Now, thereafter, some rulings has been placed, and then conclusion that plaintiff failed to prove cruelty, desertion, and adultery, but relied upon, learned judge relied upon irritable background of marriage.
Only that.
Only that point. But judgment is, my lord, and satisfactory judgment on the point. Learned judge at the conclusion saying the plaintiff is able to prove his case, but in the first portion says unable to prove. Only 7 except that irritable background of marriage. Some other points could not be able to prove by the plaintiff husband. Now, my lord, I am placing, my lord, the judgment, operative portion of the judgment, my lord. Kindly see page 86.
Yes.
86 bottom.
Yes.
After observing all the rulings and considering those rulings and my discussion as above, I think there is no chance of reconciliation between the parties. Marriage is beyond repair on account of bitterness created by the acts of the husband or the wife or both. And the courts have always taken irretrievable breakdown of marriage as a very weighty circumstance, amongst other necessitating severance of marital tie, and a marriage which is dead for all purposes cannot be revived by court's verdict if the parties are not willing. It is true that when the reconciliation attempt proved futile, marriage between the parties is dead for all practical purposes, and there is no chance of it being revived. Continuance of such marriage would itself amount to cruelty. What is cruelty is one case may not amount to cruelty in another case. The concept of cruelty differs from person to person depending upon his upbringing, level of sensitivity, educational, family, and cultural background, financial position, social status, customs, traditions, religious beliefs, human values, and the value system. All the issues are accordingly disposed of. Considering all aspects, I think the petitioner husband, Sri Ashim Kumar Shil, has able to prove his case beyond reasonable doubt against the respondent wife, Srimati Lovely Shil, alias Vishwas, and there is no legal impediment before the court to declare the marriage between the parties, which took place on 22nd January 2003, as dissolved. Now, my lord, the ordering question, the second paragraph of the ordering question, the marital tie between the petitioner husband, Sri Ashim Kumar Shil, and respondent wife, Srimati Lovely Shil, alias Vishwas, dated 22nd January 2003, as per Hindu rights and customs, is declared as dissolved with immediate effect in terms of the provisions provided in section 13.1, 13.1, Roman 1 and Roman 1b of the
Have you
Hindu
brought the
Marriage
two
Act
judgments,
55.
the Justice Dhule and Justice
Lordship.
Nagaratna? Two judgments? You have brought those judgments? Mr.
Yes, yes.
Both the judgments?
Yes, both the
If
judges.
necessary, we'll take later. Yes.
Well, at that
First point, my
Rakesh Raman as well as that judgment of Kohli.
judgment I'm
Common
qualified.
cause Kohli were there. No, we are speaking about the other two judgments.
Yes.
Justice.
One is Revati probably.
Shilpa, Rakesh Raman.
Yes, and
And
Revati.
Shilpa Shailesh. Shilpa Shailesh, Rakesh Raman, and the one was Rinku Baheti.
Rinku Bhai, right.
Yes. Now, my lord,
Rinku Bhai diluted Rakesh Raman. That's why
yes,
that's in your
yes,
favor.
yes.
Maybe you argue.
Related upon both the judgments. Now, my first point is section 13.1a, 1b. 1a says cruelty, 1b desertion. So, first 1b is concerned, 2 years must be there before placing the. In this case, 2000 cause of action, we are seeing, my lord, that March 2011 cause of action arose and suit filed in the same year 2011. So 2 years separation is not possible. That is 1b, 1b is not applicable. That desertion is not applicable in this case. And first one, cruelty. Learned judge never discussed anything that petitioner plaintiff has been able to prove cruelty exerted by his wife upon her or in-laws. Therefore, these 2 points are totally
But does the
valid.
court deal with cruelty and holds that it is
Nothing, my lord.
failed to prove?
Nothing, my lord. Failed to be, yes.
No, that failed to prove.
My lord, kindly come page 78. page 78. It starts from page 77. Better can you have
77? Yes.
77. His learned court says there are some admitted positions in this case. Now 1, 2, 3, 4. Then you also kindly see next page 18, 78, 18. There is no chance between the parties to live together as husband and wife. 19. Both parties have raised wild allegations against each other, and both of them did not prove the allegations of adultery to each other. So far as cruelty is concerned, my lord, learned judge remains silent, totally silent. There is no observation that cruelty has been exerted by the wife against in-laws or the husband, all related upon the irritable background of marriage.
How many cases? 125 has been filed by you. Section
498
Yes,
also.
498,
Section
DV
12 of the domestic. This is PW DV.
DV, my lord.
Section 498A is also there.
Yes.
But that has been disposed of, my lord, resulting, my lord, acquittal.
Which one?
498A. That was against the husband, the sister of the
We'll
husband.
come back. We'll come
Yes,
back.
your lordship.
Mr. Mukherjee, take your seat.
Yeah,
We'll
yeah,
hear it.
And
Yeah.
normal so far as cruelty is concerned, then Lordship kindly come to the plain case.
Domestic Violence Act was filed by you against your
Yes.
mother-in-law.
Yes, madam.
All are filed by you.
Yes, all of 5 brothers. Actually, she was under cruelty by in-laws and husband also.
No, you have a right to file.
Yes.
Case. And
Now, my lord, kindly come to the plain case. What plaintiff says, how cruelty has been made by the wife against in-laws and the husband. For a moment, my lord.
what is this Exhibit B you have court considers it? You have signed in a white paper saying that relationship has totally ruined.
Yes, at the
What was the
page 75, my
what
lord.
was the occasion for saying that?
Yes, on that
That is at page 75.
75, my lord.
9/9/2010. 9/9/2010.
2010. It is much prior to filing of the case. This is as per instruction of my client, my lord. They forced him to leave the room.
This
He is
was
leaving-
exhibited by you. Exhibit B means defendant.
Yes, yes, my lord.
So why did you exhibit B to prove what?
To prove that she was under pressure to quit from the matrimonial home. Then this agreement was written. Document was given by the wife to claim some amount. If she is satisfied, then he is ready to quit the.
You have said that
premises.
মনোমালিন্যের জন্য বিবাহ বিচ্ছেদে সম্মত হলাম এই মর্মে বসত বাটিতে আমার নামে নথিভুক্ত করুন. So you are agreeable if he transfers the property in your favor.
Yes, that was the point.
On that condition, you are agreeable to বিবাহ বিচ্ছেদ. So what remains between you?
I'm in the last section I have said, my lord, that the
You are just
situation.
trying to retain him just as a mode of blackmail now.
No, my lord, that is not fair. Actually, this
You
lady-
signed, you have exhibited the document, not that you have denied it. They have produced your document. You say that if they transfer the house to you. Yes, exhibit B.
my lord, most probably it isn't submitted by the other state.
Page 77, just see, it's exhibit B. Second last sentence court says exhibit B. Exhibit B means it has to be by the defendant.
But natural,
Was the evidence there? Might be that they put it in cross-examination and you said admitted something like that. Then also you maybe, let us see the evidence once, how exhibit B comes. Evidence will show. Where does DW1 start? The cross-examination or whatever.
Nablish starts one of my lord.
Lovely checks oral evidence, not the affidavit in chief.
Page,
But-
page
54, yes, 50. 54. You deposed alone or somebody also supported you?
He supported somebody, his sister and local inhabitant.
So let us see how exhibit B comes. Yes, yes, yes. Page 57. It was tendered as was our hunch. It was tendered in cross-examination by them. On perusal of the Seacha. Please come to page 57.
57 my lord, for the person.
On perusal, just about 6 lines, 7 lines from the top. On perusal. Just before exhibit B.
Exhibit B. On perusal of the same witness stated that the signature and the handwriting was of her. Let the same be marked as exhibit B. It isn't a fact that whatever I stated in paragraph.
One Xerox copy is shown to the witness. On perusal of the same, witness stated that the signature and handwriting was of her.
Yes.
So you admitted your handwriting, your signature. Exhibit B.
Yes, my lord.
So, but you do not explain away Do not say that it was done under compulsion or force. Nothing of that sort.
No, it can even happen in indication of
Let us see whether you have tried to explain on recall. You could have explained if it was not your handwriting. There's nothing of that sort.
টিকিট করোনি তোমরা
কিছু বলতেই দেওয়া হয়নি ওইখানে যেটুকু
সেটা
জিজ্ঞেস
আলাদা কথা আমি করিনি
Yes.
Yes. Now, my lord, the fact is that the petitioner is not an educated lady. He just school final passed. Now,
Final is sufficient.
situation was not,
Not a naive baby.
no, and one child also. The child now major. It may be
Must have become major by now.
Yes, my lord, major. The only difficulty is that
There are less than school final pass people who are, I mean, we don't want to comment, but who are in very high positions.
that's true, but he's unlucky and unfortunate. He has not got such a chance to get some high position. But problem is, he has a source of income and he has a residential accommodation. So that's why.
What you meant to say, not about the high position. You are capable of understanding things.
Yes, my lord.
School final pass lady, her evidence shows that she's.
No, I'm not.
She has been filing.
I'm not on that, my lord. Yes, yes, yes. He has admitted. What I'm saying, my lord, that
No,
he has
school
to.
final pass. So how does that matter?
What I'm
Regarding permanent alimony, will
yes,
definitely
that is the point.
will definitely give you leave to file at section 26. That has to be done by evidence and in the trial. If
That
you
is-
grant a degree of divorce, it's your right to file a section 26, 26 and 25.
25.
25, sorry. 26 is custom. You have a right to file section 25 and please go and file 25. We'll say, give that liberty to you. Without that liberty also you can file.
File করেছি তো 25 না?
Even if you have not filed, language of 25 is at the time of passing of the degree or after, you know that. Or at any time thereafter. You can at any time you can go and file a section 25 if a divorce is granted. Divorce has been granted here, you could still file, but because you have preferred this challenge, obviously you did not prefer at 25 because you are trying to set aside that.
That's it.
If you affirm that, Mr. Das, you are entitled to go and file a section 25 tomorrow. But we don't find anything, I mean, in view of these judgments. You can argue on the judgments.
On
We have dealt with this in other matters also. You know our view by now because you were in court on the last few occasions. It's a dead marriage. When did you last live together?
2011. 2000 up to 2011.
Up to 2000. When was the marriage?
2003, my lord.
2003 marriage.
2006, I have a child. Born,
2006 child.
and 2011,
2011
divorce file.
you separated in 2011 for whatever reason.
Yes.
So you stayed together for 8 years
Lordship.
and you are I mean staying apart just for the period of bonobas, 14 years.
But
What
before,
remains in the marriage apart from permanent alimony, which you have a right to claim?
practically, I mean, that is the case.
What is the husband doing? I mean, we don't know.
He's a airport service in airport. Service.
You are school final, he's service in airport, get a huge amount of maintenance from there. We shouldn't advise you. Mr. Mukhopadhyay will advise his client how to defend. Otherwise, we don't find anything.
Just কত salary জানো? He earns more than 1 lakh per month.
We cannot grant it from here because the court also has to consider
liabilities has to be transmitted.
assets also. Not only
In this
Only
case,
one thing, my lord. Only one thing, my lord, I will submit.
no, Mr. Das has finished or anything.
Yes, my lord. That is the
No use here. This is his beauty. I mean, He understands.
Honestly, my lord, don't worry.
He has the quality of a good advocate. I mean,
Apart from
obviously,
any other evidences adduced by the parties, my lord, only one thing which is very vital.
reconciliation failed.
That is true. One residential accommodation which is standing in the name of the husband as well as her sister, she has been occupying and has driven out. The husband, sister, and the mother-in-law. Mother-in-law filed an application under Domestic Violence Act, got an order. That order has been stayed by filing a revisional application by this wife.
Maybe, but
She is not allowing. Huh?
these are not part of the record or not before the
Yes,
trial.
part of the record. In the evidence that has come.
In the trial court, it was
Yes,
discussed.
yes.
Which was that?
Yes.
Your mother filed the Domestic Violence Act.
Yes, filed.
Got an order there that has been stayed in revision.
Yes,
They
revision.
have a right. That's a legal right they have.
That's the legal right.
That
She has
does not tantamount
exercised.
per se to cruelty. It's
She
so
has-
fact that is not
She
true.
has exercised, and my lord, on exercising legal right, she filed an application under 498A against me and my sister and the husband of my sister. That resulted acquittal. My lord, kindly visualize the entire situation. My lord.
You cite those judgments. That is the last two. Rakesh Raman and the other one. Rinku Behati.
আমি দিয়ে দেবো?
এই তো রাকেশ একটা কথা শিল্প শৈলেশ দেখো তো একটু একটা দিচ্ছি একটা রাকেশ রাকেশ রামন and
দুটো কপি দিয়ে দাও।
these are Shilpa Shailesh.
No, the Revati, the Rinku Behati.
Rinku Bhai there.
Why are you citing Shilpa Shailesh? Because Rinku Behati referred to it.
Yes.
Shilpa Shailesh was on under 142 it was granted.
142, my lord.
142 it can be
It's-
granted
it's
at any point of.
at-
That
at-
does
at
not
what
mean that it cannot be granted under 141. That is what Rakesh Raman actually, in particular, in a particular paragraph, is very clinching that
It's 6.
it is cruelty under section 13(1).
Though it is not relevant in my case, but one thing, it is stated that in case of irritable breakdown of marriage, that will be treated as cruelty.
Yes.
But first, my lord, it has been to be declared irritable breakdown of marriage. That can be done by the Honorable Supreme Court only.
No, there is no
Then
question of
it will be
declaration.
wrong.
That has been read as a ground of divorce.
But
Under,
that is why I put this question to myself, my lord. Can the district judge has the power to decide it is irritable breakdown of marriage? Then comes cruelty.
yes, Phil, the passage has been.
Your lordship
But-
kindly comes to page 54. Evidence adduced
Yes.
by the wife in the cross-examination. My lord, at the bottom portion, I will not trouble to your lordship to take the entire, my lord. Last 8-9 lines from the bottom. It is a fact that I have filed a case under section 498A, read with section 406 of IPC against my husband, my married sister-in-law, and her husband. Lordship, kindly pause for a moment. This was adduced, my lord, on 2017. And thereafter, in the year, my lord, in the year 2020, that resulted acquittal. I am placing two judgments. He must be aware of.
Give a copy to them also.
At page 10, your lordship will find ordering portion. কোহলি judgment কোহলি না ভান্ডারি না কোহলি কোহলি ও হ্যাঁ হ্যাঁ নীল কোহলি
Yes. Anything else, Mr.
And my lordship knows, my lord, in Sri Rakesh Raman's case, a reference has been given in respect of Navin Kohli versus Nilu Kohli's case.
Navin Nilu, Samar Ghosh.
Yes, Samar Ghosh. My lord, in Navin Kohli's case, Honorable Supreme Court held repeatedly that repeatedly filing of criminal cases by one party against the other in a matrimonial matter would amount to cruelty, and same was reiterated by a division bench in case Srinivas Rao versus D.A. Deepa. But this is the view, my lord. Even filing.
Cite that separately. You can cite that.
Lordship may.
You can cite that to us.
At page, your lordship will find at page number 8.
We don't have that judgment.
No. Rakesh.
You are relying Navin Kohli.
Navin Kohli, which has been discussed in Rakesh. Your lordship will find there.
Yes, that is there.
That is there, my lord. And I will.
But in Navin Kohli,
yes,
Rakesh Raman says Navin Kohli, a strong recommendation has been made by the court to consider adding irretrievable breakdown. That means that it is not a ground. And it is not a ground in the law.
My lord,
Paragraph 14.
Yes.
The paragraph which you read after that, a few lines after that, one paragraph after that, Supreme Court says in Navin Kohli, a strong recommendation has been made by this court to the Union of India to consider adding irretrievable breakdown of marriage as a ground for divorce. That per se, that ipso facto means that it is not yet a ground.
Yes. The same has been reiterated by the Law Commission's report.
It was Rakesh Raman where it was first held that whatever else was there, it is there for a ground for dissolution of marriage under 13. That is where the law was laid down, according to us.
Yes, in Rakesh Raman's case, my lord. That has been stated by the Honorable Supreme Court. It has to be treated as the ground of cruelty, my lord.
We will be passing our judgment right now. The present appeal has been preferred by the. Please take your seats, all. Present appeal has been preferred by the defendant wife in a suit for divorce against a judgment decreeing the respondent husband's suit for divorce against the appellant. First up, next para. The suit was filed inter alia on the grounds of desertion, cruelty and adultery. First up, next para. It is pointed out by learned counsel for the appellant that none of the grounds were discussed at length by the learned trial judge, but the impugned decree was passed primarily on the ground of irretrievable breakdown of marriage. Which it is submitted that irretrievable breakdown of marriage, by itself, is not a ground recognized by Indian law for grant of divorce. First of next para, learned counsel submits that insofar as the ground of desertion is concerned, the cause of action for the suit allegedly arose in the month of March 2011, whereas the suit was filed in the year 2011 itself. Full stop. Section 13 within bracket 1 within bracket small b of the Hindu Marriage Act, 1955, which contemplates the ground of desertion as one of the grounds for divorce, clearly stipulates that unless there are 2 clear years before arising of the cause of action and the filing of the suit, no suit for divorce can be decreed on such ground. Full stop. Such test having not been met in the present case, it is argued that the suit could not have been granted on the ground of desertion in any manner and was not so granted by the trial court as well. So next para, insofar as adultery is concerned, comma, it is pointed out that the same was also not proved. Full stop. More importantly, comma, learned counsel for the appellant argues that the learned trial judge did not independently come to any specific findings of cruelty against the present appellant wife. Full stop. Next para. Despite the same comma, the learned trial judge granted divorce only on the ground of irretrievable breakdown. Full stop. Next para. By placing reliance on the judgment of Shilpa Sailesh versus Varun Srinivasan, comma, reported at 2023 5 SCR 165, comma, learned counsel for the appellant argues that divorce was granted on the ground of irretrievable breakdown in the said case by the Honorable Supreme Court, comma, invoking its jurisdiction under Article 142 of the Constitution of India, comma, which permits only the Supreme Court to pass any decree or order to do complete and substantial justice between the parties. Full stop. Next para. However, comma, such power was not available to the learned trial court, comma, which granted the decree of divorce. Full stop. Next para. Learned counsel also relies on an unreported judgment of the Honorable Supreme Court in the matter of Rinku Baheti versus Sandesh Sharda, comma, where the Honorable Supreme Court took into consideration all judgments, comma, including that of Shilpa Sailesh Supra, and held that the Honorable Supreme Court has the power under Article 142 of the Constitution to grant a decree of divorce. Full stop. The case of Rakesh Raman versus Kavita, reported at 2023 3 SCR 552, was also considered therein. Full stop. In the case of Rakesh Raman Supra, comma, although the Honorable Supreme Court took a view that irretrievable breakdown amounted to cruelty, comma, the Honorable Supreme Court, comma, in the case of Rinku Baheti Supra, comma, held that such power was exercised under Article 142 of the Constitution of India. Full stop. Next para. In such view of the matter, comma, it is pointed out that the appellant wife, comma, having not been guilty of cruelty and still wanting to live together with the appellant husband, comma, no case of irretrievable breakdown or cruelty was made out. Full stop. Thus, comma, it is argued that the impugned judgment and decree ought to be set aside. So next para, learned counsel for the respondent places reliance on Rakesh Raman Supra and argues that in the said judgment, comma, the Honorable Supreme Court did not exercise merely its powers under Article 142 of the Constitution, but also laid down the law that irretrievable breakdown is a component of cruelty and thus, comma, comes within the contemplation of Section 13 within bracket 1 within bracket small a bracket closed, comma, tantamounting to cruelty by itself. Full stop. Thus, comma, it is argued that the learned trial judge was justified in passing the impugned decree. Full stop. Next para, learned counsel for the respondent husband next hands over a photocopy of a certified copy of an order of acquittal passed in a proceeding initiated by the appellant wife under Section 498 capital A of the Indian Penal Code against the husband, comma, his sister and the sister's husband. Full stop. Next para. By relying on the same, comma, it is argued that the filing of such false case, comma, which has been disbelieved by the competent criminal court and the respondent and his relatives acquitted, comma, itself tantamounts to an act of cruelty. Full stop. Learned counsel further points out that multiple multiple complaints, criminal complaints were lodged against the respondent and his family by the appellant wife. Full stop. Next para. Such baseless allegations, comma, it is argued, comma, by themselves constitute cruelty sufficient to grant a decree of divorce. Full stop. Next para. Learned counsel for the respondent husband further submits that a proceeding that since the appellant wife ousted the appellant and his parents from the appellant respondent and his mother from their residence, comma, a proceeding had to be initiated by the respondent's mother under the Domestic Violence Act, comma, which culminated in an order passed by the competent court, by the competent forum, directing restoration of possession to the respondent and his mother. Full stop. Next para. However, comma, the appellant wife has preferred a revision and obtained an order of stay against the same, comma, thereby depriving the respondent and his mother from residence in their own property, in their own dwelling house. Full stop. This, comma, it is argued, comma, also amounts to cruelty. Full stop. Next para. Learned counsel specifically relies on the judgment of the Supreme Court rendered in the matter of Naveen Kohli versus Neelu Kohli, reported at 2006 4 SCC 558, comma, where it was held by the Honorable Supreme Court that repeated filing of criminal cases by one party against the other in a matrimonial matter would amount to cruelty. Full stop. Next para. The said proposition was also reiterated by a division bench of the Honorable Supreme Court in K. Srinivas Rao versus D.A. Deepa, DWPA, reported at 2013 5 SCC 226. Full stop. Only upon considering the said position, comma, the Honorable Supreme Court, comma, in Rakesh Raman Supra, comma, came to the conclusion that irretrievable breakdown by itself is a component of cruelty. Full stop. Next para. In the circumstances above, comma, it is argued that the learned trial judge was justified in passing the impugned decree of divorce. Full stop. Next para. The position of law is required to be ascertained first before coming to conclusions on the facts of the case. Full stop. We therefore take up for consideration Rakesh Raman Supra at the outset, comma, since in the said judgment, comma, the Honorable Supreme Court considered all relevant previous judgments holding the field. Full stop. As rightly argued by learned counsel for the respondent before us, comma, the Honorable Supreme Court relied on Naveen Kohli Supra and K. Srinivas Rao Supra, in both of which it was observed that repeated filing of criminal cases by one party against the other in a matrimonial matter would amount to cruelty. Full stop. Next para. In Rakesh Raman, comma, the Honorable Supreme Court observed that in its considered opinion, comma, a marital relationship which has only become more bitter and acrimonious over the years does nothing but inflict cruelty on both the sides. Full stop. To keep the facade of this broken marriage alive. Facade hoche FACADE. Facade of this broken marriage alive would be doing injustice to both the parties. Full stop. It was further held that a marriage which has broken down irretrievably, comma, in the opinion of the Supreme Court, comma, spells 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 cruelty to both these parties, comma, as in such a relationship each party is treating the other with cruelty. Full stop. The Honorable Supreme Court, comma, on the basis of the above findings, comma, came to the categorical conclusion that it is, comma, therefore, comma, a ground for dissolution of marriage under section 13 within bracket 1 within bracket small ia bracket closed of the Hindu Marriage Act. Which of next para, thus, comma, the said judgment clearly lays down the law of the country under Article 141 of the Constitution to the effect that irretrievable breakdown of marriage between the parties is itself a ground for dissolution of marriage under section 13 within bracket 1 within bracket small ia of the Hindu Marriage Act, comma, therefore bringing the said component within the purview of cruelty, comma, which is a valid ground for grant of divorce in the Indian law, comma, particularly under the Hindu Marriage Act. Push up. Next para. Although in numerous judgments, comma, the Honorable Supreme Court has repeatedly been requesting stroke recommending the Parliament to enact appropriate amendments by incorporating the ground of irretrievable breakdown as one of the grounds of divorce, comma, fact remains that the legislature, comma, in its wisdom, comma, has not yet done so. Full stop. Therefore, comma, on a strict and narrow interpretation, comma, section 13 within bracket 1 within bracket 1 small ia of the Hindu Marriage Act till date does not include irretrievable breakdown as a ground of divorce. Full stop. However, comma, Article 141 of the of the Constitution of India vests untrammeled power on the Honorable Supreme Court to lay down the law of the country, which, comma, as and when enunciated, enunciated, comma, becomes the law of the land and has binding precedential value, comma, on all subordinate courts as well as other constitutional courts and becomes the law of the land. Full stop. Thus, comma, the specific observation of the Honorable Supreme Court, comma, taking into consideration the previous judgments in the field, comma, to the effect that irretrievable breakdown is a ground for dissolution of marriage under section 13 within bracket 1 within bracket small ia of the Hindu Marriage Act clearly raises the clearly lays down the proposition that irretrievable breakdown itself is included within the definition of cruelty, comma, which is a ground of divorce under section 13 within bracket 1 within bracket small ia of the said act. Push up next para. In Rinku Bahati Supra, comma, the Honorable Supreme Court, comma, while considering several judgments, comma, came to the conclusion that the Supreme Court has, comma, under Article 142 of the Constitution, comma, the power to grant a decree of divorce in spite of the same being not a ground recognized by Indian law. Full stop. Next para. However, comma, a judgment is only a precedence for the exact proposition laid down therein, and not whatever can be derived or inferred from the same. Full stop. Next para. In Rinku Bahati Supra, comma, the Supreme Court was deciding an application under section 25 of the Code of Civil Procedure for transfer of a matrimonial suit and posed before itself the question as to whether in such a proceeding, comma, a decree of dissolution of marriage can be granted by it under Article 142 of the Constitution of India, comma, which was answered in the affirmative. Full stop. Hence, comma, the judgment has to be read in such context. Full stop. In the said case, comma, the Honorable Supreme Court was not considering an appeal against a decree of divorce granted on the ground of irretrievable breakdown and was not adjudicating on the question as to whether such component is included within the definition of cruelty. Full stop. Next para. In the passing, comma, it was observed, comma, in the same paragraph within bracket paragraph 8.1 bracket closed of Rinku Bahati, where Rakesh Raman Supra was being considered, comma, that the exercise of power by the court under Article 142 within bracket 1 to grant a decree of divorce and the factors to be considered while doing so have varied with facts and circumstances of each case. Full stop. Next para. Such observations makes it clear that the Honorable Supreme Court, comma, in Rinku Bahati Supra, comma, neither disapproved, comma, nor overruled by implication or explicitly, comma, the law laid down in Rakesh Raman Supra, comma, which the latter being in consonance with the previous judgments of the Supreme Court itself. Full stop. Next para. In Shilpa Sailesh Supra, comma, the Honorable Supreme Court granted a divorce decree under Article 142 of the Constitution of India in the context of considering Section 13 capital B within bracket 2 of the Hindu Marriage Act, comma, as to whether the waiting period for mutual consent could be waived by the Supreme Court. Full stop. In such context, comma, the Honorable Supreme Court held that the timeline stipulated in section 13 capital B within bracket 2 of the Hindu Marriage Act could be waived by the Supreme Court under Article 142 of the Constitution of India, which was entirely on a different footing than the present case, and hence, the said judgment is not applicable. For sub next para, thus, in the event there is irretrievable breakdown of marriage, the same constitutes cruelty, which is a ground under section 13 within bracket 1 within bracket small ia of the Hindu Marriage Act for granting divorce. Full stop. Next para. Proceeding on the above premise of law, we find that in the evidence of the wife, she had admitted that she had filed a case under section 498 capital A stroke 406 of the IPC against her husband, that is the present respondent, his married sister and her husband. Full stop. She also admitted in her cross-examination that she did not file any case of Domestic Violence Act. Full stop. Next para. However, that she did not file any petition showing her intention to stay with her husband in any of the cases, such as in the case of DV Act. Full stop. Next para. During her cross-examination, a letter, a declaration by her, written by hand was tendered to her, which she admitted to contain her signature and handwriting and was marked as Exhibit B. Full stop. Exhibit B, in Bengali vernacular, specifically states that the appellant wife was agreed to a decree of dissolution of the marriage between the parties, subject to the residential accommodation of the respondent husband being transferred in favor of the appellant wife and rupees 5 lakh being paid to the appellant wife. Full stop. Next para. That apart, we also take judicial note of the fact that the marriage between the parties happened in the year 2003. Full stop. The parties are living separately, admittedly, since March 2011. Full stop. Thus, they lived together as spouses only for a period of 8 years, whereas they have been living separately from 2011 till date, for almost double the time, that is for 14 years. Full stop. There is no attempt from any corner by either of the parties, evident from the records, as to any animus revertandi, by any of the spouses seeking to return to each other. So rather, the learned trial judge observed categorically that the attempts at reconciliation had failed. Full stop. Next para. Several criminal cases were filed by the appellant wife, including one under sections 498 capital A and 406 of the Indian Penal Code, which ultimately led to acquittal of the appellant and his relatives. Full stop. Even the other cases, of criminal nature, by themselves indicate that the animus of the appellant wife was never to return to the husband, but to go on filing criminal complaints and cases against him and his family. Full stop. Next para. Without the appellant wife having proved before the learned trial judge any reasonable basis for such complaints, rather one of them having resulted in acquittal, we also find an element of cruelty in such filing of numerous applications against the respondent husband. So also, Exhibit B, the declaration by the wife, which is admitted to be in her handwriting and signature, clearly gives out the intention of the wife that she is otherwise agreeable to a dissolution of the marriage, subject only to the respondent husband transferring his residential house to her and paying an amount of money to the appellant. Full stop. Next para. In such view of the matter, we clearly find that the learned trial judge was perfectly justified in arriving at the conclusion that the marriage between the parties are dead for all practical purposes. Full stop. In line with the ratio laid down in Rakesh Raman Supra, thus, we are of the opinion that the marriage has only become a deadwood and would create further cruelty for both parties against each other. Full stop. Maintaining such a facade, comma, borrowing the language from Rakesh Raman Supra, comma, would only lead to further pain and torture to the parties. Full stop. Next para, thus, comma, FA 149 of 2019 is allowed on dismissed on contest, thereby affirming the impugned judgment and decree dated May 16, 2018, passed by the learned additional district judge, fast track court Roman 4, comma, Barakpur, comma, district North 24 Parganas, in matrimonial suit number 930 of 2011, and dissolving the marriage between the parties on the ground of cruelty by way of irretrievable breakdown of marriage. Full stop. Next para, it is interim order, if any, stands vacated. Full stop. It is, comma, however, comma, made clear that it will be open to the appellant wife to approach the jurisdictional court with an application under section 25 of the Hindu Marriage Act seeking permanent alimony. Full stop. If such an approach is made, comma, the learned judge having jurisdiction shall decide such issue independently and in accordance with law upon giving adequate opportunity of filing objections, filing their pleadings and hearing to both the parties without being unnecessarily influenced by any of the observations made above. No orders to cause, a formal decree be drawn up accordingly.
Obliged to.
Sorry, Mr. Das. Law says otherwise, according to our opinion. We'll take up the next matter when we come back. This matter is over. Irretrievable breakdown. Granted.
Irretrievable breakdown.
Right. Copy
My-
paste from the previous judge. We noticed when we were going out that we broke a marriage at Brihaspatibar Barwala. We don't know. I mean, we have to probably.
But it was already
Ganges is now already dirty, so we have to find some other river.
No, it was your lordship's. No, not this case. It was affirmed by your lordship, the broken marriage.
Yes, but the effect remains the same. Anyway, what is your case?
My lord, the appellant before your lordship is an MBBS doctor and working in a government hospital, and the husband, as per the evidence produced by him, is a daily wage laborer of earning rupees 300 per day. My lord, it's a mismatch from the day one, though he presented himself to be a successful businessman. In 2004, they met each other through a cross connection of a telephone call. They fell in love.
This is like a
Yes. It's an observation from the impugned order itself, impugned judgment.
There are some people who can speak for hours even in a cross connection.
Yes.
But probably they were of that sort.
Yes.
But this is a copybook fairy tale.
Yes.
Why is it ending?
Means 2011, they had a son. Thereafter,
Did the marriage take place?
2007. 2007, the marriage was solemnized behind the back of their parents. It was made an impression by the opposite party that no, if you tell your parents, there will be objection. She accepted that terms.
You are a naive little baby,
Yes.
and you agreed
Yes,
to
yes,
that.
yes. That is,
You're an MBBS doctor.
yes.
You know the consequences. Why
Yes,
cast the blame on him?
No, I'm not casting the blame on him. I'm saying this is the situation. These are the facts. So I accepted that. I wanted to try to this
Obviously,
marriage.
you were also
Yes.
willing. That's
Yes, I was willing. 2011, the marriage was solemnized. Thereafter, I was posted in different
Seven
places.
marriage.
7 marriage,
11 son.
child son. Thereafter, I got as a BMOH in different parts of the Malda. Then I took a transfer in Sankrel. That is my father-in-law's house. That is my husband's house. Thereafter, I was persuaded. Sankrel. Thereafter, I was persuaded that after that the child is growing, you should take transfer, because in the meantime I came to know that there is a dispute between the mother-in-law and these things are going on, and the husband persuaded that you take a transfer to the Karsiong so that our child could have a better life. So this is an admitted fact. This is in his
matrimonial home is in
Sankrel.
Thereafter
in Karsiong, since 2015, I was posted. Since 2015, the husband took a loan in my name near about.
Stayed with you?
No, not stayed. Not stayed with. He only used to come only for the purpose of taking money. That is, occasionally he would come. From 2015 to 2017, there is a huge unrest. In 2017, I would say there is a huge unrest. There is regarding Gurkha land issue. He didn't came. He didn't turn up. Only to just to visit his child. Also, he would turn up.
Only was in a boarding school in.
No, not in boarding school. With the mother in Karsiong.
Then how were you convinced that Karsiong would give a better life to your child?
It was
You were also an
yes, I was also a party to that. I'm not saying that. I was convinced to that. I got a transfer to the Karsiong. I went to the Karsiong. I was posted there. My husband never used to come, only for the purpose of taking money. The loan was taken of 25 lakhs for constructing the house. It is an admitted fact from the evidence that what was the purpose, how he used the loan. The house was never constructed. The money was never used. Even the LIC amount, LIC policy was made in my name. That was also monthly installments they are deducting. Now, up to 2018, the situation was so that each and every occasion he would come for the money, and the moment if I deny, then the dispute means there is a discord. Thereafter, once he also threatened in presence of the office staffs of the hospitals.
Take your seat.
That I have mentioned in my plaint also. In presence of the hospital staff, threatening, abusing, these things are going on. In 2018, I filed this matrimonial suit.
Threats in presence of your
yes,
colleagues.
I'm my colleagues in the hospital. that part of the evidence was not taken by the learned court below. In 2021, when the evidence was taken up, I prayed that
Suit is of 2018.
2018. Since 2015, we are separately living. Though he is coming only for the purpose of money. And once also in 2018, he came to threaten me in my house.
To Karsiang in
Yes.
2015.
Yes, since 2015.
Yes.
Thereafter, in 2018, prior to filing of the this matrimonial suit also, he came to threaten in my quarter that he would kidnap our child, he would take away. I filed a GD to that effect also in 2018. Thereafter, I filed this suit. Thereafter, in 2021, when I want to adduce the evidence, because I want to adduce the evidence through online, because at that time Corona was going on, court said that it is not well equipped. That's why I cannot take the evidence. That application was turned on, page 7 of my paper book. And while considering the cruelty part
in 2021,
you
are also challenging that order under section 105. I mean,
I have not challenged. I have not.
No, you need not specifically put it as a ground, but you can take it as a challenge. Irregularity in any interlocutory order can be challenged under 105. Under order for 33, you can look into that.
Yes. And thereafter, in this appeal, while
revision is required to be filed under section 105, that can be set up as a ground of appeal. But in the ground also, it's not.
My lord, while considering all the issues, the honorable the learned court below has framed out the issues of cruelty, adultery, and desertion. My specific application was under 27(1)(b) and D of the Special Marriage Act, cruelty and desertion. I made it an allegation that my husband was chatting with other ladies in the plane, and that lady used to go with us in the tour on the persuasion of my husband, and I have seen my husband with him in the another room, and that part was not in the part of the plane. That's why the learned court below has said that that is not in the plane, that cannot be considered. But that was the chatting which has created doubts in my mind. I have seen with him another room. That also amounts to cruelty. And considering that allegation, the learned court below has taken out the issue of adultery also while framing the issues. The adultery cannot be sustained because I have not made the other lady as a party. That's why that adultery part cannot be sustained. The cruelty cannot be sustained because I have not adduced evidence, though it has not observed that my evidence was not considered, was turned down.
You did not adduce evidence at all.
I could not adduce evidence with respect to cruelty.
Only with respect to cruelty?
With respect
your
to
evidence is on record?
Yes, my evidence.
You wanted to additionally give evidence?
Yeah, I order 41 rule 27. I have made out an application here.
In the trial court, you took out an order 18 rule 17 application?
Yes.
Took out an order 18 rule 17 application? At subsequent stages?
No.
What was your application for permitting to adduce
evidence of the
General Diary lodged on 10/8/2018 being GT entry 417 to the officer in charge of the Karsiang police station. Petition filed by the applicant appellant before the learned trial court on 10/12/2021, which was affirmed on 23rd of August 2021 for taking further evidence and applicant's MBBS certificate. These three documents. General Diary, Milord, that is his knowledge.
No, that is the
her knowledge is there, Milord. 2018.
That is this.
Which page are you reading?
It is a supplementary.
Supplementary affidavit they have filed in connection with the CAN2 application, Milord.
CAN2 is the order for 10/27.
Yes.
We'll look into that also. Page 7
of the paper book, that order was.
Who did you seek to produce in evidence as witnesses?
The office staffs of my hospital. In my supplementary affidavit, it is at page 4.
That application?
Yes.
Only these 3 persons you wanted to call
Yes.
to show further cruelties.
Yes. Not 3, my lord. There are
No, sorry.
5 more.
8.
8
Up to
persons.
7. 8 persons. Yes.
Oh. Oh.
All right.
My lord, may I read out the observation of the learned court below in the impugned judgment, where it would itself demonstrate that it is an irretrievable breakdown of marriage and the conduct of the respondent amounts to cruelty.
Which page?
My lord, it starts from the observation starts from page 61 after the reliefs, and the impugned judgment starts from page 51. Page 61 after reliefs. My lord, may I take the liberty to read out the 3 pages, if your lordship.
From 61?
Page 61, if your lordship so permits.
Yes.
Page 61, after the relief.
Yes.
The respondent admitted that the acquaintance between them started on a cross-examination in a
Connection, not examination. Everyone is not a lawyer.
Oh, my cross connection, my lord. I am sorry.
Yes.
The respondent also says that he had business at the time of his love affairs with the petitioner, which business suffered loss. In cross-examination, the respondent DW1 said that he earns 300 per day as a day labor working under one Gopinath for last 4 years, and before that he had business. He deposed on 31/3/22. So, according to him, he had business before 2018. He could not show any paper of his business which he closed, or any paper to show his business place or any kind of business he had. He could not say the turnover of his business. He said that he never had paid income tax as his wife did not allow him to file income tax return. His story of having been a businessman appears to be a cock and bull story. It is difficult to digest. His written statement says that the petitioner put pressure upon the respondent to close his business as the petitioner made sufficient income for both of them and the child of the parties, and that in order to pay attention to his wife and son, the respondent suffered total loss in his business and he became unemployed. No businessman closes his business to pay attention to his wife and children at the instruction of his wife. No wife would ever advise to her husband to close his running business and be happy to live and maintain a penniless husband. It is ludicrous for the respondent to say that he did not pay income tax because his wife did not allow him to. Who told him not to pay tax before his marriage? A man having a taxable income may evade payment of tax by concealing his income, but that is different thing. It is not his case that he had taxable income. The story of his having been a businessman, have multiple business appears to be false. On his own evidence, the respondent is a day laborer and does not earn sufficient to maintain his family and educate his son. he made himself dependent on his wife. The allegations made by the petitioner that the respondent was successful in alluring the petitioner to the proposal of marriage, representing himself as a well-established person, having small family with multiple business, own house, shop, etc., and always tried to establish that the respondent was able to give a comfortable marital home for the petitioner as per her status, and was further able to convince that the present parent of the petitioner will not allow this marriage in view of his being only a graduate, and thus without any information to the parent and or relative of the petitioner registered the marriage before the above named marriage officer appeared to be probably true. Had the respondent been a businessman, he would have had voluminous documents in view that he was a prosperous businessman when he married the petitioner or before his marriage. The petitioner was a girl of immature mind when she completed MBBS course and doing internship at Calcutta Medical College and Hospital. There is no ground to disbelieve her that the respondent, who had no business or income sufficient to maintain a family, made a fool of her, disguised his real nature, business, and intention, and hoodwinked the gullible and unsuspecting petitioner into agreeing to his proposal of marriage, believing the respondent to be a man with multiple businesses, having own house and shop, and would give her a good life. In all probability, the respondent wanted to get rid of his indigence by deceiving the petitioner, who had a promising future as a doctor, into marriage by making her believe that he was sufficiently rich. It is in cross-examination the respondent that on the date of solemnization of marriage, no family member of the petitioner was present. The respondent could not say the source from which he got the telephone number of the petitioner. Obviously, the petitioner was dragged and a fraud was played on her to get her fall in love and agree to marriage. The consent of the petitioner was obtained on fraud practiced on her. This could be a good ground for annulment of marriage by decree of nullity on the detection of the fraud. But the petitioner continued the marriage, residing with the respondent beyond the period of limitation of 1 year from the date of detection of the fraud or the actual state of affairs. The said ground for avoiding marriage cannot be converted into a ground of cruelty. Fraud in obtaining consent to marriage and cruelty post-marriage are different things. The petitioner wants a peaceful life without any interference by the respondent in any manner. It is no doubt this is a case of an unfortunate mismatch of the parties, but for want of proper allegations and evidence of cruelty or adultery or desertion, it would not be possible to give any relief to the petitioner, and the suit is liable to be dismissed. There is a huge status gap between the parties. On hearing the parties, I am of the opinion that the petitioner was not happy residing with the respondent. Dismissal of the suit would not confer any right on the respondent to forcibly enter into the respondent residential quarters or premises of the petitioner, wherever she might be residing, or to force him on her or to annoy or disturb her in any manner.
Yeah, that was a very good, well-written judgment.
Yes, my lord.
Because the judge has distinguished nicely between fraud at the time of marriage, which you can condone, and cruelty. That
Yes.
Cruelty post-marriage.
Yes.
Absolutely right on this.
Yes. But at the same time, my lord, since
Because at the time of marriage, even if he hoodwinked you into believing something,
yes,
then also you condoned that and lived with him. So, and you have not taken out a nullity suit.
No.
On the ground of
Yes, in my evidence also said
really.
yes.
So court is absolutely correct on this.
Yes, but at the same time, it would since 2015 we are living separately. We means the relationship has been broken. There is a marital discord, and this has been irretrievably broken down. This cannot continue. Otherwise, this would amount to further cruelty upon me, and I would say upon both the parties.
You also rely on the same judgment.
Yes, yes, yes. Rakesh Raman and the.
You brought copies.
Yes, yes, yes.
Because in every judgment you keep the
Yes, yes, sir.
copies with the file.
Rakesh
If they go up, then those files, it will be available in the file.
This is Rakesh Raman, para 27.
Rinku Bhatti have you brought? No.
Yes, yes, yes. Both them.
আগেকার সব এটাও রিসিভ নেই, এটা অন্য কন্টেক্সট থাকে। Yes.
My humble submission in view of these judgments, I would be praying for this
Anything else, Mr. Adhikar? Yes.
But one thing I must say, Milord,
Yes.
after filing of this matrimonial suit, Milord, in the year 2021, Milord,
Hmm.
he has lodged a complaint against me, Milord, in Karshiang, and one 490-day case was pending, Milord, in 2021, Milord. And Milord, when he has filed that divorce petition, Milord, we live together, Milord. We live together. Milord, kindly come to my examination, Milord. That is at page, Milord, 43.
Yes.
Page 43. Milord, the relevant portion is, Milord, page 47, Milord. Page 47, Milord.
47, yes.
Para number 13, Milord.
Hmm.
That during the pendency of this suit, all on a sudden the petitioner requested me to come at her quarter over telephone, situated at Karshiang district, Darjeeling, West Bengal on 1/1/2020 and 1/1/2020. That is, we have celebrated our reunion in Hotel Amorjit, situated at Karshiang, along with our said son, and thereafter I have started residing at her official quarter situated at Karshiang in regular course and participating all household works with my wife, like shopping, marketing, refilling of cooking gas from Ashok Brother gas dealer, and we have jointly visited nearby park and hotel for amusement. We have exchanged clothes in between us for puja festival, and also for my said son during the said period. We have also intimated sexually for two to three occasions, and my wife also assured me that she would withdraw the said suit and resume our marital life, but unfortunately without any reasonable cause she again started behaving with me with adamant manner, and thereafter initiated a case against me and my old aged mother under section 406/34 of IPC. As a result, I have compelled to take shelter at Noya Bazar, Karshiang district, Darjeeling, at a night shelter organized and managed by local authority, so that I could meet with my son in regular course, Milord. I have also filed one application before your lordship, Milord, for the visitation rights also, Milord. And that still I am very much interested to resume my marital life with my wife, that is petitioner wife, with an intention to live happy marital life along with said son, particularly thinking about the future of the said son, Milord. Now, Milord, kindly come to
What is the age of the son now?
Milord, age of the son? 14. Milord, now, Milord, kindly come to my
Son is with the wife.
Son is with the wife, Milord.
You file any custody application in the trial court?
Yes, Milord.
What happened to that?
Milord, it is pending, Milord.
In the trial court?
Yes, Milord. It is
in this suit, you did not take out any application?
Yes, Milord, I filed. What
happened to that? We are asking you that.
Yes, Milord. I have.
Tell us what happened to that.
Milord, that visitation right was allowed.
All right.
That visitation right was allowed, Milord. That is, Milord, page 6 of the paper book, Milord.
No, need not. If you say, we'll accept that for the time being.
Yes. The petitioner shall bring her child on every date. Suit is fixed for hearing, and the respondent may exercise his visitation right in counselor's room for 1 hour at most, the presence of the counselor, Srimati Shukla Sen. Respondent shall not annoy and threaten the child. Our order of visitation is subject to further order after interacting with the child, Milord. That was allowed. Now, Milord, kindly come to, Milord, my cross-examination. Page 49, Milord.
Yes.
This
is examination chief.
Examination chief of DW. Milord, page 49, Milord, my cross-examination. Page 49, Milord. I'm sorry.
Page 49.
49.
49.
Oh,
middle.
All right.
Page 49.
Yes.
I am the respondent DW1 in this suit. Today I have filed affidavit of my examination in chief. This is my affidavit, which has been drafted and typed as per my instruction. I put signature on each page after going through the understanding it is concerned. Its content. Cross-examination. I was married in 2007. On the date of solemnization of registered marriage, no family member of the petitioner was present. I cannot say the source from which I got the telephone number of the petitioner before marriage. I cannot produce receipt of document of sale of gold ornaments of my mother for arranging rupees 4 lakh. My wife took loan 25 lakh jointly with me. I cannot produce today any document of utilization of the said loan of 25 lakhs taken as a loan for construction of house. The amount of loan was spent by my wife and me. I had no role in my wife shifting from Sharkrel to Karshiang. I know Mundira Ghosh through my wife, not a fact that Mundira Ghosh was with me in Coach Bihar and Bhutan, not a fact that I have developed illicit intimacy with Mundira Ghosh, not a fact that I had Mundira resided in separated room. My wife did not subject me to cruelty, any physical or mental. I cannot say the date or month or year I resided with my wife. I have no document to show that with my wife requested me over telephone to come with to her quarter in Karshiang on 1/1/2020. Not a fact that no such request was made, or I did not celebrate reunion with my wife in Hotel Amarjit along with her son, or that I made false statement in my affidavit. Not a fact that I did not start residing at the official quarters at Karshiang in regular course. I had no quarrels or dispute with my wife. To quote, I work as labor in Karshiang. I am a history BA honors. I am produce papers of my educational qualification. I earn 300 per day as daily labor. I work under Gopinath. I cannot produce paper. I am working under Gopinath for last 4 months. I work on no work, no pay basis. I went to Karshiang first 2015 with my wife. At that time, I did not find any job in Karshiang. Before working as day labor, I had business. I cannot say the turnover my business. I had never paid income tax. I never filed income tax return. My wife did not allow me to file the income tax return. I know that 1,20,000 is being spent by my wife per year for education of my son, my lord.
Why are you placing this?
My lord, what happened, my lord?
To show what?
Because, my lord,
Your cross-examination, we are meaning.
yes, my lord. Cross-examination, because why I am pressing, my lord? It is the welfare of the child, my lord. We took the son at Karshiang, my lord. Because, my lord, we both were consented to that we will study our son at Gothel school. And, my lord, thereafter, my lord, the 2020, after filing of the matrimonial suit, my lord, we lived together. We lived together, my lord. And 2021, my lord, they filed 498 proceeding against me, my lord. And, my lord, I am ready to stay with my wife, my lord. Now, my lord, kindly come to the judgment, my lord. Impugn judgment, my lord. I want to place the issue portion, my lord. I want to place the issue portion, my lord. That is very vital. Page 57, my lord. Issue number 1 is
57, yes.
Yes, my lord. Issue number 1, maintainability, my lord. I think I don't want to place it. Issue number 2, adultery. Under the matrimonial law governing the parties, adultery is an offense against the marriage, and one single act of adultery is enough for grant of divorce to the aggrieved spouse. The burden of proof is on the petitioner, and she must prove it beyond reasonable doubt. Proof beyond reasonable doubt means such proof as precludes every reasonable hypothesis except that which tends to support it. It need not reach certainly, but must carry a high degree of probability. Evidence of opportunities alone is not enough. In para 7 of the petition, the petitioner states that the respondent developed illicit intimacy with a married woman and used to chat with her in her presence, and looking at the chat, she believed that the respondent has voluntarily illicit intercourse with the lady. The details of the chat has not been disclosed in the plaint. Without knowing the contents of this chat, cannot express any opinion on it. In para 8, petitioner states that the respondent invited that lady and they went for family tour to Coach Bihar at North Bengal. There is no explanation as to why, after knowing such chats which raised certainty in her mind about adulterous relationship of her husband, she agreed to go to the tour with her family with that lady. In cross-examination, petitioner said that she viewed her husband in a separate room with that lady. The petitioner did not state this fact in her plaint. This appears to be clearly an afterthought. Further, viewing the husband with another lady is not an adultery. The allegation of adultery has not been made properly, making the other lady a co-respondent, or at least serving her a copy of the plaint to enable her to intervene if so desired. The petitioner did not state the date or period during which she discovered that her husband committed adultery. In para 8, the petitioner says that she is an educated person and is not inclined to name and malign of the reputation of the lady concerned. Under Rule 340A, subsection 10 of the Civil Rules and Order of the Calcutta High Court, relating to Special Marriage Act 1954, it is mandatory for petitioner in every petition for divorce on the ground of adultery to implead the alleged adulterer co-respondent, which he has not done. And this lady was never come up for evidence also. The petitioner is well aware the name and identity of the women with whom her husband allegedly committed adultery. The ground of adultery must fail for non-joinder of necessary party and particulars of the act with specific date, time, place. The petitioner did not bring on record documentary evidence of such family tour. The evidence on charge of adultery is very weak and uncorroborated in material particulars. It must fail on the ground also. Issue is decided by finding the petitioner failed to prove that the respondent committed adultery, my lord. Now, my lord, the cruelty. No precise definition of cruelty exists, nor it is possible to do so. Acts or conduct constituting cruelty can be so numerous and varied that it would be impossible to fit them into any watertight compartments. Cruelty may be subtle or brutal. It may be physical or mental. It may be words, gestures, or by silence. Cruelty is conduct of such a character as to have caused danger to life, limb, or health, bodily or mental, or as to give rise to a reasonable apprehension of such danger. I have thoroughly gone through the plain. There is absolutely no allegation or acts amount to cruelty. The petitioner ought to have started acts of cruelty, physical or mental, for the court to judge whether those acts could be termed matrimonial cruelty or not. Abusing the petitioner in presence of her colleagues is cruelty, but particulars of such acts have not been stated. Petitioner did not say that terms of abuse and the names of her colleagues in whose presence she was abused. It is not written, my lord, also in plain. She did not examine any of her colleagues in whose presence she alleges that she was abused by respondent. In para 5, the petitioner says that she took a loan of 23 lakh for construction of single-storied house, but the respondent siphoned a huge amount, leaving the petitioner to burden the payment of EMI. This allegation is without any particulars of amount siphoned by the respondent and which date and other particulars. Merely saying huge amount does not mean anything. The petitioner has not stated or did not produce any document to show that the respondent took her loan money without her consent, if at all he took. Further, how the respondent took money, including salary, from her, that is the manner of taking it, also not stated. The respondent denied the allegation. There is no allegation that the respondent committed theft and breach of trust of money entrusted to his care and amount of money entrusted. General allegations of misappropriation of funds of the petitioner by her husband is no allegation. There is no allegation that the respondent abused her in filthy language or used to beat her. Merely using the word abused is no allegation of abuse. The acts of cruelty and words of abuse must be stated in the plaint with reference to a period of time if precise dates are not possible to be stated for lapse of memory. Experience shows that it is seldom that a wife forgets any serious acts of cruelty of her husband against her. She generally remembers the occasion and the period of time when it occurred and how she coped with it. PW2 is a sister of the petitioner, my lord. She came for the cross-examination. In cross-examination, she said that she could not say the date since the parties were residing separately. She did not witness any act of cruelty and she came to know all incident regarding to parties from 2018. Interestingly, the suit was filed in the year 2018. She personally did not witness any ill treatment as per her cross-examination. Her evidence is not direct. Petitioner did not examine any other witness to prove that the petitioner was ill-treated or subjected to cruelty by the respondent. This is the evidence on record. Suffice it to say that the petitioner failed to allege and prove that she was subjected to cruelty, physical or mental. Issue is disposed of accordingly. Issue number 4, desertion. Para 10 of the petitioner says that the parties are residing separately since 2015. Since the posting of the petitioner as subdivisional hospital at Karshiang, the petitioner is a medical officer. In the year 2010, she became permanent BMOH at Malda Bamungola Rural Hospital, and in 2011, she joins West Bengal Health Service. She was transferred from Margram PHC and posted at PHC Haji Street, Molla BPHC in Sakrel as medical authorities. From Margram, she was transferred to Karshiang. She resided government quarters at Karshiang and still residing there. This is absolutely no case of desertion of the petitioner by the respondent. It is not a case that both of them were residing at Karshiang from where the respondent deserted her with intention never to visit her. In fact, that status of the respondent, who is a day laborer living from hand to mouth, shows that he would be the last person to desert his petitioner wife, who is having a social status and making sufficiently good income as a government doctor. The written statement shows that the respondent willingly wanted to live as a dependent on the petitioner. The ground of desertion is not true. The issue is economic. Therefore, the issue have taken the trial court that adultery, cruelty, and desertion all failed. All failed, Milord. And now kindly come to the cross-examination of the petitioner, Milord. 63. English. কোনটা আছে আমাকে দেখা জাজমেন্টটা করছিস ও যা kindly come to page cross to 37 38 minutes.
Yes.
Only 2 documents were exhibited, the Aadhaar card and certified copy of the marriage certificate. These 2 documents were exhibited. Page 38. May I read the information? My marriage was solemnized following love affairs. No social marriage was solemnized. On the date of my marriage in 2007, I had joined as house staff ship after internship as Medical College, Kolkata. In the year 2004, I received a phone call from an unknown number, which later I came to know it was of the respondent. At present, I am posted in Karshiang Subdivisional Hospital as medical officer as block medical level. I am not BMOH at present, This is transfer, Today, I have come to court on leave. I had applied for leave. I can obtain certified copy of the leave application. I can produce it later. After I went to matrimonial home, after my marriage, I came to know that the respondent was not an established businessman having several business his own house. I did not immediately file the suit for divorce as I married against my wishes of parents, and I wanted to give a trial to the marriage, forgetting what had happened. I wanted to give a trial to the marriage, forgetting whatever had happened. I did not make any complaint against the respondent relating to allegation that I was unable to establish relationship with my family members under undue influence and pressure from the respondent. Landed property stated in para 8 of my affidavit is in the joint name of myself and my husband. I applied for taking a house building loan from construction of houses. Loan was disbursed in 2017. First, rupees 18 lakhs was taken as loan. Then, as construction was incomplete, I took further loan of 7 lakhs. I took two loans. I cannot recollect the loan account number. Loan was taken from State Bank of India, Bauria branch. I took loan on my responsibility. Not a fact that the statement, that is not a fact that the statement made by the para 9 are wholly false. My husband developed illicit intimacy on Mundira. This she was never came before the court. Never. A resident of Nohiati. I don't know full address of the lady. I have not met the said lady party in the suit. My affidavit in chief has been prepared by my lawyer. I cannot recollect the date of filing affidavit of my examination. I cannot recollect the date of notarizing affidavit of examination in chief. I was on leave. If the duty register of the leave is, I came to know about the illicit intimacy conclusively when the OP took the said lady in our family trip as stated in paragraph 10. I came to know the intimacy when I found that they were found in a separate room. I did not make any complaint against the respondent seeing intimacy, my lord. Not a fact. The statement made in paragraph 10 is false, or I have made statement to humiliate the respondent. Now, my lord, I must say, my lord, these are the baseless allegations, my lord, which raised against me, my lord, for obtaining a divorce. I wanted to stay with my husband. I wanted to stay with my wife, my lord. I want to look after my son. And still now I want to I want to take the responsibility of my wife and my son, my lord.
How?
My lord, I will, my lord. I will, my lord.
You earn 300 per day.
My lord, that is the past issue, my lord. Now I am in a job. I am having a job, my lord, in Karsiang, my lord. Now my
Job is also for daily labor.
Daily labor at that point of time, my lord.
What is your job in Karsiang? There is nothing on record.
My lord,
You did not bring forward any document like
Lord,
they brought order of attorney.
my lord, I will bring, my lord, the document.
How?
my
After
lord.
hearing you? No.
Yes, my lord. My lord, I am doing a business, my lord. Now I am doing a
You
business.
just failed to produce anything to show that you have made untrue statements which have been held by the court to be untrue.
Yes, my lord.
How can
That was because, my lord, under
what would be the use of
my lord, I left my job.
what would be the use of keeping the marriage an unhappy marriage, a mismatch pending?
My lord, one thing I must say, my lord, in 498 proceeding, the wife stated that the same allegation I brought in my 498. Even the wife knows, my lord, how can she maintain this matrimonial suit, my lord?
We don't understand.
What my lord, in 498 proceeding, my lord, what in 498 proceeding, the wife himself stated that, my lord, at present I have filed an appeal in respect of this said dismissal of the suit. It is a fact that I have made the same allegation in this case, which allegation I made in mat suit 2006 or 2018. The same allegation.
Obviously.
In 498 proceeding, also same allegation which is there.
Must be.
But, my lord, I still want to stay with my wife and my son, my lord. And, my lord, the issues which they have raised, my lord, is not tenable. Each and every issues have failed, my lord. Each and every issues. Even prior to her marriage, she knows everything, my lord. She knows everything, and, my lord, she himself stated, I give a trial. I want to give a trial.
Give a trial. Past tense.
Give a trial, my lord. That is the issue.
No, we are not holding you guilty for having suppressed because as a trial court, as we expressed our mind to Mr. Odhikari also, that that cannot be a ground because she did not file a suit for nullity on suppression by fraud.
Yes,
that was never brought by her. She condoned that suppression. It's obvious.
Cruelty, not proved. Desertion, not proved.
Boils down to irretrievable breakdown now.
Adultery, not proved.
You say it's not irretrievable breakdown because it has to be from both sides.
Irretrievable
Breakdown has to be from both
yes,
sides. You are fully willing and
yes.
Even after this,
I am ready to give undertaking before your lordship. I am willing to stay with my.
I'm not asking to us, but you have stated in your evidence that even after this suit in 2020, he went there to Karsiang. You went there to Karsiang. She has stated.
No.
No.
Quick response to that.
Yes,
Quick response to that.
yes,
in
yes,
paragraph.
No, you will come to you.
Yes, sir.
We have not completed
Yes.
hearing him.
Sorry.
My wife requested me page 50, my lord.
Yes.
Page 47, my lord, in my cross-examination, I have stated, my lord, that paragraph 13, my lord, that during the pendency of this suit, all on a sudden petitioner requested me to come to her at her quarter over telephone situated at Karshiang, district Darjeeling, West Bengal on Ato. On 1/1/2020, we have celebrated our reunion in Hotel Omorjit, situated at Karshiang, along with our said son. And thereafter, I have started residing at her official quarter, situated at Karshiang, in regular course and participating all household works with my wife, like shopping, marketing.
But you have
retailing.
produced nothing during your evidence to show that you are now working in Karshiang.
Milord, I have
or you are
made
there.
that is why, Milord, she had lodged a complaint against me.
No, but
Against me and my
so
mother.
you said that now you're in Karshiang, you are not a daily labor. Please come to page 50. You
50.
say to court, yes, page 50.
Yes, ma'am.
I work to court, middle of that page.
Yes, madam.
I work in
labor.
present tense as labor in Karshiang.
Labor in Karshiang.
I am history BA honors. You did not produce any document regarding that. You say in present tense, I earn rupees 300 per day as day labor. Therefore, you are in Karshiang as a day labor, you earn rupees 300. Work under one government. So you are doing that in Karshiang only. That was your admission.
Yes, Milord. But Milord,
You have never stated that you are in business in Karshiang. Now,
Milord, I left my business.
you told us that
I
he is
left
now
my
in a
business.
job, now in some job. Even during evidence, you said that at that point of time also you were in Karshiang only as a day labor and you were earning rupees 300 under one Gopinath.
Now I am doing a marketing
That is
job,
entirely
Milord.
coming from the bar. There is
Yes,
nothing
Milord.
on
I
record.
was doing the marketing job at that point of time, Milord.
At that point of time, it's your evidence. You say this evidence is dated 31st of March 2022. There is not an iota of anything. No pleadings, nothing. No amendment sought, nothing. Even in 2022, you are working as day labor in Karshiang only. 300 rupees. It's an utter mismatch. Although we are not in a position to judge because she chose you.
Yes, Milord.
And she agreed to stay with you, and
Yes,
it's her admission that she wanted to give a try to the marriage.
Yes, Milord.
Just because she now does not want, she cannot discard you. We agree with you on that.
Yes, Milord.
But whether this marriage is at all workable, there is nothing to show, nothing, no evidence, not a piece of evidence. If you had been living in Karshiang with her, should have brought forward some evidence, have yourself recalled as a witness, some document to show that you are in Karshiang. Something, your train ticket, your whatever, that you purchase something in Karshiang, nothing. Absolutely nothing.
Milord, I can.
Even if you
I can bring
buy
the rent receipt.
an
I can bring the rent receipt.
exercise book or even,
Yes, Milord. I have.
even a paper from a shop, stationery shop in Karshiang, you can have a receipt. Could have produced that before the court. Nothing to show that you are residing there regularly. Rent receipt, nothing was produced. Nothing.
After
You say
filing
you are
of the-
residing in-
after filing of the 498 proceeding, Milord, I live separately in Karshiang, Milord. I have that document, Milord. But Milord,
You are not residing together since long. You have not produced any.
2021, Milord,
At
actually
least
the
after
date.
filing of the suit.
After filing of the suit, Milord, they have filed the 498 proceeding.
No, after filing of the suit also you stayed with her. There is nothing on record to show that. Nothing on record. It was a consistent case in your defense. You said you filed in the suit only. After filing of the suit only, you filed the written statement, obviously.
Yes,
And you adduced your evidence, everything after filing of the suit.
Exactly.
He did not bring a single piece of paper before the court, nothing, no other corroborative witness to show that you are still residing in Karshiang. Not a single witness. Did anybody corroborate you? You are the sole witness for you.
Sole witness.
So there is no corroboration by either documents or by oral evidence that you are, after filing of the suit, you have been residing in Karshiang. Nothing of that sort. And you admit that you are still in 2022, you admit that you are a day labor under one Gopinath. 300 rupees.
2025 was, Milord, I'm saying.
So now you are saying you are willing to take responsibility. We are not confident of that. Suit was filed in 2018. We are in 2025 now. 7 years. Now 7 years you are not together. You have not brought anything to show that you are living with her in Karshiang. Never, nothing. Omorjit hotel or whatever.
That
nothing.
I cannot develop, Milord. Now, Milord, I cannot
No,
develop.
you cannot
Yes,
develop.
Milord.
We are not speaking about you.
Yes, Milord.
You are doing your level best and you are doing very well also.
Milord, what has happened, Milord? The issues, Milord, on the ground of.
See, these
the
judgments
plain,
are
Milord.
coming not because it's a whim of court just to break a marriage. We don't derive fun out of it. Not that. Not at any point of time. But we have to see the ground realities which we are looking from this side. After taking up so many matters and so regularly we are taking up, you are dealing with a case. You are also taking up so many matters, all of you. But we see the pragmatic ground realities. For these only these judgments are coming. None of the courts had fun in getting a divorce decree, getting a sadistic pleasure in breaking a marriage. None of us do that. You are parties, you chose your marriage, you chose your partners, you have been living together. And moreover, you have got a 14-year-old son, which is also a consideration, undoubtedly. But what is the son getting for the last 7 years after filing of the marriage? He is residing with his mother. You are admittedly a daily labor till 2022. So he probably has nothing. Visitation right is something else. Father has a right to visit. We agree with that. But regarding this marriage, what remains? Why should the son come in as a consideration here? The son did not have did not ever see,
Your
son did not see the family together. I mean, he is in a broken family from the beginning.
he saw everything, Miller. The son knows everything, Miller. Now she manipulated my son, Miller. Now she completely manipulated my son.
You don't know how difficult it is to manipulate a 14-year-old.
Miller, now, Miller, what has happened?
They will manipulate you.
Even in the London trial court, Miller, the SCGM court, Miller, asked to bring the child, Miller. She did not bring the child, Miller. She did not. And Miller,
That's
I gave
usual in
the
matrimonial
exercise book, color pencil, pen, books, etc., etc.
We are being very candid. We are not castigating you for your poverty. Someone's marriage should not be, that would be very cruel. I mean, it would be against all norms of human society. Just because I am poor, my marriage should be broken? Definitely not. We are not saying that at any point of time. Whether the marriage is workable, that is what we are thinking because of the mismatch. We would say the same thing if you are rich and she was poor. We would say the same thing. She sought, being a poor lady, she sought for a divorce and you are a rich man. We would say the same thing. The mismatch is what we are thinking about. And this mismatch is continuing. Initially, she tried, gave it a chance. She admits that. That's why the marriage persisted for so long. When it did not work out, she has filed a divorce suit.
And we both were consented to that our child will study at Kaxiang.
That is disputed. That is a disputed position. You have not said that. You have admitted that you had no hand in the child going to Kaxiang. Not the child, the wife. I will just tell you that.
Miller, 1 year after.
We'll just tell you from where we are. Sorry.
No, that
You
সে তো ঠিক আছে, সেটা তো জিজ্ঞেস করছে না, একটা ডকুমেন্ট একটা হবে।
somewhere here. In your evidence, probably cannot say the person.
Page 49.
Yes, please come to page 49.
49. Yes, ma'am.
You have been repeatedly saying that it was a joint decision so that the son has a good education. But just say about 6-7 lines from the bottom, page 49. I had no role in my wife shifting from Sakrail to Karsian. It was her transfer, you also said to us.
Transfer.
It has been going on. So you are now saying that it was a joint decision of both the parties that your son will have a good future. So he will have an education in Karsiang. You say you have nothing to do with her going to Karsiang. So how can it be a joint decision by you so that your son gets a good education in Karsiang?
Joint decision.
And if in Karsiang, why not in Calcutta or Howrah?
The Karsiang, Miller, it was a transfer posting, Miller.
Yes, so therefore you did not have there was never any joint decision by both of you for the benefit of your son. We don't see anything joint between you. Everything is broken between you.
If my son resides here and studies in Howrah, Miller, that will be difficult for us to look after our son, Miller. That is why we took our
But you had no role to play in that. Wife shifted to Karsiang, child from the day the marriage suit was filed, the matrimonial suit, son is with the mother.
Son with the mother, and I also used to visit with my wife.
That's
and
disputed.
Son,
That's disputed. You have produced nothing to show, not even anything.
They have also even they have also made allegation, but they have also not proved.
They cannot prove a negative fact. They cannot show that you had not gone. You had to show it's your positive assertion. Negative fact cannot be proved.
But they have leveled allegation against me that I did not take care of my
Yes,
son
it was the moment she said that on oath, it was your duty to show that no, I went there, I had resided there. If you are residing there, you say you are running a business there.
Difficulty I am facing it now, Miller.
But not a single document you laid evidence at a time when you were in Karsiang. And you admit that I am now doing a daily labor as a daily labor.
I'm still now in
But you have
Calcutta.
not produced a single document to show that you are paying rent, as you said, either paying rent or that you are doing something there. Some receipt, something to show that you have been in
Difficulty
Calcutta.
is that, Milord, I cannot develop the evidence at this stage.
That
Milord.
is where we are saying that the marriage seems to have broken irretrievably. You obviously want her to remain with you.
Exactly.
The difficulty is one other difficulty we are also finding that in Special Marriage Act, husband cannot claim alimony.
No,
No, we are being very serious. It's our gender bias that only wives claim alimony. It's absolutely gender bias. Hindu Marriage Act is more progressive on that. Now here the language is different. And it's,
would have, uh,
so no, we are
made an
seriously
application
thinking
even
this.
at the earlier stage. I don't want to, Milord, but I want my son.
That's
my
because of your
wife-
male prejudice.
Milord, I
For
want
no other
my
reason.
son and
Which all of us have. It's
Yes.
good to have prejudice, male prejudice,
Yes,
masculinity.
yes.
Men will have masculinity, females will have femininity. No difficulty in that. But the law is very neutral gender, Hindu law. That is the difficulty for you in this. Your marriage was under Special Marriage Act.
Special Marriage Act. But
On the application of the wife only. So
I
we cannot
still
also give you that relief. That is the difficulty.
that relief, Milord,
You have been living on her income. You should admit that. You have admitted that. If you are a day labor with 300 rupees, either you are living on that or you have been living during your marriage, throughout your marriage. All along you have said, I had a business. I never had a business. You never had a business during the marriage. So it's obvious how the son was brought up.
during the marriage, Milord, but prior to marriage, I had a business, but
Prior to marriage, you might have. What we are saying is that you are totally dependent on your wife. Therefore, regarding this irretrievable breakdown, we are only hesitant on two counts: 14-year-old son, and you are not having an income of your own.
I will make myself better now, Milord. Now I am.
Make yourself better without the wife.
No, Milord, that
Make yourself. You will be much better off without her.
I still want to, Milord, stay
You
with
cannot
my-
make an unwilling horse drink water
Yes,
from
Milord.
the pond.
My lord, may
But Milord, what has
We'll
happened
continue
is-
after this. Think
may
something
I
else.
file my affidavits means
No,
to
no,
their
I'm sorry, Milord.
can
Keep
application.
it with you for
My
the time. Just before rising, don't file anything
My-
before
my-
any court.
my-
When you come back, we'll consider and then permit.
My-
We'll
Grateful.
continue after this.
Grateful.
আপনি শুনুন একটু।
Before you leave for mentioning a matter, Lordship,
This or no?
Lordship, I apologize. I have mentioned earlier this morning, but I couldn't actually, for my fault, I couldn't mention it.
No, not now, not now. We are in the midst of a matter. Yes.
Was checking the documents whether I filed any documents or not before the trial court law.
Okay.
Here,
Yes, what else?
We can.
So you say you have intention to live together
yes,
and you have been going to Korshiang also.
may I claim one thing? Just for a last chance, can it be sent?
No.
Just for a last resort.
Mediation, was it sent to mediation?
No, it was
No, no,
Mediation, you can't understand if both parties don't agree.
no. It was
Mediation, Mr. Adhikari, may also be that you live apart.
not.
No, no.
Fail হয়েছে. There was a failure of
কোথায়
mediation.
mediation হয়নি?
My lord, may I check that?
But we are in the midst of argument now. I don't think it will be prudent. We have already heard him. You are in the midst of argument. You have already almost completed. So let us
May I
conclude
clear
whatever.
some judgment bill on the next date?
No, 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 no next date. This is appearing as a part-heard matter. Part-heard matters we don't grant content.
One judgment minute I was going through minute where minute the appellant has been pointed out that 17 years of irretrievable breakdown of marriage minute that was turned down minute and the
What is the judgment? Your citation.
minute I have the soft copy minute in my phone.
Now these are the latest judgments holding the field. You give us a citation at least.
2024 minute judgment minute Telangana High Court judgment minute.
Telling a Supreme Court
Yes.
judgments that the Telangana High Court won't bind us.
Irretrievable breakdown of marriage minute I strongly.
Now it's very clear this judge Rakesh Raman is there.
Yes, minute Rakesh Raman judgment.
Rakesh Raman there, Justice Nagaratna dealt with it subsequently, but did not hold it to be bad law. Rakesh Raman, if you come to the relevant probably paragraph 26 or something like that. Not 26.
27 minute we have a
27.
27 minute. We have a married couple before us who have barely stayed.
If you come to the
together
last sentence, long separation and absence of cohabitation,
Yes,
completed on meaningful bonds, and the
25
existing
years,
bitterness has to be read as cruelty.
Yes, ma'am.
So that becomes cruelty. And
But the long gap of 25 years here only 7 years.
so the number of years is not.
Even 2020 we stayed together.
You have not able to prove anything regarding that. Sorry.
Stayed
There's
together.
not a single document to show that you had lived since 2020.
No, দর্শক তো সেটাই বলছে যে has there been any documents to show believe that is not at this stage Milord, I cannot bring also Milord the documents Milord.
Nothing. We're in the middle of hearing. How can you?
Yes, Milord, yes,
You just let us conclude the hearing and we'll consider.
My
Yes.
contention is that Milord the
You say they have failed to prove their case
yes,
totally,
yes Milord.
which
On
is
that ground Milord
which is
the-
correct apparently from the judgment also.
Yes, Milord.
And you say you intend to live together. So just because one side does not want to live, you cannot say irretrievable breakdown also. So it has not irretrievably broken down because you are still agreeable to live with her, and it's your case that you lived subsequently also during the.
Yes, Milord. It's my case also Milord. I live subsequently. But this is the main point.
Let us hear the reply.
A short reply, my lord. In respect of the allegation that in 2020, after filing of the matrimonial suit, he stayed together in page 47, which he has alleged
Yes.
in his para 47, in page 47, page 49 in his cross. My lord, kindly see the last line. Nothing else I want to show. Last line. Page 49, last line.
Yes.
I cannot say the date or month or year I last resided with my wife. How can he say that he resided together? He himself admitted.
Okay.
Why the accept my state?
My contention, for the last 10 years, we are living separately, no cohabitation, nothing. And after the suit, there is no chance. It is evident from the records. And lastly, my lord, here I would place the affidavits. Miss, we have filed in the we want to file the counter affidavits in respect of the vegetation, right? Though we do not have, I have taken
Vegetation, we are not
we do not
taking
have any difficulty. We do not have any
No,
objection.
Visitation we can.
Yes, yes. May I file those?
What is the visitation they are seeking?
May I file that?
Yes, file it.
Para
This can see.
Can 3 is my application.
Opposition to that.
Can see already.
Can 3 is my application.
Can
আমাদের
এটা এখানে উপরেই যাবে।
The right of the petitioner being the father to have access and visitation to his only son, to be considered as a prime consideration that the petitioner being a father of the said child should be allowed to pay a visit and meet his son at least for a day in a week. The day.
You have no objection to this.
We do not have any objection, at least in a weekend in a public place. That is my.
We'll think about that. So this is the CAN 3 composited board.
Yeah, to their plain case, they have completely failed, Miller, to prove.
And what about this? What your learned friend has argued that you have failed completely to prove your plain case. You have made several serious allegations. But just because you don't want to live, why should the marriage be broken?
My lord,
There
in
is no
that respect,
irretrievable
may I,
breakdown for both sides.
is my in that regard, I would rely D. Bhagat versus B. Bhagat, para 16.
But it's a new judgment you're relying on. We'll get a chance of reply to this. So just put a specific question to him. Because it's your, it has come up from his argument that he is fully willing to live with you. The Rakesh Raman says where there is irretrievable breakdown of the marriage between the parties, then. So why shouldn't we say that there is no irretrievable breakdown of marriage? It cannot be one-sided. One party, then there will be no sanctity to these matrimonial laws. One can get a divorce just by saying that it has broken down. You cannot take advantage of your own wrong also.
I'm not.
Don't live with him.
No, I'm not.
To live with him.
No.
You. So side Divaghat on that.
Para 16.
I want the citation to him.
I'm giving a copy.
Give a copy, yes. Para 16, let us read together.
Yes,
you and us.
1994 judgment.
No, even then, the Bibhagat, all the judgments have been considered probably.
Yes, yes.
16, yes.
Para 16. May I read it up?
Yes.
Mental cruelty in section 13(1) IA can broadly be defined as that conduct which inflicts upon the other party such mental pain and suffering as would make it not possible for that party to live with the other. In other words, mental cruelty must be of such a nature that the parties cannot reasonably be expected to live together, which the learned trial court has observed. The situation must be such that the wrong party cannot reasonably be asked to put up with such conduct and continue to live with the other party. It is not necessary to prove that the mental cruelty is such as to cause injury to the health of the petitioner. While arriving at such conclusion, regard must be had to the social status, educational level of the parties, the society they move in, the possibility or otherwise of the parties ever living together, in case they are already living apart, and all other relevant facts and circumstances which it is neither possible nor desirable to set out exhaustively. Parties' cruelty in one case may not amount to cruelty in another case. It is a matter to be determined in each case, having regard to the facts and circumstances of that case.
But here you have failed to prove cruelty. What is the cruelty?
Grateful.
My lord,
for this there has to be some cruelty on his part. You have failed on all counts.
No, the cruelty,
desertion, adultery.
Desertion, adultery, let us forget.
Cruelty.
Adultery, even he too, as Mr. Udhikari rightly pointed out, adultery was formulated by the trial court. It was not one stray sentence that it made him assume
Yes.
that they had illicit
Yes,
intercourse.
yes, yes, yes.
But that is not even an proper allegation.
She brought that allegation in her plain case, my lord.
In a plain case,
Yes, my lord.
that allegation, at best, he can put it within the bracket of cruelty.
Yes.
That he
And-
was having an affair with this lady.
Yes.
At best, adultery is having sexual intercourse. He
Yes.
has utterly failed to prove even the date, time, particular, nothing.
And desertion also, and with
No,
regard to
we are
cruelty,
taking
my lord, he
taking
also
that
failed.
allegation of his allegation of illicit relation within the scope of cruelty. So it can come within the bracket of cruelty
Yes.
on your part.
Yes, sir.
If you had an illicit relation, then it could be cruelty at best.
At best.
But he has failed to prove
Yes, my
apparently. That we have seen. Yes.
In respect of the cruelty, my lord, first of all,
Money
kindly
they were
consider the loan amount that they have taken. Kindly allow me. The loan amount which had been taken. It is evident from the evidence of the cross-examination of the respondent.
He says you both of you took together.
Jointly taken, but he cannot say he is using that money. That money was used for construction of house in my matrimonial
There
residence.
is nothing on
He
record.
said that in my cross that I cannot give any account how I used that money.
In the
My look, may I show that? Page 49 again.
Neither could you show that he had that loan was taken only for him. You have taken it jointly.
No,
How did you establish that it was used by him only?
it was the loan amount was taken for construction of the houses, and he was
A
residing.
single document on that he has constructed house or anything of that.
He is
property stood
No, please take your seat. Take your seat.
my lord, the property. It is the exhibit, my lord. The
In
document,
her name.
yes, my lord, document.
What does it say?
My lord, the Tanmoy Devnath, Srimati Mondal,
Both
Shoma
your
Mondal,
names.
both them. Yes, my lord.
Take your seat.
that I am not disputing. That is in my evidence also. That it is both in my EMI I am paying. The construction that is one part of it. Yeah, that is one part, and the other part
As you
is
said, poverty cannot be cruelty.
no, poverty cannot be cruelty,
I'm
but
poor, that's why it's cruelty to my wife.
that also
You no, to take your seat, both of you. Any moment you'll jump this side.
No.
And you're tall, you can do that. Yes.
my lord, since 2015, what was the purpose of
See,
his?
he is a poor person. You are a doctor, established doctor.
Yes,
You knew this when you entered into a relationship. Your evidence says that you gave the marriage a chance.
yes,
And you tried to live together and you did not complain against that.
yes.
So that chapter is a bygone chapter. You,
Yes.
you
I'm not entering into that.
Yes.
I bow down. I'll not enter into that.
No.
In respect of the evidence that I was
Therefore,
that was
he's
not.
using the money and all these things. These are
Yes,
not borne out
these
by
are
the record.
these are one of the.
They have
parts.
been using.
Yes, they have been using. Lastly,
If a wife can use the income of her husband,
yes.
why can't a husband use the income of her wife?
But if
he earns less than the wife.
Yes, my
Can
lord.
be that
That corollary can be brought, my lord, subject to correction. If wife is residing with the husband, residing together, taking care of the family, in that scenario, this happens. There is no problem. But the husband, if only comes once in a month or twice in a week, just to take the money, for what purpose?
Just to take the money, we can't. Don't.
Yes, that cannot be
Your
done.
allegation
And
that's
in
coming from the
respect of the in respect of the abuse or the harassment done in front of the colleagues, which I
fully failed.
no, not failed. It was not taken up. It was not taken up. Page 7 of my application.
So we can then, if we allow the order for Rule 27,
Then it should be remanded back.
Should we
I would be relying.
For the rest of your life,
Yes,
you're
yes,
with
yes,
your
that-
husband. You'll
but
be very happy with that.
But irretrievable breakdown of marriage, or I'm relying on those two judgments, living separately for the last 10 years, and he could not establish that at 2020 I was residing with.
But order for Rule 27, actually, we should, here it's very difficult to take evidence and all.
Yes, it is not.
Then we'll have to remand it for that limited purpose, keeping the appeal pending.
Kindly consider these two judgments of Rakesh Raman and this. And that judgment, if considered, my lord, we are living separately for the last 10 years. There is an observation of the learned trial court that there is a complete mismatch. And they cannot force upon each other.
We'll reserve judge. Yes, what is your answer to V Bhagat?
Irretrievable breakdown of marriage, that is, I am not on that. If I am agreeable with that, my lord, then irretrievable breakdown of marriage
Cannot happen.
yes, my lord. Now, my lord, in this case, my lord, what is her allegation? My lord, all are allegations: cruelty, desertion, adultery, I left it. But the cruelty, my lord, completely failed, my lord. Not a single document, not a single averment, not a single pleading is there, my lord, to prove that I have committed cruelty against her.
No, pleading is there. Sorry. pleading is.
Not proved.
Pleading is there, but
Pleading is there, but
He
not
said
proved, my lord.
pleading is
And
not
even
here.
and even my lord,
I'm sorry.
and even my lord, her own sister says, my lord, I cannot say that whether the cruelty, the husband made any kind of cruelty, any kind of abusive language on his wife.
sister
and-
decided with her. Sister, how can the sister say in it?
My lord, the sister, my lord, even my lord, nowadays, my lord,
Even
we
if
can,
sister says it
Lord,
will be hearsay.
my lord, what is in nowadays, my
Nowadays,
lord,
what
whatever
happens?
happens in in-laws house, all such of news will be shared by the
News may be shared, but then even then, if the sister said that I know, that would be hearsay. If she is not present, that
But
we would
but
in
the
any
wife,
event discard.
but when the wife herself fails to prove it, that is the best evidence, I am the best evidence. Others are corroborated. Now I am the best evidence,
We'll reserve judgment on this.
Milord,
sir.
grateful, I am grateful.
I think on
Milord,
this.
Milord,
This is not a
the,
straight jacket one where we can.
Milord, the affidavit in reply, Milord, they have filed the opposition against my application. The kind 3, Milord, this is the reply.
The affidavits in opposition and reply with regard to can 2 of
Milord, can 3, Milord, can 3.
Can 3.
no can 2 also they have filed a reply.
Yes, we have can 2.
Yes.
In respect of can 2 of 2022, an application under order for 27 of the Code of Civil Procedure and can 3 of 2024, an application for visitation rights filed by the respondent husband, be kept on record, full stop. Heard learned counsel for the parties at length, full stop. And the matter is reserved for judgment. The appeal along with the applications are reserved for judgment.
Grateful. Grateful.
আচ্ছা একটু চিন্তা করা দরকার আছে। এক কথায় এই জাজমেন্টের সঙ্গেটা রুয়েলটি প্রমাণ করতে পারেনি কি রুয়েলটি তো হয় অর্ডার ফর 27 করে উল্লেখ ছিল সেটা করলে এখন
Lordship, I am appearing on behalf of the respondent, Lordship.
yes respondent yes Mr. Dole.
Yes. This matter, man, on last occasion, man. Yes.
Yes, tell us in a nutshell what the matter
Yes,
is.
man. This is
You please take your seat.
my husband has filed a suit.
You can also take your seats. Let him argue. Yes.
My husband has filed a suit, man, on the ground of cruelty and desertion. My cruelty could not be proved. Desertion also could not be proved. Only on the last paragraph, my lord, the learned trial court came to the finding that is a deadwood. The relationship has become deadwood and irretrievable breakdown. And so, my lord, desertion. Now, my lord, in this situation, only, my lord, I'll be taking two vital points with your lordship, my lord. Now, this desertion was, my lord, created by my husband. And that is a letter I'll show before your lordship. My lord, two suits previously was filed in 2003 or 2005 and 2007. Those were withdrawn. Specific evidence has come from the husband. My lord, question was asked whether you want to live with the wife. Specifically, no. I in my all case, in entire case in affidavit in chief also, I have laid that I want to live with my husband. But today, the desertion ground which has been placed, if your lordship's
It
judgment
has been decreed on the ground of desertion.
only desertion, cruelty not touched, cruelty not touched. And my lord, constructive desertion will come into play, my lord. Your lordship has also passed this judgment in recent, my lord, that if a wife is not get due to husband's, my lord, whatever may be, my lord, if a wife has not get it is her access to the matrimonial house, my lord, or anyways, my lord, then my lord, that cannot be a point of, my lord, desertion. And my lord, husband has to prove his own case. So, my lord, this is the only, my lord, substance of this appeal.
So what is the evidence on this?
Yes. Now, my lord, lordship will kindly seize, my lord. If your lordship kindly takes the judgment, my lord, just place the judgment.
79.
Yes. Yes. Page 79, the judgment starts, my lord. I'll not trouble your lordship with the whole, my lord. I'll just place. Page 86, issues were framed.
Yes.
Well, issue number 5 and 6 has the respondent shown utmost cruelty towards the petitioner? Has the respondent deserted the petitioner for considerable period without any reason? And Lordship will kindly take page 87, paragraph 10.
You have a child.
I have a child, he is with me, and now he's in college, he's studying engineering, I am paying entire thing,
Above 18.
Above 18, yes. Yes.
Yes.
Now, now may I read from page 87, page 88. Both parties laid evidence. The petitioner adduced oral as well as documentary evidence. The respondent adduced oral evidence only. The petitioner himself has deposed as PW1. He, by filing his examination chief on affidavit, asserted positive plain case and also denied the respondent's case. The witness has undergone cross-examination by the respondent. In court of cross-examination, he has admitted that in copies of complaint which he had produced not bears the respective GD numbers. He has admitted that gift during marriage still lying at his residence. He has further admitted that in month of February 2004, the respondent joined as assistant teacher at Borisha High School, Kolkata. He has admitted that his previous suits filed in the year 2005 and 2007 respectively should have ultimately withdrawn as he intended to continue his conjugal life.
Those were divorce suits?
Yes, those were divorce suits. At this stage, learned counsel for the respondent categorically asked him by saying that the respondent was then ready to go with him to lead family life. Whether he was ready to live with her, he replied in negative. He denied the suggestions to be forwarded by the learned counsel for the opposite party, denying the positive plain case or asserting the respondent's case. 12b, one Brikodhar Haldar has deposed as PW2 in support of the petitioner's case. He, by filing his examination chief on affidavit, contended that both the parties to the suit were known to him as they were his neighbor and he had attended in their marriage ceremony held in 12 July 2001. He has alleged that the respondent during her stay at her matrimonial house never performed the duty and often used to leave her husband abroad without intimating the petitioner to her paternal house, and he himself along with her husband on several occasions went there to bring back, but she used to refuse. He has further contended that since the petitioner and his relatives at several occasions requested the respondent to come back to her matrimonial home, but as she refuted, prompted the petitioner to file a suit for divorce. This witness has also undergone cross-examination by respondent's learned advocate. At the very first occasion, he admitted that he did not receive any summons. Further, he denied that he appeared before the court as directed by the petitioner, but also admitted that as per his instruction, he appeared before this court. He claimed himself as businessman. He has also admitted that the respondent used to reside at a matrimonial home at Behal, but he flatly denied about any knowledge regarding any quarrel cropped up in between the couple while the petitioner came to his house or whether the petitioner ever assaulted the respondent. He admitted the respondent observed all the rituals after the death of mother of the petitioner. The witness was asked about this date of marriage. He replied he cannot say. He admitted that his wife was not residing with him. He has admitted that he has no knowledge whether the petitioner came to Krishnanagar to take back his wife to his home. Now, these documents were exhibited, all the address to the officer in charge, all complaints were exhibited, Now, after that, page 91, 14a. The respondent, on the other hand, herself has deposed as OPW1. She, by filing her examination in chief on affidavit, denied the plain case and asserted her positive case as depicted in her written statement. She has also undergone cross-examination by the petitioner. During cross-examination, she has admitted about the profession of her husband or about his place of posting.
What do the parties do?
Both are my client is teacher. He's a teacher.
And husband?
Government employee.
Government employee. And he's a government employee.
Government employee.
Yes.
She admitted that she used to reside with her husband at his place of posting, but subsequently, due to her pregnancy, she came back at her paternal home. She also admitted that she was qualified in SSC examination in the year 2004, and at that time, she used to reside at her matrimonial home, and during her said stay, her son was also admitted at a school at Kolkata. She denied the suggestion that while her husband was posted at Jangipur, he used to attend office from Krishnanagar. However, she admitted that often he used to come over there. She denied that since 23rd October 2006 till that day of cross-examination, that is 6 March 2021, they had no physical relation. She also denied that since she was not willing to lead the conjugal life with her husband, for that she never filed any suit praying for restitution of conjugal life. She also flatly denied the suggestion that after joining service in the year 2004, she used to reside in a separate rented room or often used to threaten her husband to implicate him in false criminal cases. She asserted that till date she did not file any single case against her husband for his alleged torture upon her. She, however, admitted that her husband withdrew his first divorce case filed in the year 2005, and she agreed to lead conjugal life with him. And as she agreed to lead conjugal life with him, she denied the suggestion regarding assault by herself and her mother, or when she got injured in an accident, her husband bear all the expenses for her treatment. She, however, admitted that although not regular, but her husband used to send money for her son without any specific direction from the court. Now, my lord, one, but this is the elder
Why
system.
is your entire team standing?
Boss.
Let them sit.
Now, my lord, if your lordship kindly takes, my lord, then my lord, the cross-examination of VA. Now, my lord, lordship will kindly takes, my lord. Yes. My lord, page 93, my lord, paragraph 16.
Yes.
Learned counsel for the respondent, on the other hand, submitted that in this case, learned counsel for the respondent, on the other hand, submitted that in this case, the petitioner has prayed for divorce on two grounds, that is, desertion and cruelty. As regards cruelty, the petitioner not able to satisfy the requirement to convince that his client ever had shown any cruel attitude. Regarding desertion, he submitted that from the plaintiff case, it would appear that alleged desertion started from 23rd October 2006, but there is no reliable, valid documents produced before the court regarding that date. He argued that so-called date of desertion is nothing but a fictitious date one. He ultimately pressed for dismissal of the suit. I have considered respective submissions. Let me consider the ground of cruelty as claimed by the petitioner for divorce. In this case, as stated earlier, the husband has paid for decree of divorce. Now, in this case, the entire from page 94 to 97, the reasons has been recorded. I am not reading before lordship. If your lordship kindly takes paragraph 19 of page 97.
Yes.
The above mentioned illustrations number 8 and 11, 8 and 12 given in the Shamor Ghosh case support the view taken by the High Court in holding that in present case the wife has treated her husband with mental cruelty. In this case, the petitioner in his plaint as well as evidence tried to point out some illustrations of mental as well as physical cruelties. On the other hand, the respondent also spoke about some instances of cruelty. Whatever may be on close scrutiny of the so-called cruelty and its evidence, as the petitioner tried to convince this court, it appears to this court, that the petitioner himself deliberately tried to create some documents, although those are admitted into evidence, that is Exhibit 1, 1A, 4 and 7, but in strict sensu, those are not admissible in evidence. In this context, it is relevant to point out that mere marking of a document is not sacrosanct. The petitioner failed to satisfy this court about its authenticity. Nonetheless, to mention that the term cruelty constitutes a strong ground of dissolution of marriage, but nowhere in the act it has been defined. It depends upon the number of factors of each case, like conglomerate conduct of the parties concerned, and if found sufficiently good to come to a conclusion from reasonable person's perspective that it is not possible for one party on account of the conduct of the other party to continue the ties. The marriage and the act of such a nature committed by the other party causing mental and physical injury, as a result of which living together is impossible, can be a ground for divorce. It is settled law that cruelty should be at such level or nature that normal living may not be possible. In this context, it is relevant to point out that any mental cruelty may not be necessary to cause injury to health, etc. Circumstances of each case and fact may be different. In one class of cases, the status of the parties, certain facts may amount to cruelty, while the some set of facts in another classes of cases may not amount to cruelty. Sometimes even mental cruelty may be accounted as cruelty. After amendment of Hindu Marriage Act, the meaning of term cruelty has become wide, but the basic requirement is that there must be a harsh or painful conduct of certain amount and for relative prolonged duration. Any solitary incident in conjugal life shall not be constituted as cruelty. It is true that it is not very easy for a person to prove mental cruelty. On the other hand, it would be very easy to prove physical cruelty. In this case, the petitioner alleged of physical cruelty as well as mental cruelty. But so far the question of physical cruelty is concerned, this court failed to found any cogent evidence. On the other hand, as regards mental cruelty, as alleged faced by the petitioner, which can be ground for divorce, shall be considered in the entire perspective of the relationship between the parties. Honorable Supreme Court time and again holds that any willful and unjustifiable conduct of the another spouse in a matrimonial relationship may give rise to cause mental. In this context, even any false allegation in the written plaint has taken as mental cruelty. However, in this case, the instances that the petitioner tried to convince this court appears to be normal wear and tear of family life. The instances in the humble omission of this court cannot be adjusted as mental cruelty. The allegations of the petitioner against his wife is that she caused misbehavior towards the petitioner as well as family inmates, ignoring the family value. And it is also alleged that she refused to remain in joint mess with the widow mother of the petitioner and also reluctant to do household work or other things which was expected from a housewife. But the fact remains that respondent resided at her matrimonial home before she gets job, and even after getting job she used to reside at a matrimonial home. And it is from the petitioner's evidence that after the demise of petitioner's parents, she had duly performed last rites of the petitioner's parents. Moreover, the case of the respondent is that indifferent attitude of the petitioner towards his wife and so on forced her to come back at Krishnagar, and from her she used to go to her school at Kolkata. Considering the entire evidence on record, I have no hesitation to hold that ground of cruelty as the petitioner tried to convince holds no water. The so-called cruel attitude as the petitioner trying to canvass a normal treats and bits of conjugal life. Now, my lord, in desertion, my lord, Lordship will kindly takes, my lord, page 101, paragraph 26, my lord, I'll be starting. My lord, any marriage, section 13(1), 1B of the Hindu Marriage Act reads as follows. Divorce, any marriage solemnized whether before or after the commencement of this act may on a petition present by either the husband or the wife be dissolved by a decree of divorce on the ground that the other party has deserted the petitioner for a continuous period of not less than 2 years immediately preceding the presentation of the petitioner or explanation. In this subsection, the expression desertion means the desertion of the petitioner by a other party to the marriage without reasonable cause and without the consent or against the wish of such party, and includes the willful neglect of the petitioner by the other party to the marriage, and its grammatical variations and cognate expressions shall be construed accordingly. The Honorable Supreme Court in Adhyatama Bhattar Alwar versus Adhyatama Bhattar Sri Devi Supra explained the term desertion. Desertion, it is in the context of matrimonial law, represents a legal conception. It is difficult to give a comprehensive definition of the term. The essential ingredients of this offense, in order that it may furnish a ground for relief, are the factum of separation, the intention to bring cohabitation permanently to an end, animus descendendi, the elements of permanence, which is a prima facie condition, requires that both these essential ingredients should continue during the entire statutory period. The clause lays down the rule that desertion to amount to matrimonial offense must be for a continuous period of not less than 2 years, immediately preceding the presentation of the petition. This clause has to be read with explanation. The explanation has widened the definition of desertion to include willful neglect of the petitioner's spouse by the respondent. It states that to amount to a matrimonial offense, desertion must be without reasonable cause and without the consent or against the wish of the petitioner. From the explanation, it is abundantly clear that the legislature intended to give to the expression a wide import which includes willful neglect of the petitioner by the other party to the marriage. Therefore, for the offense of desertion, so far as the deserting spouse is concerned, two essential conditions must there, namely the factum of separation, the intention to bring cohabitation permanently to an end, animus descendendi. Similarly, two elements are essential so far as the deserted spouse is concerned: the absence of consent and the absence of conduct deviable reasonable cause to the spouse leaving the matrimonial home to form the necessary intention aforesaid. The petitioner for divorce bears the burden of proving those elements in these two spouses respectively, and they continues throughout the statutory period. Now, Mala, the judgment has been given, Mala. I am not reading, Mala, 104, 105. 106, my lord, 106, my lord, paragraph 30, my lord, I'm starting.
That's also reiteration of the principles laid down.
Yes,
there.
yes.
Same factor
Yes,
of
same,
separation.
same, all. Paragraph 30, my lord. So considering the other celebrated pronouncements and the aforesaid two pronouncements, one thing is very common, that the offense of desertion so far as the deserting spouse is concerned, two essential conditions must be there: the factum of separation, the intention to bring cohabitation permanently to an end, and similarly two other elements are also essential so far as the deserted spouse is concerned: absence of consent and absence of conduct. Absence of conduct giving reasonable cause to the spouse leaving the matrimonial home to form intention aforesaid. Nonetheless, to mention that the burden of proving desertion and that such desertion was without any reasonable cause is on the party taking the plea. However, this is initial that is initial burden that can be shifted if the party able to satisfy the initial burden. Well, I'll be arguing on this point also. So it is not created that though the wife is living in her father house separated from husband, can be offended the term desertion. In this case, admittedly, the respondent is residing at Krishnanagar, leaving her matrimonial home on and from 2006. The petitioner alleged the respondent without any reasonable cause withdrew herself from her matrimonial home, and since then she is living separately and never ever intended to go back there. But the respondent from the very beginning contended that respondent himself abandoned her, as initially he refused to take her to his place of job, and subsequently when she was residing in a matrimonial home, the husband willfully not going there for months together, and as such feeling insecurity of herself and minor son, she was forced to withdraw herself from her matrimonial home, and since then she was residing at Krishnanagar. It is also for the case of the respondent that since she had been residing since she had been transferred to a nearby school of Krishnanagar, she is residing here, but she is willing to go to a matrimonial home to resume conjugal life. Here, one thing is very much clear, that the respondent never lodged any complaint that while she was residing at a matrimonial home, she had been subject to any mental or physical cruelty by the husband or his family inmates. There is no scrap of paper produced even by the respondent while deposing before this court admitted that she had never made any complaint to any authority concerned. So her sudden withdrawal from her matrimonial home is seemed to quite unnatural. Even she was then working at Kolkata itself. There is no denial that since then they do not have any cohabitation. So the fact remains that the respondent is living separately at her paternal home and never ever tried to resume her conjugal life. The petitioner, on the other hand, on two occasions filed divorce case, and both occasions he withdrew the suit, fortified his intention to resume conjugal life. Even he had unsuccessfully tried to get custody of the child. The intermittent desertion by the wife ultimately suggests her animus disorderly, so the act of the respondent appears to be active or willful termination of an existing state of cohabitation without the consent expressed or implied by her husband against his wish, and as such he is entitled to get a decree of divorce. Now another question would arise as to whether the marital ties between the parties shall continue or not. Again, another point has been emphasized by the learned counsel for the petitioner, that from the evidence on record, it is abundantly clear the relationship between the parties has broken down irretrievably, and as such there is no possibility of coming together and leading a conjugal life. I have considered on this court feel that there is no need to go beyond the statute. Honorable Supreme Court in Vishnu Datta Sharma versus Manju Sharma report in AI 2009 SCW 2984 has been pleased to hold that on a bare reading of section 13 of the act reproduced above, it is crystal clear that no such ground of irretrievably broken down of marriage is provided by the legislature for granting a decree of divorce. This court cannot be added such a ground to section 13 of the act, as that would be amending act, which is function of the legislature. Honorable court also another judgment in Darshan Gupta versus Radhika Gupta has been pleased to hold that if the husband living separately for 12 years cannot seek divorce on the plea of irretrievably broken down of relation and offering to pay to wife whatever was considered appropriate by the court, whatever may be taking into account the abaments and testified as DW, it is found that there are sufficient materials in the record from which the court can come to the conclusion that the respondent has caused by her conduct desertion to the present petitioner, and such there is remote possibility to live together as husband and wife with all this anguish in their respective minds. This court can come to the conclusion the relationship in between the parties has now become a deadwood and there is no possibility for resumption. As such, if this decree of dissolution of this marriage is passed, the instant suit should be suffice. So, my lord, before my lordship going to any document, my lord, lordship will kindly takes, my lord.
So wife is now residing in Krishnanagar.
Now Krishna.
What is the matrimonial home?
Matrimonial home presently in Kolkata. Kolkata থাকে তো,
So you did not prove, court says that you did not prove anything to show that your animals reverted.
Now, my lordship will, I'll just show you a lordship a document at page 149. This was exhibited, but my lord, anyways, it was marked as exhibited. This is the document. Prabhat Majumdar has filed a complaint to the officer in charge, Thakurpur PS, page 149. Well, may I read for your lordship? This is to inform you that I married Srimati Sharbani Majumdar, Nee Sarkar, daughter of Sri Shitish Chandra Sarkar, on according to Hindu rites and customs. Since after marriage, my said wife severely mentally tortured me. We have got a child who is aged about 4 years. But unfortunately, my wife did not allow me to have access to the said son, and she has withdrawn herself from my company for more than 1 year. All attempts to reconcile with her having been failed, I decided to end the matrimonial relation due to the cruel treatment perpetrated by my wife to me and to my other family members also. Accordingly, I have filed the divorce suit against my wife, being matrimonial suit number 2023 of 2007 on 17 December 2007, and the said suit is now pending in the court of London District Judge at Alipur. My wife has been constantly, well, I am stressing on these lines. My wife has been constantly threatening to implicate me in false criminal case in order to terminate my service. My said wife is an assistant teacher of Borisha Uchcho Balika Vidya Mandir at 178 Rajarammohan Road, James Long Soroni, Kolkata 8. And she has been forcefully occupying 2 rooms in our premises at 57-4 Santosh Rai Road, Post Office, Borisha, Kolkata 8, where my mother is also living. Well, I'll stop here. Well, I was doing their job. Well, I want to live with my husband, my lord. And lordship will kindly seize the date 21st December 2007. Yes. And plain case is of 2006. The desertion is from 2006. So, this is the document, my lord. Probably, my lord, if I this is the document, my lord. Why I was stressing on this document, my lord? While I was in
you are residing here, 57 for Santosh Rai.
There was lordship will residing there. That was my school. So my matrimonial home. Beside there, there was my school. Lordship will kindly seize, my lord. This is the letter written by the husband.
Husband, he says that you are forcibly occupying 2 rooms. Sorry, this is his premises.
His premises.
That is what
yes. So, my lord, this is a pure case of constructive desertion, my lord. I will be relying on your lordship's judgment on it.
That was Justice Kumar's probably authored by
Yes. Your lordship held that, my lord. If the wife is restrained, from leading to the matrimony.
Yes. That was relying on some other judgment also. Probably.
Yes, my lord.
That constructive.
কত প্যারাগ্রাফ কোনটা মার্ক করে দিচ্ছি প্যারাগ্রাফ কোনটা
one of the possible views
25 থেকে 32 yes প্যারাগ্রাফ 25 to 32 onwards তোমাকে বলে দিচ্ছি সাইটেশনটা রিপোর্টেরও হয়েছে মনে হয় 2025 SCC অনলাইন ক্যালকাটা 4835
When was the suit filed?
This suit has been filed 2017. This is a third suit. 370 of 27 years. Another evidence.
Would that be relevant? Because in 2007, after that, 2007, he wrote a letter.
Yes.
But after that, he withdrew the suit, and this is a subsequent cause of action.
Even
So
subsequent.
at that point of time, you were living.
What has happened?
In this suit, what is the allegation? Since when you were deciding?
Yes. Paragraph, lordship will kindly comes to page 5. page 5, yes, page 5.
Yes.
Page 5, my lord, paragraph 5. This is their case. Yes. But that soon after the petitioner understood that the respondent did not change her attitude at all, on 23rd October 2006, the respondent along with her mother jointly assaulted your petitioner at his own house, and the petitioner was treated at Vidyasagar State General Hospital and intimated the matter before Thakurpukur PS with a GD number 2541/2006 dated 23rd October 2006. And thereafter, the petitioner again filed a suit for divorce against the respondent before the learned district judge Alipur being.
Is para 7, it has been stated since 2310.
Yes. And on the basis of this matter, the court proceeded. And another important evidence, I'll show before your lordship, just for lordship kind consideration. Yes. Yes. Well, page 46. Starts from 44, the cross-examination of the husband. I'll be only reading the relevant part. Page 46.
Yes.
My lord has opened.
Yes.
46. It is not a fact that I drove her out from our house along with the child soon after joining her service as an assistant teacher of Borisha High School, Kolkata 1 on a single sari. It is not a fact that since we ousted her along with the child, she was compelled to live with her parents out at Krishnagar, or that she used to visit to a school from Krishnagar on daily basis. I know that respondent is now continuing in her service at Rotwari High School at Shimurali under T.S. Chakda. Previously, in the year 2005 and 7, I have filed matrimonial suit against the respondent, and in both occasions, I have withdrawn the suit as I intend to continue my family life with the respondent. The respondent is questioned. The respondent is ready today to go with you to carry her family life. Did you ready to live with her? No. So, I used to travel daily from for 120 to 30 kilometers.
So these suits, previous suits were dismissed or withdrawn?
Yes, lordship will kindly say just after no. It is not a fact that the other two cases which are filed by me in the year 2005 and 2007 were dismissed after holding in full sanction. So, probably it was withdrawn.
No, previous sentence it says.
Yes.
Previously, before the question.
Sorry, I'm extremely sorry.
Before the question, it
Were
says.
dismissed after holding in full sanction. Yes. So
No, before the queue.
Yes, my lord.
Previously in the year such and such, I filed my suit, and in both occasions I have withdrawn.
Withdraw the suit.
Specifically says.
Yes.
But the second line.
It is not a fact. It's
not
a fact.
double negative.
Not a fact. Double
negative.
negative.
Yes, that won't do. That won't help.
Yes.
That won't help in this court. Kaar samne bolchis won't help you. Yeah.
So, the sum and substance comes from this only, because this is.
You're citing the judgment.
Yes, that is a judgment. I am citing and kunta paragraph. From 25 to 32, if your lordship allows me, I can read the entirety. Specifically, yes.
You underlined the portion, so we can read from. Yes, they rely on 57 Supreme Court.
Yes.
মেন করেছিল যে আমার জন্য যদি আপনারা ছেড়ে দিতে হয় তাহলে আপনি কনস্ট্রাকটিভেশন না আমাকে রিজার্ভেশনের উপর দিয়ে পড়ে No, what about you? I mean, your evidence says that you are still in Krishnanagar somewhere.
Now, probably in Krishnanagar, because this is 2025.
In Krishnanagar.
Yes.
So, did you show anything to prove that you have tried to come back and?
No, that was my evidence from all along. In my evidence, it starts from 55. Yes. Well, page 58, my lord, I'll be just reading for your lordship, my lord. Yes. Well, page 58 and 59, I'll done. Yes. Read, ma'am. Well, may I read, ma'am? Yes.
Yes.
That my husband never look after our son and myself and used to come at Kolkata at his house once after 1 or 2 months. He never spent any time with his son and he used to misbehave with myself. That from beginning the petitioner used to threaten me for divorce and he used to quarrel with me and used to assault me, and prior to filing this suit the petitioner filed suit for dissolution of marriage thrice, and even such suit got dismissed. The petitioner used to threaten me that he will marry another lady and will drove out myself from my house, that for the sake of a future of my son I used to digest all the torture inflicted upon me by the petitioner and his family members. That thereafter the parents of the petitioner had died and I had performed all their funeral works along with the petitioner. That the petitioner never wanted to continue his conjugal life with me accordingly after filing a second suit for divorce against me. That I was driven out from a matrimonial home and was forced to leave the house, keeping all my belongings in that house, and I, along with my minor child, left my matrimonial home and came to my paternal house at Krishnagar along with my minor child and took shelter there. That I used to attend my school at Behala, Kolkata regularly from Krishnagar, but I was not allowed to stay at my matrimonial home. Thereafter, I compelled to take transfer from Behala to Krishnagar, and at present I am assistant teacher in Routuri High School for girls at Shimulari, Nodia. That I admitted my son in the Bishop Moro School, the West English School with the Nadia district, and all expenses are being borne by me only. The petitioner spent a single farthing towards the maintenance and education of a minor child, Suprabha Mujumdar. Not only that, but also my husband few months ago went to the school of a minor child and met with the principal of the school and harassed our minor son and tried to obtain TC certificate in the name of a minor child. But due to my intervention, the petitioner was failed in his mission. That still I am willing to continue my matrimonial life with the petitioner for the betterment and good future of our child. That during my pregnancy period, the petitioner used to force me to abort, but I was not willing to do so, for which the petitioner intentionally kicked me and I fall down, got injury, and my father took me at Krishnagar and treated me. My father requested me to stay at Krishnagar till the birth of my child, but the petitioner did not allow me. Accordingly, I was brought to Kolkata at my paternal house, where my son took birth at Ramakrishna Mission Hospital at Taliganj in Kolkata. That thereafter the petitioner, without any just cause, used to stay at his sister's house, leaving me and my son alone. That I, along with my minor son, are residing at Krishnagar in my paternal house since 2007, and the petitioner never looked after myself or minor child till that date. That was never willing to dissolve I was never willing to dissolve our matrimonial tie. I am still willing to continue our marital life with the petitioner, for which I never made any complaint before any authority against the petitioner. That the petitioner, with some ill and ulterior motive to get marriage once again with another woman, has filed this present suit with false and fabricated. So, my intention was very clear from first. I have proved that. On the contrary, the husband case is totally based that desertion he could not prove. On the contrary, he has made a situation that I could not enjoy the whatever the marital life.
Yes. What about irretrievable breakdown? Deal with the judgments of Rakesh Raman and.
Today I'm not coming now. I have not got that judgment.
Throughout the morning, we have been dealing with this. None of you followed.
I should have.
Those are the only two judgments.
Yes, yes. My only case before your lordship is that whether
Paja, are you ready with that those judgments?
Yes,
Rakesh,
ready.
so when you cite, they'll give reply. That's all.
Yes. Only one point, whether the husband is entitled to get a decree for desertion on the basis of these facts and circumstances, where he has made a complaint before the police.
Desertion, it has not been granted on the ground of desertion, has it been? Only
But observation has been given. Well, if I could have followed, my lord. Well, the observation has been given, but my lord, on the last point, my lord, the court came to the conclusion that
See, you had driven out and everything. You did not produce a single piece of evidence to show that
well, I
there
have
is any complaint or anything.
well, I have taken a plea, my lord, that well, I have not lodged a complaint because he is a
To
government
save the
servant.
marriage.
Yes, he also government servant. My lord. Well, I have not done that thing. On the contrary, man, on apprehending that I'll lodge a criminal case, he lodged a complaint. And man, specifically, man, that I should not enter into that group. So, man, this is my factual aspect is concerned. Man. Well, I have not made a complaint, man. That was my bona fide.
He cannot take advantage of his own wrong.
Yes, grateful. No, I am the last, and nothing else.
Very good. Yes.
Chief, the dates are very important here. July 17th, the petitioners got married.
Which year?
Subsequently,
Which year?
2021. 2001.
2000. Married? Yeah.
17th of July 2001, petitioner and respondent got married. Subsequently, in August 2001, they went to the working place of the husband and both of them started to reside together.
That was in Murshidabad.
That was in Murshidabad, Jangipara. Jangipur. Jangipara. Subsequently, in 2003, Jangipur.
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 Jangipur, Murshidabad.
In Murshidabad.
Murshidabad and
Murshidabad.
Jangipur.
Subsequently, in 2003, 13th of October, the son was born. In 2004, she got the cracked SSC and she became a teacher. Then the first matrimonial suit was instituted by the husband. That was in 2005. Here, primarily from day one, the allegation was that she was not residing with him and the marriage was, they were living, but they were not living together for a constant period of time. It was kind of on and off relation. Subsequently, the wife agreed to reside together. The suit was withdrawn. 2005 suit was withdrawn. In 2006, both the husband and wife met with an accident on 23rd of October 2006. Both husband and wife met with an accident. Her husband only took her to the hospital and everything was taken care of. But subsequently, it has been alleged by the husband that he has been tortured and assaulted by the wife and the mother of the wife. And subsequently, a police complaint has been made. Although the GD number of that complaint is not reflected, but a police complaint was made.
You are the husband. You made the police complaint.
Yes. I am the husband. Police complaint has
But if
been
you got to hospital, then that should be disbelieved.
Yes.
Your allegation should be disbelieved.
No, subsequently, if Lordship kindly...
2005, you filed a divorce suit.
Yes.
2006, you met with an accident.
2005, the suit was filed. Subsequently, it was withdrawn also. Since the
When
wife...
withdrawn?
Withdrawn in 2005 only. Because the wife agreed to reside to.
All right. Then accident in 2006. What was the nature of the accident? At home?
It was a road accident. It was a road accident. They were traveling together in
He
a
lodged a
scooter.
complaint saying that
No,
they
it
beat
is
you up.
not related with the accident. Accident happened, then subsequently they went to, she was treated and everything has been done. He was not alleged because of the accident. It was, the assault was in regard to the issues, home issues, not
In
regard
the
to
same year, 2006.
2006. They were residing together at that time.
Yes.
Then subsequently in 2007, another suit was filed. It was also withdrawn because due to the illness of the mother of the husband.
Why should the suit be withdrawn for that?
No, he couldn't continue at that time because he was alone. He was taking care of the mother. He couldn't go to the court properly, and subsequently the wife also agreed to reside. So that's why he didn't continue. He didn't pursue with
You
the
seem
suit.
to have a biannual habit of filing suits. Every 2 years, one suit.
But Lordship, subsequent
You
suit
withdraw
was
this
not
also
filed.
and live happily together.
But subsequent suit was not filed within 2 years. Lordship will find the last suit on which the decree has
Much
been
later,
passed
much later.
much later, 2017. Almost after 10 years, he waited for her, but there was no sign of any kind of mutual agreement or coming to a conjugal to leave a conjugal right. There was no sign or signal from the wife. Lordship, there has been several allegations against me, which has been leveled by the wife. Right now, my learned friend only read from page 59 that she has been forced and kicked, and which forced her to go to the matrimonial house during pregnancy. But her only statement, if Lordship kindly comes to page 59, sixth line from last paragraph, from last page. till birth of my child, but the petitioner did not allow.
Read up one sentence before that. That still I am willing to continue.
Yes.
Just middle of that.
Still I am willing to continue my matrimonial life with the petitioner for the betterment and good future of our child.
Then
that during my pregnancy, the petitioner used to force me to abort. But I was not willing to do so, for which the petitioner intentionally kicked me, and I was fall down, got injury, and my father took me at Krishnanagar and treated me. My father requested me to stay at Krishnanagar till the birth of my child, but the petitioner did not allow me. Accordingly, I was brought to Kolkata at my matrimonial house, where my son took birth at Ramakrishna Mission at Tollygunge in Kolkata. So at one hand, she's alleging that I am not taking care of the child, and I'm kicking her and forcing her to terminate the pregnancy, and I am the only one who is taking care of her, bringing her to Kolkata for delivery. So first allegation, just a second. Page, if Lordship kindly comes to page 16. Middle of the page.
yes, this is the written statement.
Yes.
Right.
That the petitioner was in government service. The petitioner used to reside in Raghunathganj, Murshidabad for his service, and the respondent used to request him to brought her at his workplace, but the petitioner did not show any endeavor to her request, and then the respondent insisted him. The petitioner threatened her for divorce. Accordingly, the respondent used to reside lonely at her matrimonial home. Subsequently, the respondent went to Murshidabad at service place of the petitioner without willingness of the petitioner, and the respondent used to come at her matrimonial home at once within a week. So this has been an allegation completely. There has been no foundation of that he was forcefully kept there. Now, Lordship, if kindly.
What sort of proof would she give? Corroborative evidence by somebody that the husband did not. He initially left her and went for work to Murshidabad. When she went there and stayed there forcibly, husband used to come once in a week. That is her allegation.
Yes.
How is she supposed to prove it? By
that is
neighbors?
what I'm saying, Lordship. If kindly compares to page 57. Page 57.
57 years.
Yes. Question number 7, Lordship. That subsequently, against the will of my husband, I went to Murshidabad at his workplace.
Yes.
After staying there for few days, I came back to the matrimonial home. She was not forced. She was never forced. She didn't specify that she was forced to come back to her matrimonial home.
Matrimonial home.
I am saying forced. She was not forced. She intentionally, by herself only, she has come back.
But this her pleading is also unclear. Page 16 you are placing, she says, subsequently respondent that respondent, the wife, went to Murshidabad, service place of the petitioner, without his willingness. And the respondent used to come at her matrimonial home at once. Let us take that as once a week. So matrimonial home is elsewhere, not in Murshidabad.
Not in Murshidabad.
You don't. Did she mean that matrimonial home means the place where he was residing?
Kolkata.
But how does this connect? This sentence doesn't make any sense actually.
Yes, I know.
Respondent went to Murshidabad at the service place of the petitioner without his willingness. Understood. Acha, respondent, and she used to come to a matrimonial once. At once, once a month. At once within a month. আচ্ছা at once সঙ্গে সঙ্গে দুটোই হতে পারে, যদি ভুল ইংরেজি হয় তাহলে once a month, once a week, কিন্তু at once within a week হচ্ছে আবার ফিরে এলো পুরো ম্যাট্রিমোনিয়াল থাকতো না, ছিল থেকে ফিরে এলো। If you take it literally, and the petitioner but used to come once a week. Anyway, so very well.
Now, Lordship kindly sees that all these allegations, during all these allegations, not a single, no complaint was filed. Definitely, she was very protective about the husband and didn't file the complaint. But she could have filed a restitution for which a complaint is not required. Not a single application for restitution for all these years from 2005, according to the if I consider it from the first suit which was filed from 2005 till date, not a single application for restitution has been filed. And it has been made in her averments. If I can show also, Lordship, if Lordship kindly comes to.
What is the time frame when this happened? She went to Murshidabad and all?
This is prior to her service. That is from
2003.
Immediately from 2001 till 2003. So if Lordship kindly comes to page number 68. Are তুমি কমেন্ট করছো কেন? আমি তো তোমার সময় কিছু বলিনি।
68, yes.
Yes. If Lordship second last question, it is true that my husband withdraw his first suit for divorce filed in 2005 since I had agreed to live conjugal life with him. Prior to that, if Lordship kindly comes to the middle of the page, I do not ever file any suit praying for restitution of conjugal life.
Nobody says that she filed a suit.
Just her
adding to that.
Yes.
Very well, yes.
Now, in regard to torture also, Lordship kindly records that no complaint has been filed, no case has been made, and rather, even after torture, according to her own statement only, the husband is the one who has taken her to the hospital in 2 occasions, once for the childbirth and second when she has met to the road accident. In her written statement only, which she has specified. Now, the third allegation is that no money has been spent, neither on her nor on the child, when and they were literally on the verge of starving, which has been specified in page 17.
Seven zero 17.
17.
Yes.
If I can start reading, that the respondent, first line only, that the respondent alone used to look after her son. The petitioner never looked after the minor child since birth, and the parents of the petitioner separated. Not clear. The respondent from their joint mess at the petitioner used to spend a little bit of his family. Therefore, the respondent and her son and the respondent on starving condition, the English is not really good, but condition used to beg money for her maintenance from her father. And this way, after expire of 1 year, the respondent got a job in Borisha Ucho Balika Vidyalaya near her matrimonial home, and she used to nourish her minor child and used to do her job, knowing her father-in-law or mother-in-law or petitioner help her in this regard. So here she is saying that she is starving and the respondent never used to pay money. But starving likha ache.
Mr. Chakrabarty, don't continuously disturb, please. It's very irritating for the court also. You're continuously commenting and it's coming within a hearing. Please keep mum or leave the court. Yes. Let her argue. Yes, please continue.
Pardon me, Lordship. Now, Lordship, kindly comes to page 160. These are certain money receipts, money order receipts, which shows that I have sent money time and again, which were refused by the wife. There was no direction from any court, but I have tried my best to do something, but which was time and again.
You have claimed alimony also.
There has been no claim because there has been no, what should I say, no connection. Neither yes, neither no. It is kind of a, they were in a limbo, kind of a limbo.
This was in which year?
This was
after filing of the
2017.
After filing of the suit.
No, prior to also in her statement also, in her examination also, she had specified that may not be specific amount, but
you have exhibited only post-suit documents. This might be for the purpose of the suit.
Here maybe,
maybe for the creating a.
Maybe, but prior to that also, Lordship, I can show the statement from her.
That is neither here nor there, Ms. Punjab, because you sent money, she did not take. This is during the pendency of the suit.
Yes, this may be during the pendency of the suit. Prior to that, she has admitted that I have been giving money. It is not denied that I have not given money.
So what is she supposed to do? Write an acknowledgement. Thank you for the money.
Definitely not.
It does not show it's a dead relation. You sent money, she either took or refused.
Yes, no, dead relation, Lordship, I am not coming, but I am only dealing with the allegation that I have not taken care of the child because I am not considering on the topic of dead relation right now, Lordship. I can show from my statement also. 2016 also. There are other money receipts which shows that 2015-16 is also there prior to the issuance of the, prior to the filing of the suit.
But those were not exhibited, so we won't look into it.
There are other money receipts also, Lordship. I am not able to go through this because there are in page 162, 161, because my copy is not very legible. But original documents are there, but no point of
2017. We find all 2017. All of 2017. Contemporaneous.
But there are other documents we have, but
we have found.
I don't know. It is not annexed here, but
2016 there is 2018. Sorry, it goes forward 2018 up to page 160 to 164, starting from 2017 to 2018. There are no money receipts before that. No other money receipt.
But in page 69, she only has, in page 69 of the, she has said that it is not a fact that my husband, it is true that my husband used to send money for my son. In page 69, volunteer, his payment was not regular and not sufficient to fulfill the needs of my child. But money used to come. And the next line is that it is not a fact that my husband voluntarily sent money without any specific direction from the court. So this is in regard to the, I'm not getting into the education part because I'll say that education she has only provided, but there are, I have even filed a habeas corpus, writ of habeas corpus for taking decisions in regard to my child, because there has been an allegation against the mother that the son has been forcefully admitted to one college, but subsequently, due to the pressure of the mother, the son changed the statement. The habeas corpus was subsequently withdrawn.
Filed a habeas corpus.
Yes, because the son said that he has been forcefully kept in the room, and there was other allegations.
What happened to the habeas corpus? Withdrawn?
Since the son gave a statement in there that I have not been forced, but it is off the record, but the son only made a phone call from his mother's phone, and in any event, there has been that I was concerned about my son. Till date, I am. Now, in regard to the Deadwood Lordship knows there, the judgments are there. Lordship has already
Yes, but for that the marriage has to be irretrievably broken down, meaning cruelty against each other. Both sides are not willing.
Yes.
But then in every case, it cannot be a rule that I just don't want to live with my spouse and I file a suit and get a divorce.
Yes, Lordship.
That cannot be from. It has to be from both sides.
Yes, but Lordship, here are two.
You have to show that there is lack of animus revertendi from their end. They don't want to revert back. For which you have said no
Yes,
suit for
Lordship,
restitution has been filed, and also that she did not show any intention to
Lordship,
come back.
there is an admission that since 2006 they were living separately. There has been an admission in the examination. There has been an admission that since 2006 both of them were living separate.
True, but she says that she went to Murshidabad. You were living at your sister's residence somewhere else.
Not from in 2006. That is prior to 2006. After 2006, there has been no progress, no effort made by the wife.
Where did she admit after 2006 there is?
Yes, Lordship.
You are living separately?
She has admitted 2007, but her sister has said that 2006.
Was those two places?
Yes, yes. I'll just show. Just a second, Lordship. Just a second, Lordship. If Lordship kindly comes to page 76, this is the cross-examination of DW2. Here, Lordship, second last question. It is true that since 23rd 10 2006, they are living separately. Her own sister, wife's own sister. And in the WS also, she has specified that since 2007, they are living separately. I'll just show. Just a second, Lordship. I sincerely apologize. I sincerely apologize. I'm not able to find the
Page 19. That the respondent along with it should be her. Is it wrong typing or the original WS is like this?
Like this, sorry.
What is patrimonial house means? Patrimonial means father's house. Mr. Chattopadhyay,
I have to check it, my lord, from the
your
record.
client's written statement. Don't you have a copy of the written statement otherwise? Just check up. Where are you nodding your head?
No, dekhi.
Last paragraph of that your written statement.
Yes, Lordship, this is the thing. 2017. That is her admission.
2007.
2007. Since 2007, she is residing there.
না কত প্যারাগ্রাফ দেখাচ্ছ না?
Last paragraph near the end. Is it written patrimonial in the original written statement also? Patrimonial, P.
প্যাট্রিমোনিয়াল এটা আবার কি রে? Yes, মানে patrimonial written.
What is a patrimonial house? A father who has money. Patri and money both are there. I've never heard this expression. Maybe I've never heard. Matrimonial, I know.
Yes,
Paternal house, I have heard. No, need not show us. If that is there, it's correctly reflected.
Sorry, yes, page 7.
A divorce degree should be granted because of your choice of advocates. Not here.
I don't know.
না দেখেছি আমি খুঁজে পাচ্ছি না। লেখা আছে।
If the entire thing has to be interpreted by us, then what remains in your pleading?
Now, Lordship, there has been situations where both the parties tried to reconcile among themselves, but eventually which failed. Lordship, Lordship, if kindly comes to page.
নাও হতে পারে, ম্যাট্রিমোনিয়াল হতে পারে, তার আগে সেন্টেন্সটা দেবে।
No, father's house, not matrimony.
Nagod is father's house.
Father's house. It's not matrimony.
Yes. The patrimonial means paternal.
Because the sentence ends at like this, and the petitioner never looks after her or her minor
That could have been even if she is in a matrimonial home, but she says along with his minors and with her minor son should be is residing at Krishnanagar in her.
Yes,
Krishnanagar is her
and
patrimonial home.
Is also that we are not letting.
She has made several disparate allegations. One is that she was in her matrimonial home,
yes,
but you used to live in your sister's house and things like this. When we can't connect the dots.
Yes. So there has been time and again they have tried to reconcile. Now, page 76, last question. This is the evidence of the DW2, that is the sister of
We
the.
have seen. She also says from 23.
Several occasions, several attempts were made for reconciliation of their relationship, but failed.
So therefore, you are arguing that although on certain discrete occasions they might have come, she might have come, he might have come, but this was, as you said, on and off.
On and off, because Lordship can see if this would have been my intention that I want to get rid of this lady, I could have done it after 2007. I have withdrawn the suit. I could have immediately filed it, but there is a gap of 10 years. I waited, but situations didn't improve. Rather, it escalated towards bad. So this is the final drastic step which I had to take. Now, Lordship, the judgment, Rakesh Raman, Lordship has well.
If the husband and wife, though intermittently, they meet together for a short period also, they reside together, whatever be the period, 1 day, 2 days, the earlier causes of action, those do not remain alive?
Lordship, it 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 remained alive because admittedly they were not living together since 2006. Prior to 2006,
It is your
according to
admission.
my understanding,
It is your admission that intermittently, though intermittently, they used to come together.
not after 2006.
Never ever.
Never after 2006. It has been admitted by the wife. It has been admitted by the sister of the wife. The husband has already said that
Whatever happened prior to that.
prior to that, not after 2006.
All right. Yes, now you're going to.
So Rakesh Raman Lordship has dealt. It is a settled provision that if the marriage is a dead wood, it has to come to an end.
Rakesh Raman is the only judgment where it has been said that it is a part of the 13(1) IA.
Yes.
No other judgment.
Yes.
No other judgment where it has been made a ground of cruelty.
Yes. Yes, Lordship. To be specific, that's true. But recently, it has not been reported. This is an unreported judgment. SLP was preferred from an order of our court only. So there, it is very interesting. The division bench were of two opinion. So
Our division bench had.
yes,
Achha.
the trial judge granted the decree. It was set aside by the presiding judge in the appeal. But the second judge was of the opinion that since the jurisdiction, there were three other things also. The jurisdiction of that court didn't allow irretrievable breakdown of marriage, so it cannot be considered. And there has been no establishment of cruelty, desertion. These are the other
The
two
conventional view.
Yes. Then the matter was sent to a referee judge. So the single referee judge also was of the opinion of the second judge. So the SLP was preferred. In the SLP, it has been considered that even if the cruelty, desertion, it has not been specified, still irrevocable breakdown of marriage.
Whether under 142 you have to consider that.
Lordship can decide. Citation nahi, unreported.
Give a copy to them. Yes.
Please.
Who are the two judges?
Lordship, Justice Sinha is the second judge, and Justice Mukherjee.
Justice Mukherjee granted on the ground of irretrievable.
Yes. I have seen the main order also.
Answer.
Paragraph.
No law laid down still. The Honorable Supreme Court relied on the findings of the High Court for coming to the conclusion that there was irretrievable breakdown.
Yes.
But does not say that trial judge, the High Court could have done that. That is not held here. Like in all the other judgments.
Yes.
Even Justice Nagaratne in the other judgment, the last judgment where she has held, that was a Section 25 transfer petition. There she held that no, her division bench held that no. In this also 142 can be exercised. Another judgment was placed before Shaila. That there it was a 13B. So that period was held to be mandatory, but 142 at least there are 500 judgments probably where this has been given. But not a single judgment except Rakesh Raman where the court was bold enough to put this in the UK law long back recognizes this. It's in some counties it's cruelty. Irretrievable breakdown is called cruelty. Definition includes this. In others, irretrievable breakdown itself is a ground. That's treated to be cruelty ultimately. But we don't have that. There has been recommendations by the Supreme Court time and again since last some decades.
Yes, that's true.
We'll keep this. We'll take this.
So, Lordship, my primary submission.
The other Justice Nagaratha's judgment you don't have.
I have got this judgment and another judgment I have got, but I don't.
Very well. Revati, no?
No, my
Reena Behati.
friend is carrying.
Reena Behati.
Yes. Rinku Bet.
Rinku Behati, right.
This is such.
Give one copy to them. You check Mr. Chattopadhyay whether you can gain any materials from this. Here 142, but if you, oh, this has been reported now. This is the first time I'm getting a reported code. Thank you. This is a judgment on the proposition under 142 Supreme Court can. But here Rakesh Raman was considered. An argument was advanced before us that this is for you also because it's in your. An argument was advanced before us that last page is not there. Up to 28, page 28.
From page 20 to or last page.
Last page is not there. An argument was made that here Rakesh Raman was considered. But Supreme Court held that these are granted under 142. But we had distinguished that in our previous judgment in this bench. We have said that here Rakesh Raman was considered along with several other judgments. In Rakesh Raman's, in certain other judgments, while dealing with some other judgments, court held that there it was granted under 142, like Shilpa Sailesh. That paragraph of this judgment, Rinku Behati, which quotes Shilpa Sailesh, says that exercise of jurisdiction was under Article 142. But the paragraph where Rakesh Raman was dealt with, the immediately preceding sentence says, in several cases, Supreme Court has granted the dissolution of marriage under 142. Then Rakesh Raman is quoted. But Rakesh Raman's proposition is also quoted. But thereafter it moves on to another judgment. So it was never, Rakesh Raman was never distinguished or even by implication overruled or distinguished or dissented from.
Yes.
Same strength bench. Justice Nagarandan's bench is 2 judges. Justice Dhulia's judgment is also, Rakesh Raman is also 2 judges. So if the second judge considers the previous one and does not, even if it tried to overrule, it would have to refer to a larger bench. Nothing of that sort was done, not even distinguished, nothing. Therefore, we held that Rakesh Raman proposition is very clear. This is included in 13(1)(a). That has not been, not been overruled. Anyway, so, and your argument is otherwise also. You, Mr. Chattopadhyay, you have argued also that even if this proposition is there, there is no irretrievable breakdown. You want to come back. That's clear from the paper.
And my argument was based on that they have created the situation. It was
constructive.
Yes,
that
constructive. Lordship, if your lordship can keep it on Monday, I'll come back. If your lordship requires to reply.
No, we'll just close arguments. What else remains? We'll have to decide. We'll have to go in this matter. We have to go through the materials.
Yes.
The evidence.
Yes, ma'am.
If you want to come back, you can file a short notes of arguments also. Do that because we may miss out on the facts. But very short, very brief. Just refer to the pages, just like you did in oral arguments. Both of you, please do that. When can you file that?
After vacation.
After vacation, if you want, then yes.
Let it be part and I'll come back after 5th. I'll can.
No. If you keep it parted, then it's already parted. Do it. Use the weekend. Today we are on
reopening.
No, not
again. 5th, I'll come back. 5th. This week, some.
No, you can't add anything. Whatever you argued today, you just.
I'll just come back. I'll also
put it this evening in your notes. Give the dictation this evening. Have it printed.
Tuesday, next
Tuesday, come back. Oral arguments are concluded. Push up. The matter shall be listed on December 23, 2025 under the heading to be mentioned for the purpose of filing of written notes of arguments by the parties.
2 to 3 pages when I'll try to complete.
Yes. But not in small print and single space.
No. Grateful.
Thank you. These judgments copies you need not give further, but after page 28 you may give.
Okay.
After this is
by today.
Paragraph 2. This contains up to page 704. 704. Your copy contains the entire thing?
No. Same.
Just give us the pages if you can during the course of the day today. It's 3:36 now, so try to give that. ওটা যদি দেন উনি তাহলে রিঙ্কু বাহাতি যে কেসটা এটা দেবেন, এটা লাস্টে ওটা সেটেল করে নেবেন।
এরপরের জন্য আসতে পারে কিন্তু ছোট স্টেপটা হবে একদম
সেলাই করে দিতে পারো, সেলাই করে দিতে পারো, ওটা তো তাড়াহুড়ো করে বার
Item number 788.
পাঠাতে বিশেষ
well I'm for the applicant in this one.
এই রে।
On the last occasion,
Yes.
my lords made an observation that why did you not prepare an affidavit? But my lord, after going through the records, my lord, it has already been affirmed, for which reaffirmation, my lord, I have done. Already, I am handing over the copy, my lord. It was long back, my lord. It was
file that affidavit. That was never
yes. That's why, my lord. I do not know. It was affirmed, my lord, since the original affidavit is missing.
Mr. Sengupta, have you given a copy to them?
Yes, yes, I have already served. And, my lord, and supplementary affidavit including only the awarding portion, whatever.
But in the supplementary affidavit, my lord, what I find, my lord,
Yes.
there are certain errors, my lord, with regard to my land, my lord.
There are certain
Error, my lord.
error. That's it. Please take the microphone a bit closer. Yes, thank you.
I'm grateful, Lord.
Grateful to your learned friend.
Kindly come to the supplementary affidavit, my lord.
Yes.
Page 3, my lord.
Page 3, yes.
Lordship will find Vastu 0.46 acre.
Yes.
Page 3, has you also got that?
Yes.
Now Pukur 0.53 acre. RS plot number 690 and 690 P. Mine is 690, my lord, which is 0.046 acre. But they are showing my land as 0.53 acre, which is a Pukur.
Achha.
In my lord appeal, I have annexed that
Yeah, my lord,
copy.
may I make one
Yeah,
submission? Sir, I preferred an state. He also preferred.
Oh, true. Nobody is denying. I mean,
why I am making a submission?
You cannot stop Mr. Sengupta. You can stop anybody.
No, it is not.
We have been.
unless
It is
your
not
lordship
privilege.
We have not been able to stop Mr. Sengupta, so you cannot.
But it is not privilege to appear before. Well, many things, my lord, I have to learn. I have learned, and I have to.
You have not learned anything. We have learned much about land.
No,
all of you. Yes.
No, my lord, my lord, only thing, my lord, in a gist, my lord. My lord, I am making. Just give me half a minute time. Half a minute, sir. Half a minute.
No.
Please check your clock.
Take you.
Yes.
My lord, admitted fact, my lord, here, my lord, that the proceeding was initiated under section 41A of the, my lord, Act 2, 1948. My lord, award was passed, declared, but they didn't accept that award. My lord, now, and my lord, 41A was invoked at that point, material point of time. And after that, my lord, 93B has come into effect, my lord, by dint of amendment. So, whatever vesting was there, vesting remains as per the amended act. My lord, I will show one of them. First of all, my lord, these are the, my lord, admitted fact. Now, the Honorable Single Judge, my lord, has taken into consideration of the, my lord, the Honorable Division Bench judgment, where one section, if the initiation be proceeded with under the provisions of land, the Act 2, 1948, then, my lord, section 20 clearly suggests that if initiation be not made under their Act 1, then, my lord, 2013 Act is not applicable. This is, my lord, this went up for appeal, my lord. Right now I cannot recollect, but, my lord, SLP was dismissed against the judgment of our Honorable Division.
And you cited BDA in the other matters, so that also holds.
Yes, also, my lord, yes, my lord. Another point, my lord, I am taking, because that Honorable Division Bench judgment, my lord, after that, my lord, before that, my lord, there was no such judgment regarding whether initiation is taken to be note of it or not. But after that, my lord knows that constitutional main judgment in the development authority and my lord others judgment I have relied upon in other cases, my lord. There, that is under the Bangalore Development Act. If that in that facts and circumstances that initiation was made under the Bengal Development Act. So if it is not initiated under the Act 1, Bangalore Development Act, my lord. That, my lord, I have placed that judgment also in other cases, my lord. So, my lord, there are two judgments of our honorable division bench, and as well as, my lord also delivered a judgment which was against me, but some observation which is in my favor regarding section 4A, whether it is vesting is done or not. But my lord, this was an obiter in that sense. But however, this is applicable. This is a ratio based deadline. Well, this is binding upon my lords also. Because I will rely, my lord, four judgments I will rely upon. One, my lord, the honorable division bench judgment. That is, my lord, I am not, my lord, I have come with a clean hand. My lord, I will, whatever judgment was against me, I will cite. My lord also subsequently.
State also has an appeal and you also have an appeal.
Yes, both.
So since Mr. Sengupta is arguing, he's disclosing his defense. Let him do it, and you will argue.
As you wish.
Yes. My lord,
he has asked half.
Yes.
No, let him argue. Let him spend. You will have an easier chance of replying. You will know what will be.
Yes.
But let him narrate the facts, my lord.
Jani, sir. First, my lord, my lord has already gone through.
So what did the learned single judge say?
The single judge says that proceeding stood lapse, and my lord, the authority has to proceed under the provisions of.
What are the facts of this case?
Facts of this case: 4.1a was issued.
Act 2.
Act 2. First section 3, my lord knows that. Then 4.1a.
Then 4.1a.
4.1a. Then 9.3b. Award was passed. But since 7a is incorporated in the Act 2, well, after amendment, 1997, 1994. So, my lord, on the 1996, something like that. I will read, my lord. I will show that. My lord, 7a was incorporated, and our larger bench, my lord, held that taking into consideration of the 7a, where admittedly that act was not subsisting. Rather, my lord, I will show all judgments which is against it.
যেটা রিকুইশন এন্ড অ্যাকুইশন অ্যাক্ট আগে দিন আনতে বলছেন ওটা কোথায় গেল? ওয়েস্ট বেঙ্গল ল্যান্ড রিকুইশন এন্ড অ্যাকুইশন অ্যাক্ট 1948 অ্যাক্ট 2 অফ 1948
এর মধ্যে আছে।
ওটা ওয়েস্ট বেঙ্গল লজে থাকবে। আমি তো অরিজিনাল সাইডের মধ্যে আনতে বলেছিলাম। Sorry.
My lord, here, my lord, sorry. My lord, only, my lord, one judgment was delivered by my lords, my lord, presided over by my lords. Whatever, this is the honorable division main judgment, which has relied upon the larger bench, the judicial pronouncement given by the larger bench, that where 7a was taken into consideration. At that point of time, my lord, I have made a submission that there is no existence of the law. So why the honorable larger bench can take into consideration of that? However, my lord held in my lord's judgment that since is a review application, the scope of review is very much limited. That's why it's requires a lengthy hearing.
That's not an adjudication on that issue.
No, my lord, also taken into consideration. Because that is an observation, my lord.
Then, Mr. Sengupta, you may have a point. We'll see that judgment also.
Yes.
You may have a point in saying that it may be obiter.
But, my lord, it is applicable to, because it is, my lord, binding upon my lords also. May have an obiter.
No, whatever.
Yes, sir.
Yes.
Now, my lord, now, whatever for or against, whatever judgments I will rely upon, my lord. First of all, my lord, the judgment, my lord, this has been reported.
So their case is that it has lapsed, and the learned judge affirmed that.
Yes.
Why then you have challenged?
Yes.
You have
challenged lapsing, my lord, with regard to lapsing.
You say
I'm coming. Learned judge, single judge has held. I'm coming within the ambit of 2013 Act, my lord. New Act.
So what was your writ petition for? What was the relief claim?
2013 Act.
Restoration of position and de-requisition compensation, my lord.
Under 2013 Act. But
No, not under under 1940.
No, what we made a submission that he is only interested to have the land.
Yes.
So learned single judge has held that the proceeding has lapsed.
Yes.
By operation of 2013 Act.
No, 48 Act.
48 Act.
Because of Section 7.
Because Section
Yes,
7.
my lord.
So it has lapsed, so fresh proceedings have been directed to be initiated.
That's why. But I don't come within the ambit of that new act, my lord, 9A and 9B, which was introduced in the year 1997, my lord.
Let us start with the impugned
Well,
order.
that's why, my lord. Yes, my lord, let us start.
Better start with the impugned
Yes,
order,
my
so
lord.
that you
Kindly
can
come.
understand the scope of the.
Yes, my lord. Kindly come to the paper book.
তন্ময় যাই হোক না কেন একটা অর্ডার রেকর্ড করে পরে খেয়াল থাকবেন
Start from page 2.
A report in the form of an affidavit as well as a supplementary affidavit, filed in court today.
Reaffirmation, my lord.
By the state be kept on record.
Because it has already.
It has never been filed before us. So
And that is
because
you reaffirm or affirm.
yes, yes.
That about my lord, description of land has gone erroneously a different, my lord.
ঠিক আছে, just
You want to file any objection to this supplementary affidavit?
I wish, my lord.
Then why didn't you ask at the first? Then we wouldn't start. So if you want
That is why I want to show you lordship, because pukur and land, my lord. Mine is land,
no,
not
we'll
pukur.
proceed on the basis of this report and supplementary affidavit unless you give a rejoinder to this.
I wish
If
to
you
give,
want
my
to
lord.
oppose this,
Yes, I am opposing, my lord.
then you have to file a rejoinder. Then we'll direct you to file. Tell her. এটা থাক তো rejoinder দে. How soon can you file the rejoinder?
কতদিন আপনি কোন থেকে কতদিন দেবেন এটা রিজনের ফাইল পর্যন্ত এটা ভুলভাল করেছে এটা দিনের মধ্যে হয়ে যাবে নেক্সট উইকে মঙ্গলবার বাই টিউজডে, my lord.
Very well. We'll keep it on Tuesday for filing. But Tuesday, then it will be kept for hearing on after reopening. Then
I leave it to your lordship, my lord.
Kindly meet, my lord. So permits. I am not.
Let us come back then after the vacation for hearing.
After reopening. After reopening. After reopening, my lord.
Yes, because you get the time. In any event, you have to hear it after. Learned, যেটা বললাম তারপরে learned counsel for the you are the land losers.
Yes.
For the land losers seeks to use rejoinder to the said affidavits, whose have accordingly the land losers are permitted to file their rejoinders to the affidavits filed by the state within January 2, 2026. Advance copies of the same shall be served on the learned advocate for the state. The present appeal shall next be listed under the same heading on January 8, 2026.
Make it part of
One interest, my lord,
If by chance the bench changes, you will be in jeopardy.
No, my lord. I am taking the risk.
No.
My lord,
I'm not
make it
taking
part
the
of- my lord, make
the requiring authority, if kindly possible to give me a copy of this.
Yes,
Yes,
sir.
definitely. Please give a copy to them. We would like to hear them also.
Yes.
Although you are selling on the same boat,
Yes.
but even then you may add something to there.
Yes.
And you also give copies of your rejoinder to the requiring body also.
I will, my lord.
Thank you.
Obliged.
Fact remains, my lord, this land requiring body didn't get till date, my lord. The land which was acquired by them.
Land is?
Which was acquired under section 3, required under section 3, and thereafter acquired under
Yes.
section 4, my lord,
Yes.
was never handed over to them, my lord. To be SNA, my lord. That is why they wish to file their. Yes, my lord.
Must have handed over.
Refusing that. My lord,
Let
there
it-
is a-
let-
my lord,
You said you have not handed over to BSNL.
Yes. My lord, this will be reflected from the honorable judges. The
I will
honorable
show you,
single
lord.
judge ordered itself.
He will himself show, my lord.
Order of the honorable single judge.
That is up to the BSNL, my lord. Let them say.
Submission has been- it was-
And I will show you, my lord.
His submission, my lord, whatever submission he has made.
Okay,
before the
you make your
honorable
submission, I will.
My lord, his submission was, my lord, recorded. What he's talking about, my lord, I fail to understand. Solve. my
No,
lord.
you fail to know. You understand very well.
I understand.
তুমি বোঝো ভালো করে।
Not obliged. Thank you.
I'm grateful.
That will be. This is also land acquisition, Mr. Pan?
Yes. Now, my lord, here, my lord, what happened? My writ application has been dismissed.
Yes.
On the ground of basis, since the award has been declared, so there is a delay in moving the writ petition.
How long was the delay?
To me, my lord, there is no delay because there was no award at all in the eye of law. Relying on
challenged
the order itself.
No, in the writ court, what have you said?
Writ court, I have said that they were trying to dispossess me on the guise of an acquisition proceeding, according to me, that has been lapsed for want of declaration of award. No, my lord.
This was an acquisition under the Land Acquisition Act, 1894 Act.
1894. No, 1948 Act.
48.
Act 2.
Requisition and acquisition.
Requisition and
You
acquisition.
admit that it was requisition.
It's a requisition, but possession never taken.
Never taken.
Possession never taken because I was not served with a notice under section 3(1), which is the mandatory in nature. Now, my lord, kindly turn to, my lord, the page 80. This is the impugned order. Of the paper book.
80.
80 of the paper book.
No.
MAT 1362 of 2022.
Yes. Oh, supplementary. There is a supplementary paper book also.
Yes. Sorry, my lord. The original paper book.
Thank you. Yes, Mr. Panit.
The present writ petition has been initiated based on a letter dated 31st October 2018 issued by the Additional District Magistrate LR and District Land and Land Reforms Officer Malda addressed to the Block Land and Land Reforms Officer Gajol Malda for recording acquisition land of the petitioner in favor of Irrigation Waterways Department, Government of West Bengal. Learned advocate representing the three petitioners being sons of late Konoklata Dasi has submitted that the land in question was proposed possessed and enjoyed by the petitioners till issuance of such memo dated 31st October 2018 for recording the land of the petition in favor of the Irrigation Waterways Department, Government of West Bengal. It is the contention on behalf of the petitioner that based on notice under section 3(1) of the West Bengal land, a proceeding might have been initiated for requisitioning on the land of the mother of the petitioner, but such proceeding was not concluded and no compensation award was paid in favor of the mother of the petitioner at the material point of time. Upon presenting this writ petition, it has been prayed by the petitioner for setting aside acquisition of land measuring 2.5 acre in RS Dag number such and such. Mr. Soumitra Bandyopadhyay, learned advocate representing the state respondents, has opposed such prayer of the petitioner based on the averments made in the affidavit in opposition to the writ petition. Upon placing reliance on the relevant part of the affidavit in opposition, it has been submitted that the land of the mother of the petitioners were acquired in connection with LA case number such and such for construction of stack yard in connection with Tista Barrage project, and the possession was handed over to the requiring body on 21st of August 1976. Based on such steps taken by the authorities, calculation sheet was prepared in connection with the said LA case by the Land Acquisition Department for payment of compensation and award to the mother of the petitioners, namely late Konoklata Dasi. Kindly mark this portion, my lord. Kindly mark this portion. This is the only averment that a calculation sheet has been made. Ultimately, it has also been submitted on 23rd August 1984. Award money was paid to the mother of the petitioners to the tune of rupees 72 lakhs 29,761 for acquiring the land of the petitioner's mother. Kindly also mark it. My mother has been paid 72 lakhs.
In this matter, my lord, for this point, my lord, this is the typographical mistake. It is not the correct amount, my lord. There is another amount, my lord, has been paid. This is
But the dates remain the same, 23rd August and all.
other is thing, my lord, the amount is, my lord, is incorrect. That amount has not been paid. Less amount.
For account land of the petitioner mothers, and in support of the same, a document has been annexed to the said affidavit in opposition, being annexure R3. But if it is incorrect, that court possibly would not have relied on annexure R3. It has also been submitted that 100% payment of compensation has been made as per the relevant provision of the said Act of 1948. Subsequently, based on letter dated 31st October 2018 issued by the Additional District Magistrate LR and District Land and Land Reform Officer Malda addressed to the Block Land and Land Reform Officer Gajol Malda relating to recording the name of the Irrigation Waters Government Department, Government of West Bengal in the record of rights based on the acquisition proceeding initiated by issuing notice under Section 3(1) in the year 1976. Petitioners cannot have any right to agitate the issue afresh as it has been done in the present writ petition. This court has heard the learned advocate representing the parties to this writ petition and perused the relevant materials available on record. It appears that one notice under Section 3(1) under the said Act was issued in connection with LA case number such and such for acquiring the land of the mother of the petitioner upon placing reliance on particular document, which is annexure R3 to the affidavit in opposition. Kindly pause for a moment, everyone. According to the understanding this, R3 is a notice under Section 931. R3. Kindly turn to page 64 once. That is the R3. বই কোথায় বই বই My lord, at any stretch of imagination, this cannot be said to be the notice under Section 3(1). Prescribed form of the rule 3(1) is something different. Lord, kindly have a yes. এটা জজ সাহেবকে একটু দেবেন। This is the rules of the my lord. This is the rules of the 1948 Act.
দিন আপাতত ওটা দিন
এটা জজ সাহেবকে দিন না একটু।
ওটা নিন।
What is it? Kindly have a look at the rule. This is the prescribed rule.
Yes. এখানে একটা আছে রুল।
The notice upon this is the specific form of the notice.
রুলসটা নেই, এখানে একটা আছে। এটা শুধু অ্যাক্ট থাকে, রুলস থাকে না। এই বইটা আনিয়ে নিতে হবে।
This is out of print.
This is not being found.
Not available in the market.
Rules, where do we get? I don't know, because in the
No, my lord, I will make a Xerox and I will hand up to your lord.
do that. Yes.
I will make a Xerox and I will hand up to your lordship.
For the timing, let us proceed on this.
Yes. Now kindly have a look at the rules, my lord.
Yes.
The prescribe the form of the notice.
Yes.
If I can compare with this page 64, this cannot be said at any stage of imagination. This is a notice under Section 3(1) that has been issued.
No. Obviously not, yes.
So therefore, my lord, my respectful submission before your lordship will be this. No notice under Section 3(1) was ever been served upon me. And if any notice under Section 3 not been served, the initiation of the proceeding itself is bad. I will rely on his judgment, because this is a mandatory in nature. Kindly have a look at the, my lord, the Section 3(1) once.
So it happens by operation of law. Irrespective of your coming late or earlier, it was a stillborn baby.
Yes, because my lord, I was not aware even about the notice. I was not aware even the acquisition proceeding. I was never been asked to hand over the possession because anyone prescribed that I have to hand over the possession. That is the prescribed the notification. Then only question of section 4(1)(a) arise for acquisition of the land. And in the affidavit in the opposition, they have never disclosed as to when this land has been acquired. Then, my lord, let's kindly turn to the impugned judgment once again.
But section 3(1), Mr. Pant, there can
Yes.
be a counter argument that the effect of section 3 has to be looked into. What is the effect of what is the implication if that notice is not given?
Yes.
Section 3(1) notice, the purpose is to notify you before taking possession. After giving section 3(1) notice, collector takes possession. Suppose there is a defect in that, then that does not vitiate, that may not vitiate section 4. Section 4 says when land has been requisitioned under section 3.
No, my lord, kindly, before that, kindly subsection 2 once. Because subsection 2 followed by subsection 3.
Yes, order has to be served.
Yes. That is the prescribed notice, my lord. The order has to be served under the rule, sub-rule 2. That is mandatory. Because if
But even then, suppose Mr. Pan,
yes,
suppose an order is not served,
yes,
then 3 takes place. If served, 3 says if any person fails to comply with an order made under subsection 1, collector or any person authorized by him in writing shall execute the order. So order followed by 3. First requisition order is made, and then if you don't comply with the order, possession is taken. So even if 2 is not given, what's possible?
Yes, my lord, if he is not given, my lord, our court, as well as the Supreme Court held, no requisition.
We'll look into those judgments.
No requisition.
Because section 4
because that is the language, is my lord, this is a mandatory. In absence of that, no proceeding can be said to be continued with.
We'll look into the judgment.
Yes. Now, my lord,
So this
because
is the
I tell
premise
you,
of your argument.
because I tell you, lordship, my lord.
Yes.
Section 4 does not prescribe for taking over possession.
No.
Section 4 prescribe for vesting of the land.
It starts when it has been requisitioned under section 4.
So possession has to be taken. Before section 4, possession has to be taken. Otherwise, land would not have been vested with the state.
Yes.
And possession can only be taken when I will be served with an order, hand over the possession with the competent authority.
Do you say that possession has not been taken at all?
Not at all. That's why my injunction application is.
Oh, you have said possession has not been
taken.
Non-service of order we could still think, but if possession is not taken, there is no.
Taken. Now what they are trying to.
4 says that. 4 says wherein land has been requisitioned under 3(1). That obviously possession has to be taken.
Yes.
You say no possession was taken.
Possession. That's why nowhere in the affidavit in opposition they have said on this particular date the acquisition has been done.
All right. Possession only কি করা হবে? Section 4 শুরুই হচ্ছে ওই দিয়ে when possession is involved. Yes.
Then, my lord, kindly see, paid to the murder, and prior to that, the possession of land was handed over to the requiring beauty in the sub-state irrigation water department. Since the entire proceeding under the relevant provision of the Act of 1948 was complete by handing over possession of land on 21st August 1976, and subsequently award money was paid to the petitioner 23rd 1984. This court posed query to the learned advocate representing the petition as to why the writ petition was filed on 18 September 2019. This court does not receive any satisfactory answer on the delay made by the petitioner in approaching the court for quashing the acquisition proceeding, which has been initiated by the concerned authorities in terms of the said Act of 1948. From the facts of the case, it appears that the requisition proceeding was initiated against the mother of the petitioner by issuing notice under section 3(1) of Act on 12th August 1976. And petitioner's mother died on 9th October 19. Now kindly see, my lord, 3(1) notice on which basis they are saying this date is 12th August 1970s. Kindly turn to page 59. Page 59.
Possession certificate.
This is a possession certificate. He has no whisper about the section 3.1.
But if
It's a possession certificate in the interpretive department. Nowhere my name, I have not handed over to them. There is no specific document that I have handed over them to the possession. It's a mere piece of paper. And there is a judgment of this honorable court, my lord. This is a mere piece of paper. Won't say that the possession was handed over. There is a prescribed form. They have to show that that possession, I handed over them to the possession. And there will be an independent witness. That possession was taken over by them in presence of such and such persons. It's a certificate of possession between that, as if possession was taken over subsequent to the possession as a handed over to the requiring body. Therefore, it appears after initiation of the proceeding of acquisition by the state respondent, mother of the petitioner being the owner of the land in question, was alive for 24 years. But she did not raise any demand to the steps taken by the authorities in order to conclude such proceeding upon payment of award as well as handing over possession to the requiring body. As per appreciation of this court, it is the mother of the petitioner who has interested person in such acquisition proceeding who could have raised the issue which has been belatedly raised by the petitioner being the sons of the Kanaklata Dasi. My lord, here my lord, respectful submission before your lordship, my mother was never been aware. Neither I was paid, mother was paid, nor any notice was served upon him. So my mother had no occasion to approach before this court challenging the issue such and such. Since the mother of the petitioners found that it is not required to initiate a legal proceeding against such acquisition proceeding initiated by the correspondent, which goes a long way to show that the authorities concluded the proceeding of payment of award money to the mother of the petitioners. On analysis of the relevant facts, it appears that the petitioner have tried to take advantage of the letter dated 13th October, 31st October 2018 issued by the Additional District Magistrate Land and Revenue Officer addressed to the block land Gajol relating to the recording name of the irrigation water department government of West Bengal in the record of rights in connection with the land in question. Such issuance of letter dated 31st October 2018 cannot confer any right upon the petitioner raise the issue of acquisition qua non-payment of compensation to the mother of the petitioner after 42 years of initiation of a proceeding on issuing notice under section 3.1 of the said Act 1940 or 12th August 1970. On the point of delay made by the petitioner approaching court, reliance has been placed on the certain reliance has been placed and a reasonable time approaching the court. In view of the aforesaid discussion, this court does not find any merit in the writ petition and the same stand dismissed.
It's upon there are certain other judgments which say otherwise, that if it is a state's fault, it did not draw up the award or give you the compensation in time, then it's not your liability, irrespective of delay.
If your lordship does not satisfy.
No, irrespective of delay, if it's a court, if it's a state's fault, then delay cannot be a bar in taking up a writ petition.
Yes.
There are certain judgments you just find out.
Moreover, my lord, so far the payment of compensation is concerned, is a continuing cause of action.
Yes, exactly. That is what
it's a continuing cause of action.
The liability of the state,
yes,
shifting the pivot from your claim to their liability.
Yes.
There's a difference between the two.
My lord. Now, my lord, kindly see.
But now, here, certain documents were relied on by the court.
Yes. My lord, I am
showing... court appeal, Mr. Pan, you have to keep that in your mind.
Yes.
Before interfering, you have to be thoroughly satisfied that these documents are not sufficient.
Yes, that I will. If, my lord, if I cannot satisfy your lordship, I am so confident, my lord, that can impose cost.
No,
no, my lord, kindly see the
what we won't interfere. If
no, my lord, kindly see
what high taste because it's an intra-court appeal.
No, kindly see, my lord, on the what basis this has been done. I have never came across such an award sheet. Just a minute. See page 56. Yota kothay? Yota? Yo. application was decided. The application was decided by the document filed by the state. Now kindly turn to page 54. That is their opposition. Yes. Paragraph 1 and 2, paragraph 3. The present deed petition is not maintainable in the following grounds: that the said application in wholly misconstrued both on points of facts and submission of the distorted facts. The said application wholly misconstrued both on facts and law, and as such same is liable to be dismissed in limine. The said application is full of baseless and vague allegations. That before dealing with the parawise statement of the state writ petition, I beg to submit the following facts, which are necessary for disposal of the for the writ petition. This is the statement based on the information derived from the records in the affidavit. Now, have said in connection with the TISA, handed over the possession to the requiring body, sub-assigned irrigation waterways department on Atho, and the requiring body taken over the possession of the said land. In the malord, affidavit in opposition, they have never uttered a single averment that 3-1 notice was served, then possession was taken over. After taking over possession, the possession subsequently handed over to the requiring body. Next, that accordingly calculation sheet made for a land acquisition case number such and such department for the said land in favor of Srimati Konoklata Devi, wife of late Ramnaran Bhuti, mother of the present petitioner number 1. My lord, in between there should have been acquisition of my land, because section 4.1a would have been the determination for the market value. The date of publication of the notification of the section 4.1a would have been the date of determination of the market value. So, my lord, I submitted before lawsuits, my land has never been acquired. And if my land has not been acquired under publication of section 4, there cannot be any award. Then, my lord, I can see that on 23rd August 1984, award money, no, before that, that accordingly calculations is made for said LA case number Atho department land in favor of Srimati Konoklata Devi Bhuti, mother of the present deed petitioner. Copy of the calculation sheet under reference is annexed here to and marked as annexure R2. My lord, kindly turn to my lord once R2. That is at page 60. This is the calculation sheet. The trial just relied upon saying that this is the award. And this is the award that has been declared in accordance with the law. Now, my lord, kindly turn to section 7. Whether any land is acquired under section 4, there shall be paid to every person inter compensation in the amount on which shall be determined by the collector in the manner and in accordance with the principles set out in subsection 1, 1A, 2 and of section 23 of the Land Acquisition Act 1894. So, provided that the market value referred to in first clause of subsection 1 of section 20 Act in respect of any land acquired under this act be deemed to be the market value of such land date of publication notice under subsection 1A of section 4. There is no whisper of this date as to when this is the cutoff date for the market value, because I have right to reference. I can produce, no, this is not the market rate on that particular day. The rate is something different. Now, my lord, lordship, kindly see. Yes. Single পাতাগুলো সিঙ্গেল পেজ গুলো ছিল যে জজ সাহেবদের জন্য পড়েছিলাম। ও ইয়েস নাও মাই লর্ড, there is a manual called executive instruction by the government of West Bengal. Now এটা জজ সাহেবদের দিন না, how the award is to be made, that has been prescribed. '93.
Yes.
In my case, 94. Can you turn to page 94? After preparation and approval of the award notes, the calculation showing the apportionment of the amount of compensation for different items are done. The pro forma in Form 12 may be used for preparation of calculations is in detail. Next is very important, my lord. The form for award in form number 13 and apportionment of the award is done in form number 13A, which is a part of the entire award prepared in form 13. Now, lordship, can you turn to my lord? I have shown to your lordship the 12, that is the calculation sheet. Now, award form is, my lord, next page, form 13. There your lordship will find a column for notification under section 418. And in the calculation sheet, nothing that sort of thing. So that's why I have respectfully submitted before your lordship, at any stage of imagination, this document cannot be said. On the basis of this document, it can be said that award was declared.
What is the position certificate you showed us?
Yes.
Which page? You
Position certificate, my lord.
just showed us.
Yes.
Page 59.
Page 59.
That was also annexed.
Yes.
What was the number? Annexing number?
Can you see?
R1. Right. Yes, Mr. Khan.
So therefore, my lord, the learned trial judge, relying on these two documents, mainly proceeded with That is an annexure R3, treating this as a notice under section 3.1. And this page 60 calculation sheet, there is a declaration of the award. So award has been declared on this. And in fact, my lord, I shown to your lordship, there was no award was ever been declared. Moreover, my lord, property was never been acquired. Nowhere in the acquisition it has been said that 4.1a was published. Upon publication of a 4.1a notice, the award has, property has been acquired and vested with the state. If that not be so, my lord, even assuming property was under requisition, that was remained under requisition till 31st March 1997. After that, because my ownership never goes. When the property was under requisition, my ownership never goes. So there was no scope for under the Act of 1894 for any requisition. So what was the course that would have been taken? They would have filed served a notice under section 9(3) capital A for the purpose of acquiring the land as well as for declaration of the award. And in fact, my lord, as when this FDPT was affirmed, till date other than this, there was no other document to show that award was declared. Meaning thereby, my lord, if there is no award, even assuming my land was acquired, even then in by operation of section 7 capital A, proceedings lapsed.
All right.
And whatever statement that I have made in the writ petition as a bare denial, just bare denial with 3 paragraphs. In their opposition, page 57, just bare denial, no reasoning. Paragraph 5 dealt with my allegation or my statement 2, 3, 4, 5, say, I do not make any comment in respect of the CSRA record, which are matter of record. That is my record of right, I annex. They said I don't have any comment. Next, with regard to the statement made in paragraph 8, 9, 10 of the, I repeat and reiterate the statement made in paragraph 4A, B, C. So if that be their case, that is the only case they have made out in the opposition. In their opposition, as I submit in cost of repetition, again I am submitting, my lord, no acquisition.
Mr. Pan, records of right produced by you show whose name?
But in the name of my mother. When, my lord, I was served with a memo that I am an encroacher, treating me as an encroacher, the police was directed to take steps and record them, correct the record of right. Then I approached this court. Then I drew the attention of the authority. They said nothing. Then they said the property was acquired, notice served, compensation paid, etc., etc.
So the cause of action for the writ petition was they're trying to evict you and to change the record.
My lord,
of right.
my lord.
They did not change because at that point of time, if they changed, then no writ petition would.
No request. If this would have been done earlier, then reflection would have been there. Then we could have taken steps. Now they have come up with their case, the property requisition followed by an award on the basis of a calculation sheet. In between, no acquisition. My respectful sir, without acquisition, there cannot be any award. And nowhere there is any whisper as to when this acquisition was done. Then case would have been, I could have challenged that acquisition, notice for acquisition in both the ways. By applying 7 capital A or 9(3)B, whatever it may be there. Next, my lord. এটাই তো আর তো কিছু বলার নেই তো বলবে দাঁড়াও পেপার পেস্টিং পেস্টিং how I came to knowledge of of these things that I have pleaded in paragraph 9 of my writ petition, which is at page 10 of the paper book. No notice was no notice grounds. Grounds good. In ground number 3, Roman 3, at page 91, I have taken the ground of service of notice under section 3.1. And ground number 4,
You said no possession was taken. And 3, 4, 2 and 3 both possession and 3, 1.
yes.
All the grounds you have taken. 3,
Yes.
2, 3, 4.
Yes. And my lord, regarding judgment, no, Assamese judgment. Judgment paper.
On the next day, Mr. Pan, please try to give a photocopy of the rules because
Yes,
we
ma'am.
are not getting the rules anyway.
No, my lord, I will make it a Xerox, my lord. Definitely I will hand up to your lordship.
Mr. Pan will start with the judgments on the next day because now it's heard in part. List the matter for further hearing on January 7, 2020, January 8, 2026. It is the next available Thursdays. এই বইটা ফেরত দিয়ে দিন